Well, hello, everybody, and welcome back to Raw Law on time for once with your host, the Just Showered Guy. Today, we are doing the final day, final day of the Alex Murdaugh murder trial. Yesterday, we were just finishing up with Waters's closing argument, which by God took forever. Okay, I understand their field trip took a little bit of time. That's fine. I get it. But, like, are you kidding me? It was absolutely. I don't understand how. I saw some comments on the internet and people were like, I think Waters did a really good job. Like, Larry, you don't know what you're talking about. And I'm like, were we watching the same closings? Like, what? You thought that in fairness, if you thought that was a good job, that means, you know what that tells me? It tells me two things. Number one, you don't know what it looks like to do a good job. Or number two, you've never seen a closing argument before, which is fair. Again, not trying to deduct points, not trying to ding you, not trying to diss you, not trying to hate on you. Although I was getting a lot of hate yesterday from various sources. Like, there was one person who even went so far as to say, "Oh, excuse me, Mr. DUI guy is a criminal defense attorney." Like, he defends drunk drivers for a living. So he cannot be trusted in anything he says for two reasons, I guess. One, he's a filthy, lying scumbag, shitty, narcissistic, full of himself, up in the clouds, has no idea, disconnected from reality lawyer, which is half true. Or number two, he's just a criminal defense lawyer, so obviously he's gonna side with the defense. Damn it, Zinni! She pulls on the cord. Stop it! My camera almost tipped over. So yeah, I was like, all right, okay, well, look, you have your opinion, I have mine. And it was just like one person. Don't get me wrong. It wasn't like the prevailing opinion or anything. But I did see it a few times. And that's why I was literally like keyboard warrioring, like trying to respond. And then I was like, hold on, Larry, look at their profile. Check their profile before you respond, because you don't know what you're getting yourself into. And I opened their profile, and it was all just like extreme far left posts, like one after another. And I was like, Larry, you do not want to get involved in this. Talking to this person, I have a better chance of winning an argument with this wall. Like, if I argue to this wall, I have a better chance of winning than if I try to argue with that person. So there's no point. There was absolutely no point. So I let it slide. I said Wusa, Kumbaya, all of the above, called it a day and said, that's not my person. And then I tweeted that I think it's going to be a hung jury. And again, people were just like, would you think you didn't do it? Blah, blah, blah. I lost like 50 followers. I'm like, on Twitter. Again, it reminds me, it's a constant reminder of the not the world we live in, but the people that inhabit this world. Of the people that inhabit this world. It's a reminder that it's kind of like Johnny Depp 2.0, and I'm going to have to get used to it. And sometimes I guess I forget that, of course, there's going to be differing opinions, and that's fine. Except like in the Johnny Depp trial, it was pretty easy because it was like just the Amber stands were the only ones supporting Amber. Here you have regular folks, who just maybe haven't watched the trial, don't know the background, because there is a lot to this trial underneath the surface. But the problem is people are not willing to disconnect from their opinion. And that's the hard truth that I had to learn, is they have an opinion that he's guilty, therefore he must be guilty. They don't understand. They can't put themselves in the shoes of the jurors who are going to be sitting in that deliberation room and deliberating based on the evidence presented. There's a fascinating experiment in chat. You may be able to help me out. It's a psychological experiment. I forget what it's called. Basically, you have person A and person B, okay? And there's a box, and it's an empty box, okay? Person A is right here. Person B is right here. Person A stays, right? I think whatever I said, this is person A. Person B leaves the room, okay? Person A opens the box, puts a ball inside the box, closes the box, and then stands back where they were. And then person B comes back. And the question is, does person B know that there is a ball in the box? Now, it's not a trick question. It's a very simple question, but it is used to deduce whether or not a person is able to put themselves in the shoes of another person. Because if the person goes, like in the psychological test, they go, oh, of course there's the ball. The person B knows there's the ball in the box because they're extrapolating the information that they know or person A knows. That obviously person B knows, but nothing has been communicated. No indication that person B, it's a state of mind theory. Is that what it's called? State of mind theory. Perhaps, Brad. That sounds right. That sounds right. I can't confirm or deny. I don't remember what it's called because I never studied psychology in depth to remember and know this stuff. Somebody shared it with me one time, and I thought it was really cool. They actually did the test on me because they thought that I may not be able to tell the difference. But it's easy. It's easy because person B is not aware of the information that person A or you, the reader, possesses in that scenario. So it's very, very simple. But some of the rest of the world is acting like person B, who are like, well, obviously there's the Netflix documentary, and there's this, and then there's the HBO documentary, and then there's the cartel connection, and there's the drugs, and there's this. Who else could have done it? And blah, blah, blah. And they are correct. They are absolutely slam dunk correct. But they're missing the most important piece. The jury hasn't watched the Netflix documentary. The jury hasn't seen the HBO documentary. The jury hasn't been following the news. The jury hasn't. 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 The jury is locked in to that room, to this microcosm, and the only information that they receive and they're allowed to consider in their deliberations is what comes from that witness stand. So the observer's personal opinion as to guilt or innocence of Alec Murdaugh has zero bearing on what the potential verdict might be. And that's where there's a complete disconnect. And that's fine. It just, again, it reminds me of how people are either unwilling or not sufficiently educated or don't care about putting themselves in and understanding the situation from an unbiased way. And then they turn it around and they call me a biased, scummy DUI defense drunk driver's lawyer, so he cannot be trusted. Really? Really? I don't know. With 32 trials under my belt, you would think I may know something. Maybe a little bit. Maybe just a tiny little fraction about trials and stuff. I don't know.
met with the juror on
With
the record,
that,
and the juror denied any.
Oh, here we go. The juror stuff.
Denied discussing the case with anyone not on the jury or with anyone on the jury.
Ooh.
She provided information that led us to the court to contact the persons that she was suspected of having conversations with concerning the case.
Oh.
Those individuals were interviewed and
Look at Alec. He's like
provided
smirking.
an affidavit regarding the contact that the juror had with them. We then also brought those two individuals in and had a hearing in chambers on the record in the presence of counsel yesterday. In which both of those individuals waffled on the nature and the extent of the contact.
No mistrial, not yet.
They also provided
I don't think so.
a recorded interview, or the state provided a recorded interview with the jurors, and I reviewed that interview last night.
That's why they stayed in court so long.
So the juror has had contact or discussions concerning the case with at least
Oh, wow.
3 individuals. Though it does not appear that the conversations were that extensive, it did involve the juror offering her opinion regarding evidence received up to that point in the trial that the conversation took place. And in order to preserve
And she said
the
not guilty to that other
integrity of
person.
the process and the interests of both the state and the defense in a fair trial, that juror will be removed.
That's fine. I mean, unfortunate,
and,
but that's
replaced
fine.
by another juror.
Yeah, that's expected. Wow.
I will make a part of the record under seal because of maintaining the confidentiality of the identity of the jurors. I will place under seal the recorded interview, affidavits received, and both discussions with counsel have taken place on the record, and all of that will be made a part of the record in the case. And we'll bring the juror out to inform her that her services will no longer be needed. We will then replace her with an alternate juror. Any additional comments by the state or the defense? Mr.
Your Honor, we do not accept from your ruling.
Yes,
I've sat through everything you sat through, and it's
I-
muddled.
You have to,
but
because
we
she was
defer
going to
to your
vote not
judgment.
guilty.
However, I think it's important for me
Oh
to
my
note for the
God.
record that the interviews of these two people were done by SLED agents, one of whom was named as a witness in this case, and the other who was listed in the notes as being one of the investigating officers. Just to note that, again, SLED has made another bad judgment in this case.
Oh.
I'm not accepting from your ruling.
Yes.
I'm just pointing out that this is just a continuum of a calamity of errors. Thank you.
And the court has not had any discussion with any SLED agents concerning this issue.
Me too.
And all the inquiry by the court has been directly with the suspected parties involved and with the juror. And this is a matter that this long trial with the intense publicity is certainly,
Good morning.
it would be certainly difficult for any individual to not have some exposure outside of the courtroom to information concerning the case, and to also be tempted to engage in discussions with others. But it is improper, it is contrary to my instructions to the jury daily, multiple times per day. And this juror unfortunately violated that order.
Damn.
So if you will bring out juror number 785. Yes. And sir? He's gone.
Oh my
Let's
God.
make sure she brings everything with her. She will, I'm sure. Tony. Good morning. Yes, ma'am, up here. In your normal spot's fine. If you just remain standing for me. Good morning. You doing okay today? All right.
Oh God.
I have, as you know, we've had some discussions with you over the past couple of days concerning indications of conversations with few folks not on the jury concerning the case and expressing some opinion about the case. I have reviewed everything, including statements given by individuals and recorded interviews, and concluded that despite my order to not discuss the case with anyone, that intentionally or unintentionally you've had some discussions with
You dumbass.
some folks not on the jury, and which is going to require me to remove you from the jury. You have been a by all accounts, great juror and smiled consistently and have seemingly been attentive to the case and performed well. And I'm sure that with all the time you've invested in it, you probably hate not to continue, or maybe you're ready to go. I don't know. But I certainly want to thank you for your service. I'm not suggesting that you intentionally did anything wrong. But
Yes, you are, but you can't tell her.
In order to preserve the integrity of the process and in fairness to all the parties involved, we're going to
That's right, Andrew.
replace you with one of the other jurors. Have you brought everything that you have outside of, you left some stuff in there? What do you have in there?
A dozen eggs.
Say it again?
A dozen eggs.
A dozen eggs.
Yeah, one of the other,
Fuck?
one of the other jurors brought in eggs for everybody.
Oh, okay.
Oh.
All right. Well, you're going to leave the eggs. You want to leave the eggs or take the eggs? You're going to take the eggs. So, Mr. Bales, can you retrieve from the jury room her dozen eggs, her
She
purse,
left her eggs. She might
and
need
what else?
those.
And a bottle of water?
There's a joke in there I'm not going to
You
use.
can get those things from the jury room.
I'm not going there. I'm not going there today, Chad. It's too early for eggs jokes.
As you know, the identity of the jurors are confidential, not known to the public, and the reason you are still where you are is that cameras are not allowed to videotape the jurors, and we have operated by
It's one of
juror
two
numbers
jurors.
throughout the process, and we'll continue to do so. And
Her voice reminds
your
me of
identity
her
will be
face.
kept confidential as far as the court is concerned, and we trust that in the event you decide you want to speak publicly about this case, that you wait until after the case is over. You're not encouraged at all to do so, but you have a right to speak to anyone you want to if you decide to do so. No, I have not spoken with her today, but no, this is not related to, I
I'm
know
not going
we
to tell
also
you.
had
I'm not going to
some
tell you guys.
conversation was brought up concerning
It's one
your
of two jurors.
ex-husband.
I'm not going to tell you who.
But that's
I don't
not
want
a
to
part of
breach
this
confidentiality
consideration
of
at
the
all.
jury.
This is totally
So you're going to have
independent of
to sit in the dark,
any
Chad.
other conversation that he might have had concerning you. That's not part of the order of the court. So they're going to get your things, and then once you're removed from the jury, you can't go back in the jury room. We'll have to tell them goodbye for you. Okay, all right. Well, thank you very much. You can go. Thank you.
Wow, what a cluster. What a way to start the day. It feels like a Friday now. I told you, I'm not telling.
We get a lot of interesting things, but now a dozen eggs. It's certainly pretty interesting.
I'm not telling.
We'll give her a chance to leave or to take her. She's gone?
I think I know who
Okay,
it is.
very good.
I think I know. It's one of
Anything
two.
else before the jury comes?
Your Honor, we picked an alternate.
Oh, right, absolutely. When they come out, we'll need to select an alternate, and the clerk you have the remaining alternates in a box. Any objection to a blind selection of that alternate out of the box?
Nothing for the defense, Your Honor.
No, they haven't. They're not permitted by the judge's orders. They're not permitted to watch the Netflix doc.
Juror number 254.
You can only consider the evidence presented. That's fact.
Deliberating panel at this point. 254.
No, Sean, they're not.
Yes, sir. Mr. Griffin.
Your Honor, before the jury comes in, early in my closing argument, we have a blow-up of the photos of Maggie and Paul at the crime scene.
Y'all can stop asking because I'm not going to
hold up
answer your questions.
so that the jury could see
To protect the juror's
audience
identity.
cannot see, but I'm just notifying Court TV that please don't display this blow-up during the proceedings. Thank you.
Thumbs up, yes.
Oh, sure, I apologize.
Welcome, Astrid. Thank you for joining on as a new member. I want to start off by saying I feel so bad about what I said to James. Oh my God. You got him real good yesterday. I was in the chat when you did it, and it was funny as hell. I had a good time. And by the way, the saddest part, the minute I get off my live, when did I get off my live? I can give you guys timestamps. He texted me. I got off my live at it was like 5:30-ish or something like that. 15 minutes later or something, I get a text, bro, were you calling me? From James. He knew. He fucking calculated. He was like, oh, Larry's no longer live. I can text him now. I don't care. It's funny to me. It was torture, yelling, pounding, repeating, and long AF. Rough to say it the least. I think you're referring to Waters' closing yesterday. Call James. I know which juror it is. I'm pretty confident. It's one of two, and I'm pretty confident I know who it is. I don't need to call him. And plus, he's going to ghost me again. What's the point? I was shocked to hear that person make an ad hominem attack on you about being a scumbag criminal defense attorney. I used to think that way, but I grew up. Thanks, Tammy. Yep, there I got that one. Was it the woman who was asleep and putting tissues in her ear? I plead the fifth. 1, 2, 3, 4, 5th. Yeah, The juror dismissed was pro-defense. This start just made up for the past 6 weeks. I wouldn't say that. It definitely did not make up for yesterday. My head is still not fully recovered from Waters' I even scared Zinnia. She just ran out.
And they bring the jury.
And by the way, there's a theory floating around. I'm not going to say from whom that I'm not saying, Ashley. There's a theory floating around that, the state would have never brought charges against Alec Murdaugh unless they knew they could convict. That is the dumbest theory I have ever heard. That is the dumbest theory I've ever heard. Have you seen any of my trials where the state has absolutely nothing, no evidence, nothing, and they still bring the case forward and try the case to a jury and lose with flying colors, and that's how you get the 4-minute, 5-minute, 6-minute verdicts? Come on, folks. How do you not realize that they
Good
will
morning.
try anything?
Yes, sir.
Evidence
Thank
for no
you.
evidence.
And good morning one more time. Day number 28. Welcome back. Juror number 254. You are now part of the first 12 jurors. We have 13. You're part of the first 12 of the panel at this time.
Where is James? Is James
And
tweeting?
The continuing with closing arguments is the defense's turn. Mr. Griffin.
Thank you, Your Honor.
No, he should be in the courtroom. Defense closing. Let's go.
Good morning. Wow. We're at the stage of the case that's called closing arguments. I don't know why they call it argument. I'm not here to have an argument with you in any form or fashion. What I'm here to do today, this morning, is to review the evidence with you that you've heard in the courtroom over the last 6 weeks. And in reviewing this evidence, my goal is to address questions that you may have about what you've heard. And the jury system that we have, frankly, is the greatest criminal justice system in the world.
Oh, come on,
Because
James.
it's the only system,
Get to the point.
jury system, that a criminal defendant's fate is put in the hands of his or her peers. In this country, we don't leave the decision of guilt or innocence up to governor, to the attorney general, to the prosecutors, to the presiding judge. You, ladies and gentlemen,
Okay,
make
fair.
that
All right, he's
decision.
laying out the groundwork.
And as
It's been a
perfect as our
long trial.
jury system is, there's one thing that I wish it provided: an interchange during the course of the trial between us. Y'all sitting there and listening to what we say.
I'll allow
And
it.
we don't know what questions you have and what you want answered. By the same token, we may have questions of you that we can't ask.
I will reserve judgment.
Here's my opportunity to try to answer the questions that I think you have. There may be some things that I go over that you've already decided, and I'm wasting your time. And if I do that, I apologize. I truly do. But I don't, this case is so important, I don't want to leave anything out that one of you may have a question about. I think I can probably speak to for everybody in this courtroom that there's one thing that we on this side have no question about. It's that y'all have been ideal jurors. We've been here 6 weeks, and each of you have come every day on time, and you've been very attentive, and it has not gone unnoticed. And we do appreciate you for your service. We know what a sacrifice it is, being away from your home, your work, your family, your personal obligations. Maybe some of you miss vacations. But you've been here in a 3-week trial, and here we are at the end of 6 weeks. And I want to thank you personally, I want to thank you on behalf of Mr. Harpootlian, Mr. Barber, Ms. Fox, and especially on behalf of Alec Murdaugh. In his opening statement, Mr. Harpootlian explained to you that the law governing your service requires each of you to engage in an unnatural task. In every criminal case, jurors are required to begin the process by presuming the defendant innocent. In this case, you were required under your solemn oath as we began to presume Alec Murdaugh innocent of these charges. And frankly, as he explained, that's not natural. When you hear on the news that
Yes.
that a crime has occurred and an arrest has been made, you feel a little bit relieved. Thank God they caught him. And frankly, I would not be surprised if some amongst you, when you read in the paper that Alec Murdaugh was charged with the murder of wife and son, that you thought, oh, good, they got him. But those opinions, and each of you, when you filled out your questionnaire, agreed and affirmed that you would leave those at the door of the courthouse and that you would decide this case solely on the evidence. And that's what the law requires. And when we begin, the law also requires you to presume him innocent of these charges.
Thank you, Mama
Now,
Bliss.
I've been doing this a long, long time, and up until the advent of instant replay in sports, it's been very difficult to explain just how to do that to jurors, how jurors can do this, apply this presumption of innocence. And if you're not as interested in sports, I apologize for this analogy, but the analogy is the instant replay. Whether you're a Clemson fan or Georgia fan, that on a Saturday afternoon, there's a play called on the field, and then it's reviewed. And under the rules, the call on the field stands unless there's visual, incontrovertible evidence that the call on the field was wrong. We see that every weekend on sports. Here, the call on the field is that Alec Murdaugh is innocent of these charges. That's what the law requires.
Yes.
And that unless and until the state proves his guilt to each one of you individually, voting individually, proves his guilt beyond a reasonable doubt,
There it is.
then that presumption of innocence stays with him.
Right there.
You're not being tasked here to give your opinion in
Yes.
this trial. You're being tasked to apply the Constitution, the bedrock principles that protect us all from a government. Those bedrock principles are, first, you get tried by a jury of your peers. Second, that the jury of your peers begin with presuming you innocent. And third, that you will remain innocent until the government, if they can, proves to you individually in your mind that the person is guilty beyond a reasonable doubt. Now, the judge will give you jury instructions on what that means, beyond a reasonable doubt. But the definition has been defined that reasonable doubt is doubt that would cause a reasonable person to hesitate when making an important decision in their
that's
personal
so
affairs,
good.
such as to buy a house, get married,
Hesitation means
any consequential decision
reasonable doubt.
you will be making when you get this case, probably later this afternoon. You'll be making one of the most consequential decisions that you will have ever made in your life, I suspect. I don't know all of your backgrounds, but it will be a very consequential decision. And if the proof that the state has put before you causes you to hesitate, when you go to fill out that vote as you're deliberating in your jury room, each of you will have a vote. And you will have the right to vote guilty or not guilty. And each of you will write it down. And if there's any reasonable cause for you
he's
to
telling them
hesitate
what to do. Write
to
it
write
out.
guilty,
Oh,
then
that
the law
I've
requires
never
you
done
to
that.
write not
I'm
guilty.
stealing that.
This burden of proof that we have, many of you may have had experience with civil cases. And in civil cases, the burden of proof is much lower, and it's called by preponderance of the evidence. And you may have seen
No
lawyers
joke.
or judges or watched on TV as they give a visual image of Lady Justice, who's blind and who's blindfolded, so she doesn't They're not biased for one side or the other. And there's scales on Lady Justice. And those scales are the scales of justice. And in
He just
a civil
appears
case,
more calm,
if
collected,
one party
confident.
proves their case by a preponderance of the evidence, meaning ever so slightly tilt those scales in their favor, then they're entitled to the verdict.
That's civil cases.
There's another heightened level of
Oh my
burden of proof
God,
in a
that's
civil
my
case
that's
called
my opening.
clear and convincing
Or
evidence.
my-
And
my-
the
what
law
do you rather?
requires
That's
things like to
exactly
prove
what I say.
fraud
Oh
or
my God.
some intentional acts. You have to prove by clear and convincing evidence, and that's an
Oh my
intermediate
God,
level
that's,
of proof.
that's exactly
And
what
so
I say in
it's
my
not
cases.
just tilt the scales ever so slightly in the favor of the party that prevails, but you have to get sort of 3/4 of the way there.
Has he been watching
But
DUI
now,
guy?
proof beyond a reasonable doubt is the highest standard of proof the law recognizes, and it is you have to tilt the scales all the way to one side in order for the state to meet their burden. Now, a little bit about the verdict. You will have an option of guilty or not guilty. My friend Dick Harpootlian over here he travels a lot. He's been to a lot of countries, and he frequently, he recently returned from Scotland, where he attended a jury trial in Scotland. And he tells me it's much like this, except the lawyers wear a wig, and I might benefit from something like that. But in Scotland, it runs about the same until it gets time to the verdict in the criminal case. And the jury in Scotland, where we derive our laws from, they are given 3 options. One option is guilty. Second option is not guilty. And the third option is not proven. Not proven. Now here in America, we have combined the verdict of innocent and not proven into one of not guilty. And so when you go to render your verdict,
Smart.
if it's a verdict of not guilty,
not proven.
it's either you concluded that the defendant is innocent of the charges, or that the government has not met their burden of proof, their heavy burden of proof beyond a reasonable doubt.
He's telling them their job. This is brilliant.
Now, and one of the reasons that defendants are presumed innocent and the government has such a high burden is because in criminal cases, the defendant really doesn't have the ability, doesn't have the resources, doesn't have the lawful authority to execute search warrants, subpoena documents, to prove his or her innocence. And so a defendant cannot secure a crime scene, cannot lift a crime scene for fingerprints, shoe-wear impressions, cannot secure telephones and get electronic data in the course of an investigation. So the defendant is limited on what they can do.
Somebody tell Kevin what that means.
In this case, on June 7th, 2021, Alec Murdaugh called 911.
Here we go.
And
Getting into the facts.
Officer Deputy Green, and then followed by other deputies, rolled up on the scene. And he is standing on his property. His wife and son lie dead in a pool of blood each. He's within yards of him, and he had just put a shotgun down. He had just put a shotgun down. And what would that look like? 90 out of 100 cases when an officer rolls up, it would look like the person who had the shotgun and 2 dead bodies may have done it, probably have done it. Certainly is someone who should be strongly considered.
Thanks, Ryan.
And all the officers in this case told you that. Deputy Rutland said, yeah, Alec Murdaugh was a suspect, but there are a lot of suspects out there. Everybody was a suspect. Fair enough. Agent Owen says, well, we have a circle, investigative circle, and it starts with immediate family members, particularly if they found the deceased, the victim. So he's in the circle by virtue of calling 911. And that's fair enough. But what doesn't strike us as fair is that the next morning on June the 8th, after the gruesome murders of Maggie and Paul, this is what is issued, a joint press release, Colleton County and SLED, that says, at this time, there's no danger to the public. At this time, there's no danger to the public. You have 2 people have been executed within, y'all are out there, I don't know, is it 100 yards, 200 yards from Moselle Road? They've been slaughtered. And at this time, there's no danger to the public. Does that tell you that on June 8th, law enforcement had decided it had to be Alec murdered? It's a fair question for you to ask yourselves. It's a question that's not been fairly answered in this trial. What we know from June 7th to June 8th, Alec is a suspect and he's in the circle. And from that day forward, he is at the mercy. He is at the mercy of the ability of SLED to exclude him from that circle. They have the ability to do the forensic work. They have the ability to interview witnesses, and they have the ability to gather electronic data. And we believe that we've shown conclusively that SLED failed miserably in investigating this case. And had they done a competent job, Alec would have been excluded from that circle a year ago, 2 years ago, but he would have been excluded. What did you hear from the witness stand? You heard from Chief Barry McCroy. I didn't know Chief McCroy until I got involved in this case, but his reputation is outstanding, and he's consummate professional. And he explained that when he got there, he was concerned that cars would be pulling up and there were some tire tracks that were not being protected and that they could have evidentiary value. And then you heard from Mark Ball, who had a conversation with Sheriff Hill, who's another fine public servant here. And he also agreed, we've got to stop cars from coming in here to preserve these tire impressions. And it was not done. It was not done. Captain Chapman from the Colleton County Sheriff's Office, he testified about seeing other sets of tire tracks. As you had came in off Moselle Road, you probably saw where Deputy Green's vehicle had stopped right at the kennels, but then on the other side, where you saw that Alec was parked and pacing on some of these videos, that's where Captain Chapman had talked about seeing tire tracks, and he tried to track them. SLED was coming on, and then it was like a trail to nowhere. It was a trail to nowhere. Deputy Rutland talked about seeing hair in Maggie's hands, you'll recall. You didn't hear anything about the hair in Maggie's hands from that moment forward. Was it tested? Was it sent off for analysis? There was no evidence of what, if anything, happened to the hair in Maggie's hands. Was it as a result of a struggle with her assailant? Was it her own hair? I mean, we don't know the answer to that. We know they failed to take fingerprints from the feed room, and they should have. They failed to properly take footwear impressions from the feed room, or at the apron right outside the feed room.
Showing all the reasonable doubt.
I think that's
is what he's doing.
I mean, I don't think that's uncontradicted. The Agent Worley, who doing the best she can, did not go there to document footwear impressions. Did not do that. You heard from our expert, Mr. Zerti, what is required. And I believe Dr. Kinsey also agreed it was not done. I know Mr. Palmbach did. And both, now I'll get to the shot angles in a little bit, but both Dr. Kinsey and Mr. Palmbach had the murderer for Paul standing on the concrete. Whether 1 foot's in, 1 foot's out, both feet are in, but there should have been footwear impressions. But we'll never know because it was not preserved. It was not taken. The thing that has baffled us, has completely baffled us, is
What is it, Jim?
why did they never take DNA samples off of Maggie's clothes?
Ooh.
Her dress. Why did they never take DNA samples off Paul's clothes?
Yeah.
They never did. They never did. And we asked their investigators, why didn't you? Well, that's somebody else's job. That's somebody else's job. It was never done.
It's a bad answer. Yeah.
But you know whose clothing they took DNA off of extensively? Alec. And you heard Agent Zapata talk about all the different grids on her shirt where DNA was samples were taken. Was Alec assaulted on June the 7th? No, he wasn't assaulted. Was Alec wrestling with the assailant on June the 7th? There's no evidence of that. So why are they taking DNA evidence of Alec's clothing in June of 2021? And there's only one reason. And it goes back to this right here. There was only one reason. Only one reason. Is that they had decided that unless we find somebody else, it's going to be Alec. Unless we find somebody else, it's going to be Alec. And I'll get into more detail about Maggie's phone. And Maggie's phone was not secured properly. Maggie's phone was, well, let me just go right into it. Maggie's phone was found on the side of the road in the morning or early afternoon on June the 8th. Whoever killed her threw that phone on the side of the road, without a doubt. Without a doubt. Alec, from the get-go, has said, you get Maggie's phone, you get my phone, or you get my OnStar data, and you will not see my car traveling down the road with Maggie's phone, because it did not happen. It could not happen. Detective Owen, have you gotten it yet? No, we've not. We sent the black box from
Morning.
on the Chevy
Morning.
to the FBI. It was a new model. Turns out the data's encrypted, and so we haven't got it yet. Well, what about General Motors? I mean, I'll do what I have to do, whatever I can do. And so, well, you know, we're looking into it. Well, what we learned during this trial is, sure, SLED sent a subpoena via a fax machine to somebody in Detroit, I believe, and whoever got it in Detroit, whether there was a number off, I have no idea what the reason was, but we do know the initial response was, we don't have anything. We don't have any OnStar data that you're looking for. There's no indication that SLED followed up with a phone call. There's no indication SLED followed up with a letter. There's no indication SLED did anything other than put it in a file. Put the response in a file. And that was it. That was it, ladies and gentlemen, until somebody watching this trial somewhere contacted somebody at General Motors and said, why don't you guys cooperate with the FBI and SLED on this investigation? And they're like, what are you talking about? So Friday, you know, sometime in the last 6 weeks, lo and behold, here comes all the OnStar data that you got to see. And that would be great. That would be great. But for the fact that when they seized Maggie's phone, it had, they put it in airplane mode. They knew how to put it in airplane mode. Excuse me, I'm losing my voice. Let me get water. I apologize.
Basically, one of the jurors got yeeted off the jury, Sholey, because they were talking to people and voiced their opinion. Probably not guilty. Almost
They
certainly.
put it in airplane mode, but
Just
what
put objected
you'll
to
see,
them.
I got a photograph,
To their removal.
is the location services were still
Welcome,
on,
Sassy.
meaning still pinging off GPS satellites.
Welcome to the channel.
And the phones don't hold that much memory. They hold a lot of data, as we have learned, but they don't hold that much memory. And it writes over itself. And for GPS location services, the ping points that we see from Paul's phone on all that data, that would have been on Maggie's phone for the 7th. But for the fact that it wasn't extracted until sometime in like June 16th. I think that's the date, but if I'm wrong, I apologize. But it's around the middle of June. And that ping information that we see on Paul's phone, for Maggie's phone, it goes back to like June the 9th. Well, a lot of good that does. A lot of good that does. We don't have it. We would have had it had they extracted it earlier. And then Agent Dove says we didn't have an updated, upgraded software that would read it. Took us a while to get it. I don't know why it took them a while to get it. There's really no explanation about that. But you heard about Faraday bags. Put it in the Faraday bag. So it's not pinging against satellites, not overriding. They didn't do that. And it's lost. Had they done it, I hope we wouldn't be here. I hope, because I know it would say, because we have enough evidence in the record, and we have to go around our elbow to get to our thumb to get there. But there is sufficient evidence in the record that shows Alec Murdaugh is not driving down the road, Moselle Road, with Maggie's phone in the car and tossed it at whatever time. When he went by at 9:08. I don't know what time they think it's tossed, but that would have gotten him out of the circle. I would hope, but probably not, because they've been so focused on him. Now, as I mentioned, Alec asked multiple times. I think the testimony was 5 times. Agent Owen, you know, if you get this data, it will show I wasn't there. And you know, we didn't learn why they didn't get it off Alec's phone until very recently, because you'll remember on June 10th, he gave SLED his phone. Yeah, you can copy it. Please copy it, because it'll show that I wasn't driving. That my phone was not with Maggie's phone at any point in time going down the road, and that I did what I said I did. Well, they did extract it, but what we've learned, the extraction was a superficial extraction. Not because Alec requested it, that's just what they did. Said a logical surface extraction. So they didn't go in and pull out any GPS pinging data like you see on Paul's phone. They didn't get off Alec's. Now, if Alec had not made those requests to Owen, and they are disputing that, it's one thing you can be 100% sure of, is they would have called Detective Owen up here on the witness stand during their rebuttal case to say, no, he lied. He didn't ask that of me. I mean, they got Sheriff Smalls in here to say, I didn't give him permission to put a blue light in his car. They came and challenged whether he had authority from the sheriff or maybe a deputy sheriff to put a blue light in his car. But they didn't contradict anything you said about, I've been asking for this data that would get me out of the circle. And now we know why it took so long to get the stuff from his car. It's because it's because the FBI wouldn't go to General Motors on this event data. The FBI was up there and they bought a Suburban, they're riding it around and they're reverse engineering all these systems to try to come up with reports. And then they come in here and tell you, well, it's not complete, some of it's inaccurate, but this is what we got. And during the middle of all that, that's when, lo and behold, we get on start. Thankfully, we did. Thankfully, we did. So then we roll into Labor Day weekend of 2021, where Alex, longtime drug problem, his financial issues, misconduct were exposed. And that made him an easy target for SLED. And I hate to say this, but the evidence is crystal clear. From that moment, they started fabricating evidence against Alec. Well, Mr. Griffin, that's an awful charge. Don't all lawyers accuse law enforcement of fabricating evidence.
I do it all the time.
I can tell you, this guy right here was a federal prosecutor, was a state prosecutor.
Oh, man.
And some of my best friends are in law enforcement.
Wow.
And I don't make that claim lightly. Here, what you have heard is they came up with a report that says Alex's T-shirt had high velocity blood spatter on it. High velocity blood spatter.
Oh,
what's that? That means you're within feet of a shooting. And they didn't just say any shooting. It said in their report, it says as a result of Paul's murder. High velocity blood spatter on the shirt as a result of Paul's murder. That was number one. Well, let's stick with number one. Why do I say that it's fabricated? Well, you heard Agent Zapata said we did hemotrace confirmatory blood tests on that shirt. That means there was two types of tests. There's a presumptive test, which is what they use a product called LCV that makes it turn purple where it might be blood. But it turns purple on other agents as well, including bleach. You heard.
Oh, God.
You also heard that the shirt came out of the bag wet and it smelled like detergent. Anyway, they spray it, it turns purple in places. So they think, well, that must be blood. Next thing they do at the SLED lab is they do a confirmatory test to see if it's blood. 0 for 74, not blood. Not blood.
Man.
That didn't stop SLED from going out and pursuing with vengeance this report. They didn't give the no blood test result to the guy in Oklahoma, and when it surfaced, they had a problem on their hands, and they were pushing it up until this trial. And you heard the testimony from the stand that they went from Mr. Bloody Shirt leading up to this trial to Mr. Clean during this trial. And they ask him, and they raise issues during the trial with Blanca, where were his clothes? No one's asking about the man's clothes that he had on the Snapchat video back in, at 7 o'clock with his son until November or so, I think is what she said. I mean, the issue of changing clothes, it was late to the dance because when they went to, as you heard, when they went to the County Grand Jury to get an indictment that you're going to be deliberating on, they told that grand jury they had an expert report that says high velocity blood spatter. And I asked Agent Owen, I said, when you went to the grand jury and when the guy gave you the report, how'd you not know, chief investigator, how'd you not know that there's this hemotrace test that says it's no blood? Well, I didn't get the email. I'm going to say it in somewhat jest, but, did the dog eat his email? I mean, how's the lead investigator in the case not get the lab report that says there's no blood on the shirt? Now, ultimately, it was produced to us, and we were raising Cain about it and saying, how can you say this on one hand and that on the other hand? And And here we are with a Mr. Clean theory that he washed off after brutally murdering Maggie and Paul. He takes a hose and washes himself off and gets in a golf cart, butt naked, I guess, and drives to the house. So that's the blood spatter fabrication.
Okay.
The other is this blue raincoat with GSR, and you remember that testimony. Shelley Smith, who worked for Ms. Libby and Mr. Randolph,
Slid is always on
had
trial.
told SLED after September, after Alex's problems had been exposed, after she had a conversation with a Allendale police officer following an accident investigation in which she was in an accident, that on the morning, she said in here, as she told you, on Wednesday after Mr. Randolph's funeral, and that turns out to be, I think, June 16th, that Alex shows up at the house at Alameda at like 6:30 in the morning, knocking, trying to get in, and he has a blue tarp. And in this blue tarp, she lets him in. He goes upstairs with this blue tarp. He comes back downstairs. He lays this blue tarp out on Ms. Libby's retirement rocking chair for in the living room, and then he leaves. And then she leaves to go to her day job, and when she left, the blue tarp was laying out on Ms. Libby's rocking chair. That was her testimony. And so SLED gets that, gets a search warrant, goes to Alameda, and they seize a blue rain jacket. They seize a blue rain jacket.
See, what I like is that
And when they do,
he's going chronologically, whereas
they take that blue rain
Waters
jacket,
was all over the
and they
place,
show it
going back and forth, back and forth,
just
back and
about
forth.
every family
Jim
member.
is like laying it out.
Get it right quick.
It's a story. We are geared to listen to
Making
stories.
things of, and
It's easy to follow
it's
because of
defendant's
that.
87.
It's a little boring, but he's got to talk about the facts. I agree.
They show this blue rain jacket to all as many family members as they can get in contact with,
And usually the one telling the truth
And
is the
the
one that
rain
tells it
jacket
in
is,
story form.
and no one recognizes it. No one sees it.
Usually,
no one,
not always.
No one said Alex ever worn it. No one said Paul's ever worn it. No one said Buster's ever worn it. No one said Maggie's ever worn it. Have not seen this blue rain jacket. Has not seen this blue rain jacket. One more thing about this blue rain jacket. When they did the search at Alameda, John Marvin was there. And John Marvin asked him, did you find anything? And they said, well, we found a blue rain jacket back on the property. And he said, well, my dad drives a buggy around and maybe it fell off the back of his buggy. Clearly, John Marvin was understanding that it was back on the property. And then they asked him to come look at the blue rain jacket, and he was told it was found in the closet. And he said, that didn't sound right. And they never clarified it. Now, here's a picture. I'm not even going to put it up, but I'm going to. 411 is a picture of this closet, and you can see the blue rain jacket that's just sort of folded up and stuffed down here at the bottom right. That's the blue rain jacket. And apparently right before this trial, they showed Shelley Smith this picture and says, does that look like the blue tarp you saw? She said, well, yeah, sure, it looks like it. They never showed her this. And she said, this is page 87, it's on the screen. She'd never seen this. But they did GSR testing on this, and it says, whoo, it's hot. A lot of GSR on that. Manufactured evidence, ladies and gentlemen. And then there's this issue of misrepresenting what are the type ammunition found in the shotguns at the residence at Moselle. Paul was murdered with first shot was a buckshot. Went through his chest. He was turned this way, went in here, and then out under his arm, and that was buckshot. The second shot was into the head, either depending on what expert and what pathologist, it's either this way or this way, but into the head. And that was still duck shot. I learned that you can't shoot ducks with anything but steel pellets because they don't want lead in the water. So you got to have steel pellets. And then Agent Owen testified, admitted begrudgingly that he had testified to the grand jury that there were 4 weapons found up on the property in the gun room, 12 gauges that were loaded, or I'm not saying 12 gauges, I'm sorry,
Morning.
4 shotguns that were loaded with buckshot and birdshot. There's 4 other ones. So that matches. Well, guess what? Totally not true. That was totally not true. And he admitted on the stand it was not true. He admitted telling Alec during the interview, and he said, well, I can do trickery. I can do, and we're going to see that shortly. But and then I said, well, you're trying to trick the grand jury. No, I didn't say that. Well, we walked through it, and he did say it. And he didn't remember it, and you'll remember the testimony. And I said, well, people make mistakes, don't you? Yeah, that was a mistake. And it's okay to make mistakes, right? Yeah. And you can make mistakes about time. Well, that's the most common thing people make mistakes about. It's not all right for Alec Murdaugh, who's in the center of the circle, who's not all right for him to make mistakes about time. It is not all right, according to the same investigator who says it's okay, happens all the time. But here we go, and then Eureka. They finally get into Paul's phone in April of 2022, and they see Alec. Well, they don't see Alec. They see Cash the dog, and they see Paul's feet walking around, and they hear voices in the background. One of them sounds like Alec. And off they go. They go off and get an indictment from the Cullinan County Grand Jury, relying upon high-velocity blood spatter, relying upon 4 guns having the same load.
Talk about the grand jury lies.
Relying upon a rain jacket that's got GSR on it, and Alex lying about being down at the kennels. Now we know, after we've been here 6 weeks, of those 4 things,
Bixby voice privacy contacts have been updated. To continue, review the updated items on your screen.
His phone just got activated.
no, that was turned off.
Voice activation.
I will turn it off.
Wednesday Adams is wearing blue today. Hey, look at that.
What we
She's
know
changing
is
colors. Again.
3 out of those 4 things that was presented to the Cullinan County Grand Jury that you're going to be deliberating on for the indictments that return aren't true. No blood spatter, no GSR rain jacket that's ever been connected to Alex whatsoever, and there's no loaded gun. So we're left with the lie. We are left with the lie. Now, Alex lied about being down at the kennels in Almeida. And why did he lie? And that is certainly a fair question. And that's, and frankly, I probably wouldn't be sitting over there right now. He had not lied. But he did lie. And he told you he lied. And he told you why he lied. He said he lied because, I'll tell you, he lied because that's what addicts do. Addicts lie. He lied because he had a closet full of skeletons, that he didn't want any more scrutiny on him, which is the most ironic thing in the world, because depending on which day of the week, their theory is that he slaughtered his wife and son to distract from a impending financial investigation. But he puts himself in the middle of a murder investigation, and he puts himself in the spotlight of a media firestorm. That's their motive evidence, and we'll get to that. But he lied. He lied because of his drug paranoia kicked in, and he was clearly in the throes of addiction. He lied for all those reasons. But what he didn't lie for is because he was covering up the fact that he killed Maggie and Paul. That is not the reason he did it. Doug, will you play the dog kennel video, please? I'm going to play the dog kennel video. Just please listen to the voice.
Wait, Cash. Hey, you got burgers now. Oh, Mom. It's a kitty. There's a chicken. Come on, Cash. Quick.
4 minutes later, the state would have you to believe that Alec Murdaugh up and blew his son's brains out of his head and murders his wife after having that conversation about Bubba having a chicken or a guinea. 4 minutes later, their case wants you to believe that this is a family down at the dog kennels doing what families do. They're checking on a dog, tail. Bubba's out running around, and they're saying, Bubba, got a chicken.
He's got a point.
Now, why would Alec not want law enforcement to hear that? I mean, there's nothing on that tape. There's nothing on that tape that indicates there's any strife, any conflict, any anger, any planning, anybody being afraid, anybody running, anybody scurrying. Nothing.
By the way, for the first time today, I heard "Get him up, get him up."
Maggie.
Somebody said there's a
Paul,
fourth voice.
And Alec.
The real
down at the
killer's
kennel.
voice may actually be on that recording.
That's
but
it.
I'm still,
And their timeline
I don't know.
is based on the fact that this automated thing kind of messed me up, but the point I was going to open this up and say, under their theory, if your phone's not moving for some period of time, you're dead right then. You could be run over in the traffic 2 hours later, but if you're not answering a text 2 minutes after you receive it, you're dead at that point. And that's their case. That is their case on time of death. Is phone stop moving, you're dead. You've heard testimony from a lot of witnesses. I would say practically every witness who took the stand, who actually knew Alec and Maggie and Paul and
Because
Buster.
he's protecting his family.
Testified under oath how much
rats
Alec
out the
adored
killer.
Maggie.
The killer comes after Buster and the
That
rest
was-
of the gang.
She was his all. Some people describe Paul as Alec's best friend. His relationship with him was awesome.
Yes,
And that was unanimous.
that's what we believe.
Unanimous. I want to just play briefly a clip from Blanca testimony about Alec's relationship with Maggie.
He also, I think in multiple interviews with Sweat and other folks, described, I think the words were, Mag.
They're replaying testimony, and I guess the state objected to the replaying of testimony that happened in court. If you're objecting to this, you're a dumbass. Because you can replay testimony, you can replay evidence. I don't understand what is happening here.
Please continue, Doug.
Thank you.
All. Isn't that what you told us, Slade?
Yes, sir.
What does that mean? Maggie was his all.
He adored her. He loved her. He adored her.
Worshipped her. I mean, just treated her as somebody he adored, correct?
Exactly. Yes, sir.
Now, this was her testimony from the witness stand. And then in every trial, there's you hope you
What is
find,
Buster eating?
some very authentic witness,
Buster is sucking on something.
part of the fabric of America that comes in this courtroom. And we had it in this case, and it's Dale Davis. And I was,
Exactly, Mama.
you
Blitz.
remember what Dale testified about Alex's relationship,
Why
with-
didn't they?
his family. We played Dale Davis.
Sloppy AF.
When you use the phrase lovey-dovey about Alec and Maggie, what does that mean? It means they loved each other. What in your presence, you described them as being lovey-dovey, didn't you? Yes. And tell the jury what you meant by that. Oh, every time I always see him, I've never seen that man even raise his voice at his wife or kids. Or his wife. I've never seen him even, none of them.
Is Buster eating the jurors' eggs?
But he always, anything she wanted or.
My eggs now, bitch.
She would try to get it. And what was your observation about the relationship with Paul? They like to hunt and fish together. I mean, they drink beer together. Okay.
That was Dale Davis. Which brings us to the question, why? Why would Alec Murdaugh on June 7th execute his son Paul and his wife Maggie, who he adored and loved? Why? The state's theory is that that it was a storm a-coming, clouds are arising, and that his financial house of cards is about to collapse, and he's about to be exposed. And because of that, he does what every rational person would do: go kill your wife and son. That is their theory of motive. That is their theory of motive. And it worked too, by the way, because he killed his wife and son. Guess what? Jeannie Seconder quit asking questions for a few weeks. Oh, in the boating case, that won't be worth anything now that his wife and son's been murdered, because he's sympathetic. Have you heard such? One thing Mr. Waters and I agree on is the best thing about jurors is you bring your common sense in here and you use your common sense. And that's what it's all about. That's what your collective wisdom. And just collectively think, individually think, what kind of sense does that make? Alex, his financial house is a wreck. He's stealing money from clients. He's got to produce a financial statement, maybe, in a hearing coming up. And his dad goes back in the hospital that day. His dad goes back in the hospital that day, and he hopefully dies a few days later. Okay. So I get a call. Jeannie comes in. My dad's going to the hospital. Paul's coming home. That'd be a good time to kill Paul, wouldn't it? That is their theory of the case. If you don't accept that beyond a reasonable doubt, ladies and gentlemen, I
Your
submit
vote must
the verdict has
must
to
be not guilty. Yes, that's exactly how you
There's
say
no
it.
reason for him to do it. No reason whatsoever. Now, you've heard a lot of testimony about these financial crimes,
The defense
misdeeds.
does not need to prove
And
innocence
he
beyond
told
a
you he did
reasonable
it. He
doubt.
told you he did it to support a very expensive drug habit, and none of that's an excuse, but he is an addict, and addiction is real, And addicts lie, addicts cheat, addicts steal to keep getting their drug.
Hey, Alexandra.
The evidence was permitted in this case for you to hear solely to consider, did he murder his wife and son because he had this storm coming?
If they
He's going to be
poll
exposed.
the jury, yes, Olga.
Is that why he murdered? That's what they say. That's why he murdered. And that's why you're allowed to consider it. Now, Judge Newman in his jury instructions will tell you that's all you can consider it for. You can't consider it by saying, man, I never knew he could do that. So if he could do that, he must be able to do the most heinous crimes in the world. Kill his wife and son, execute him style. That's a no use of that evidence. The only permissible use of the evidence is that sufficient provocation,
Hey, Mom.
motive for him to kill his wife and son? Was it sufficient motive, not provocation? And the evidence in the case is that there was no impending financial doom on June 7th. June 7th was a day which frankly was no different than any other day in the frenetic lifestyle of Alec Murdaugh. He had so many balls in the air, and he even forgot his paralegal's name, and I apologize to her. I think Christy. She said he would come in like a Tasmanian devil. I mean, he was frenetic. And they were on to this $792,000 fee in the Ferris case. And they were asking questions at Chris Wilson's office. But the reason they weren't concerned that he was stealing money. They were concerned that he was sheltering money, trying to hide it from being disclosed in the voting litigation, in which he was a defendant. And they didn't want any part of that. And that situation with the with the Ferris fee, as Ms. Seckinger, Jeannie Seckinger said, that was a one-off. That was completely on its own, different type conduct than all the other stuff that you heard about. That was a one-off. And what happened on June 7th? She says, I'm in his office, and he gets a phone call that his dad's put back in the hospital. And she thinks that he told her it was terminal. He may have, I don't know, but
You really
his
think so,
dad is
Diane?
put back in the hospital. He wasn't terminal that day, but the next day he got the terminal diagnosis. Any event, she takes off her CFO hat and puts on her mama bear hat and hugs him and a friend hat. And
He's flustered.
their theory
because
is
this case is
he
just so
slaughters Maggie and Paul to buy time from her
hollow.
investigation. That is it. That is their theory. That is their theory. And it's totally fabricated. They've got no evidence of that. There's no evidence that Maggie was on to his financial misdeeds. There's no evidence that she was about to blow the whistle on him. There's no evidence that he had a $20 million life insurance policy on her, and that if he murdered her, that he could get out of financial bond. None of that. None of that.
If it didn't come into evidence, Liam,
And I asked Ms. Secretary, how long of a delay did that buy Alec? What, month maybe? A month? A month? That's their theory. That's what their case is built upon. And then this motions hearing is, there's a motions hearing scheduled for Thursday. It had previously been scheduled 2 other times. And it was continued at the last minute on the other occasions because 2 of the lawyers had cancer and were receiving treatments. But it wasn't sure it was going to be
My
continued.
benchmark
previously.
on closings is
Did
does
he
it
go
cause
murder anybody?
headache to DUI guy?
Get out from under those prior hearings? No.
DUI guy gets headache,
This had
bad
nothing to
closing.
do
DUI guy gets
with
no
it.
headache, good closing.
And,
DUI
so
guy
they
doesn't
brought
have
the
a headache
plaintiff's lawyer
today.
in. He's
Good
an excellent
closing.
lawyer. And he's, like any plaintiff's lawyer. I'm going to clean his clock. I'm going to take everything he's got. That's what they all say. So then we had to bring the defense lawyer in to say, that was a negligent parenting case, and it wasn't worth the paper it was written on. I mean, folks, that's what That's what we are in the murder case, and that's what we're having to deal with because that is their theory of motive.
Maybe.
But even if the financial day of reckoning was impending, if it was right there, Alec would not have killed the people he loved the most in the world. There's no evidence that he would do that. We do have evidence of what he would do and did do. And if you'll pull up Defense Exhibit 125, which is in evidence. On September 2nd, 3rd, 4th, I forget the date. This is Labor Day weekend. He gets his drug dealer, Curtis Eddie Smith, to shoot him in the head till he couldn't go on because it was all going to come crashing down.
What kind of?
And he had a big life insurance policy. So when Alex is
I have an idea. All right, I'll make a poll.
Financial collapse, he doesn't go kill somebody else. He tries to end it himself. This is a natural response. You don't want anybody to do it, but people kill themselves from being exposed. Don't kill their wife they adore, son, the apple of his eye, as some people have said. That's not. That is, I don't have the adjective for that. That is so outlandish. I don't have a word for it. Totally illogical, irrational, and insane. Those are words I wrote down. For someone to kill their loved ones when their criminal conduct is being exposed. So, you can take that down. Yeah, thank you, Doug. Yesterday we heard a lot from Mr. Waters. And I've been in Mr. Waters' position. As I explained, I was a federal prosecutor for a number of years. I've been a state prosecutor, part-time mostly. And I've done his job. It's a very rewarding job. And I hold him and I hold his office in very high esteem. But there just sometimes folks just get caught up in a case. They get a desire to win. They get so intoxicated by the attention that's brought on by the case that they start sort of a win at all cost approach. And I'm going to go through some things that Mr. Waters stated to you that just aren't facts and aren't supported by the facts and the evidence that you heard.
Thanks,
And
Alan.
before I do that, I want to give you a cautionary statement. We lawyers aren't witnesses. I didn't take an oath to stand up here and talk to you. I have ethical obligations about what I can say and limitations under the rules, but I'm not a witness. I'm here to talk to you about the evidence. And the same applies to Mr. Waters.
Why are you saying that? That's a waste.
You decide
Jim.
what the evidence is.
Don't do that.
You decide.
You just
And
stop, Jim.
Further, we're going to take a short break for about 10 minutes. Please do not discuss the case.
That was a good place. That was a good place. That was a good place to stop, but I don't understand why Jim was going back into that. That was unusual. You don't want to remind them that everything you're saying is not evidence. That's a bad reminder. That's a very bad reminder. Okay? You don't want...
And it was untrue. That's a problem.
You don't want to remind them of the fact that everything that you're saying is not evidence. Even though that is a fact, but reminding them just tunes them out. And they're like, well, why do we need to listen to you? Now I don't need to. You're inviting them to tune you out. That's the problem. When you remind them of that, of the fact that everything you say is not evidence, you're inviting the jury to stop listening. And so, in order to avoid that, you want to just talk about the facts. I mean, thanking them for their service, that's the prosecutor's job. Defense attorneys, we don't need to do that. Our job is to show that there is reasonable doubt. If I were Jim, this is what I would modify about his closing. I would get an easel and a Sharpie. Okay, this is extremely effective. I've seen it done. I've done it myself. I now do it usually in PowerPoints. But I find all the reasonable doubts that we have in the case. Like, for example, absence of motive for Alex to kill. The fact that the Snapchat video has like a fourth voice in it. The fact that the tarp didn't have blood. You know, all of those things. And as I'm talking about them, I would walk over to the easel, or in my PowerPoint, I would just have it as a PowerPoint. And I would write out, you know, like no blood on the blue tarp. And then I would keep talking. And and then by the time I'm done, if you do it right, you're going to have, in a case like this, I mean, it's going to take a while. In a case like this, because this is a 6-week trial, you know, in a DUI trial, I usually have no more than like 13, 14 reasonable doubts. But each and every single one of these is a reasonable doubt. And what I tell the jury is, you don't need to have 100 reasonable doubts. You know, like I listed 14 on here. If you have a doubt in your heart about one of these 14 that I've listed, and Jim could, in theory, have like 157 in a case like this very easily. We have 157 reasonable doubts here, ladies and gentlemen, of the jury. You don't need to be convinced that there are 157 reasonable doubts here. All you have to do is believe there is one. If you believe out of these 157 that I've listed, and you're like, you know what? I don't know. Right there, that I don't know, that's reasonable doubt. Your vote must be not guilty. Boom. And that takes a lot of pressure away from the jurors. When they go back to deliberate, they're like, well, the lawyer said in his closing, hesitating. If I have a moment where I'm uncertain, if there's a moment where I'm unsure, if there's a moment where I'm like, I don't know, I'm hesitating, that right there is reasonable doubt. Now, Jim talked about that. Kudos and props to Jim. He's been watching DUI guy videos, apparently. I'm joking, of course. And you can't, exactly, Diane, you cannot go with your gut. That is not permitted in a court of law. We can do that. I can do that because I'm streaming it. You can do that because you're sitting at home. The jurors are not permitted to do that. The jurors, by law, they will be instructed in maybe 3 hours or so. They'll be instructed by the judge that they are not permitted. They have to follow the law. And assuming, this is a big assumption, assuming that they do follow the law, they will not be permitted to go with, quote unquote, their gut. We can do it. You can do it. I can do it. Everyone else in the world can do it except for the people in the jury box. Therein lies the difference. And that's why 808 fee, I'm on the same boat. It's been like not guilty hung jury. We already have, I mean, it's kind of staggering. So what happened this morning? For those of you who missed it, okay? Let's talk about what happened this morning. Exactly, Rose. So this morning, one of the jurors was struck by the court, not by any of the lawyers. I believe I know who it was too. She was also covering herself with a blanket for the majority of the trial, but not like her face or anything. She just liked her blanket. It's either her or the other one. Based on the voice, I could tell, you know, I think I can tell who they are. and James may confirm or deny, but again, I'm not telling you all because I don't want to give away her identity on accident, and I don't want to reveal any information about her. That's just not fair. So she was struck because, according to the judge, they have had in-camera hearings, and Jeanette reported yesterday. I don't know if this is public or not. It's about to be. She said that the lawyers did not get out of the courthouse until like 6:30 p.m. yesterday, like super late. And she was like, I don't know what the heck they're doing back there. And I asked her, do you think they're discussing about that whole juror situation? And she said, I don't know. Wouldn't that be decided by now? And I said, I don't know either. I guess we'll find out. And here we are. So now we know what they were talking about. They went in chambers, as the judge said, after court and had an in-camera hearing. What does that mean? It means in the judge's chambers, in the judge's room, they sat and they talked with that one juror about the conversations that she has had with people. And apparently she has been saying, this is, again, a very... I mean, it's confirmation in my book. Take it with a grain of salt that I'm a defense attorney, okay? So I understand if the defense is objecting to anything, that means it helps their case. Otherwise, there's no reason to object. If let's say that the juror was going to vote guilty, a Poot would have been like, show her the door. Here, I'll hold it for her. Like get her out of my room. Get her off my jury. But because Poot's like, Your Honor, I object to your decision. I believe, like, basically she should be able to stay. We disagree with the court. I just want to make the record clear, blah, 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 preserving the record for appeal, standard stuff. That means that juror was favorable to the defense. Not even a question. Not even a question. And the judge insinuated that she not only talked to people about the case, but she prematurely prejudged. She made a guilt or innocence determination. So that's a fact. That's what the judge said. He just didn't say which determination it was, which direction she was leaning. But the fact that the state just sat there quietly and we don't care, and Poot was like, nope, don't like, please stop. She was a defense verdict with juror. And we have, how many alternates do we have remaining? 1? 2 at most, but we have at least 1 alternate, and we should be good because they're going to go deliberate probably in about 3.5 hours. So as long as there's at least 1 juror who is going to say not guilty, we're going to have at least a hung jury, because there is not a realm of possibility, in my opinion, as a professional, as someone who's been watching this trial, as someone who has an opinion, as someone who has, has seen the evidence presented, there's not enough for a unanimous 12 people who have not been influenced by outside sources like Netflix and reading articles and news and media and all that, assuming they've been following the rules. Again, there's a lot of assumptions, but for the most part, jurors are very apt, except for that one that was talking about and that's the thing. She wasn't even really violating the rules. Even the judge insinuated that you're not really violating the rules, Ms. Juror. You didn't do anything wrong. You just shouldn't have talked. You prejudged the case. You're not supposed to do that. You're not supposed to talk to people about the case before the case is over, and you're only allowed to talk amongst yourselves. That's just inexperience. Probably her first time as a juror. She's fairly young, I believe, if that's the one who I'm thinking of. So she might be like in her early 20s. James will confirm or deny. When they go back to deliberate, I don't think it matters anymore. So James will confirm or deny later today as to whether or not it's exactly who I'm thinking it is. And so, yes, exactly, Trey Tib. So anyway, all it takes is 1. So if there's 1 juror on there that's like, look, I don't care, I'm going with my gut and ignoring the law, like jury nullification, but the other 11 are like, we're not sure, or maybe a few, like it's still a hung jury. See, no matter which way you swing the pendulum, it's pointing towards a hung jury. You see what I'm saying?
Used to. Yeah.
Sorry, I'm just making sure I wasn't live. Here we go. Their court's not back yet. So all it takes is one. So I believe if we do get a hung jury, the state is not going to retry. There is still a realm of possibility of getting a unanimous not guilty. You know, it's like reverse 12 Angry Men, where there's like one juror who's like guilty, and it's like 11-1 or 10-2, and then the two that are going guilty, they're like, well, maybe I missed something, and then they'll flip, or like they'll come out, and yeah, James is staying for the verdict from what I hear. Summer Golden. You know, they'll come out and say, oh, and Corey Simon and I, we have a dollar bet going. The bet is he's saying the judge is going to Allen charge the jury at least 3 times. I'm saying there's no way he's going to Allen charge them at least 3 times. What is an Allen charge? An Allen charge is when, let's say, the jury is hanging and they come out and they say, Your Honor, we can't decide. And the judge goes, what's your split? And they're like, I don't know, 9-3, 8-4, whatever. We can't decide. Okay. Allen charging them means, all right, you go back, try again, deliberate, see if you can reach a conclusion. And they come back out. All right, what's your split now? Well, now we're 10-2. Okay. He can be like, all right, Allen charge, go back, deliberate. And they come back, Your Honor, we still can't decide. What's your split? We're still 10-2. All right, give it one more shot. Corey's saying that's going to happen. Corey's saying that's going to happen. I'm saying there's no way there's going to be 3 Allen charges. A. Gluck also wants a bet, huh? Somebody want to take him up? I'm not doing it. Olga says I'm winning this bet for sure. Maybe. I don't know. Hey, he offered. It was a hard bet not to take. And I wasn't going to bet more because it's like I'm not a gambling man. I like to make my money the honest, earnest way. You know, by making YouTube videos, shitting on Amber Heard, and making videos about Alec Murdaugh, and of course my law firm. You know, the honest way, shitting on people who deserve it. So, or as Boozy would say, grifting off of the pain of others. The fucking asshole. If you know, you know, Monica. If you know, you know.
And they bring them in.
Bring the girl. All right, here we go. Don't forget to vote in the poll. If you know, you know. We're not revealing what that is. If you know, you know. You had to be there.
All right, thank you. You may continue.
Thank you, Your Honor.
Yesterday in Mr. Waters' closing argument, he said that the evidence established that Paul and Maggie were murdered with family guns. I mean, that perhaps is his view of the evidence, but that's not a fact. In fact, the state's ballistic expert testified that the 12-gauge shot shells, as you found in the feed room, were fired by the same shotgun. That the shot shells, the things that rolled under the door, were fired by the same gun. That's all he testified to as the shotgun. Now, they have put a lot of guns in evidence here that have nothing to do with the crime. So we don't know what shotgun was used. It could have been a shotgun bought at Walmart that afternoon. It could have been a 20-year-old shotgun. But all the evidence, ballistic evidence, is shot shells were fired by the same gun. And don't know that you really need an expert for that, but that's what the testimony was on the shotgun. With regard to the 300 blackout, you'll recall that this guy, Paul Greer, testified that the cartridges found at the crime scene, and Maggie was shot with a 300 blackout, that the tool marks, it's called tool marks, that the extractor and ejector marks from the cartridges found at the crime scene matched extractor and ejector tool marks on some cartridges found at the house and some found at the shooting range. And what he didn't say was that where the firing pin breaches that cartridge, which is one of the most reliable indications, it did not match. No match. And he also did not compare projectiles. There wasn't a projectile found. When I say projectile, that's the bullet. That's the bullet thing. That went into Maggie's body and broke up. But one went into the dog house and was found in the dog bed. And so they have that. And what they did not do is take that projectile and dig projectiles out of the berm where the shooting range was and compare it to see if they match. And that's the most reliable way to do it. Now, in David Owen's notes, he said that the ballistic expert can't be 100% sure until you have the gun. And you heard my cross-examination of Agent Greer, and this tool mark ballistic examination is somewhat soft science. It's come under criticism. It's what they rely upon. Not every investigative lab relies upon it. That's what they did here, but it's not gospel. It's not gospel. Another thing about the 300 blackout, he in his closing, Mr. Waters repeatedly said that Alec bought it. And I assume we're talking about the replacement. I don't know. Alec bought it. Well, Alec didn't buy it. The evidence in the record is Maggie bought it. And he kept saying it's the defendants. And it's not the defendants. The replacement 300 blackout, which frankly no one had seen Paul with it in quite some time except Will Loving on one occasion in sometime in March. It was Paul's gun. It wasn't Alec's gun. Paul's gun. At one point in time during his closing argument yesterday, Mr. Waters reenacted a shooting scenario, if you'll recall. And I'll do my best, but he stands up here and he says that Alec shoots Paul in the chest one time. And 999,999 times out of a million, that person is dead. He puts his shotgun down, and he has a 300 blackout right here because he is so smart and so diabolical that he's going to stage it so it look like two shooters. So he's got a 300 blackout here, a shotgun that he just took his son out, but his son was 1 in a million, he says. 1 in a million comes this way, so Alec has to put the 300 blackout back down, pick up the shotgun, and shoot Paul. Where in the world does that scenario reside other than in Mr. Waters' mind? It doesn't. It doesn't. There's no evidence to support anything like that. None. And the fact that he has to go to such
No, Lee.
gymnastics to come up with Alec staging a two-shooter theory, I ought to tell you, there's two shooters out there. I ought to tell you, someone to do that Another curious point in Mr. Waters' closing argument yesterday involves Paul's intuitive talents. You will recall that Alex informed agents that Paul was an intuitive little dude.
I don't know where she is.
Referred to him as a detective. That Miriam Proctor, Maggie's sister, said that Maggie referred to Paul as his little detective, her little detective. And particularly when it came to
Almost
trying
sounds
to
sexual.
root out whether Alex was still doing drugs.
Reel your
sort of
horses
left
in.
it there. Sort of left it there for you to then take it and run with it as if, oh, Paul must have found Alex using drugs. There must have been a confrontation down there at the kennel, and that must have been what happened.
You're
Now,
so
he
thirsty, I can
didn't
see
go
you
that
drooling,
far
Olga.
in his argument, but he laid it out there for you to run with. But that was clearly the implication. And I want to tell you first, there are no facts to support that. None whatsoever. Let me add another scenario that's equally as plausible. What if Paul the detective learned the source of drugs that were being sold to his dad? What if Paul the detective goes to that drug source, says, cut it out. It's my dad. You're ruining my family. And if you don't, I'm going to tell on you, turn you in. And what if
There it is.
source is a member of dangerous drug gang?
No, I don't object.
Sustained.
Okay.
Well,
Anyway.
the point is, there's no more evidence to support it, and there was no evidence. Those were just plausible scenarios that they were throwing out to you, and that you could think up many equally plausible scenarios. But you have to decide the evidence based on the facts that the state puts before you.
No, I didn't, Olga.
Not theories.
It's the slang.
Not inferences.
Slang
Not
term.
speculation, but cold, hard facts. Mr. Waters also said that Alex, the master liar, accused Shelley, Smith, Blanca, and perhaps another witness of lying. He never did such a thing. He never accused anybody of lying from this witness stand. Now, I've been around long enough to know that witnesses can misremember things and believe them to be true. And frankly, I'm the biggest defender of that trait in my household. I convinced myself that I remembered something accurately, and I will have an argument with my wife until she shows me photographic evidence that I'm just wrong, and that's what it takes. I mean, that happens. People misremember things. But because we point out that there was an inconsistent fact, that doesn't mean we're saying someone lied, and we never did that. We never did that. One example is Sister Marion. One example of misremembering. Sister Marion said that she spoke with Maggie about 7 p.m. while she was at Edistoke, and that Alec wanted to come to Moselle to visit her father. Well, we know that her recollection is mistaken because we have cell phone records, we got FBI records, we got her phone bill, we got that shows she was in Mount Pleasant and then she was traveling to Moselle around the period of time where Sister Marion thought she was at Edistoke. Did not happen. That doesn't mean that she was lying about that. Absolutely not. That's just how she remembered it. And she also said that when she talked to Maggie, that Maggie was going to go over and visit Mr. Randolph at Alameda. But we know from the records that Mr. Randolph had already been readmitted to the hospital. I mean, that's in the records. And that Maggie knew it. We've got Maggie's text to Blanca, I think in the day, saying they're putting Mr. Randolph back in the hospital. We're scared for everybody and hope Alec doesn't go down to the hospital. Well, no reason I'm pointing it out. This is how Miriam remembered it. But if she remembered it incorrectly, and that happens, because we point stuff out like that, we're not saying they're lying. Now, in the same with Shelley and the blue tarp, she remembers something. We're not sure what, but the evidence clearly is. She says it was on Wednesday, June 16th, and we got FBI cell phone forensics. We've got records, and we got testimony that Alec is in Somerville He spent the night with his in-laws, the Branstetters on Tuesday, and he stayed there toward the end of the week, and then they went to the mountains at Kiowee. So Alec could not have been knocking on the door of the Almeda house on the morning of June 16th. And Barbara Mixon came in and told you that she relieves Shelley. Shelley works all night, leaves, and goes to work at the school district. Barbara Ann comes in at 8 o'clock and relieves Shelley. And as Shelley recalled it, as the tarp was laid out when she left for work. Barbara Ann came in and said, I didn't see it. No time during that week that when I worked was there a blue tarp. I mean, Shelley remembers something, but she's not a blue raincoat, and it's certainly Alec could not have come over there on Wednesday. Now Shelley also says that he spoke to me about times, and that bothered me. And I called my brother. We're not disputing that, but what she didn't say is Alec told me to say I was here in 45 minutes or things like that, and frankly, it doesn't make a lot of sense because Alec kept saying, "You get my phone records, and you'll know exactly what time I was when I was there." And I'll get to this a little bit more in a moment, but Mr. Waters keeps talking about, oh, he's hurrying to get over there. He's hurrying to get over there to compress the time so that it looks like he's been gone from Moselle longer than he was. Fair enough argument. I understand his point, but that point evaporates when you're talking about how long you are at Almeda. It doesn't matter if he's there 45 minutes or 20 minutes. Does it really matter how long he was there? Now, I guess before you had the OnStar data, they could be saying, oh, he said he was there 45 minutes, but he's only there 22 minutes, and he spent the other 10, 15 minutes traipsing through the woods, burying bloody clothes and getting rid of murder weapons. Well, we may have heard that in this trial had we not gotten the OnStar data from General Motors in the middle of the trial, which shows conclusively he drove over there and he drove straight back. Another small point. He said there's biological material on the Polaris. I don't think that was ever tested. It certainly looks like it. But what we've learned in this case is things aren't always as they seem. They thought they had blood on the shirt. Turns out there's no blood on the shirt. And that this biological material showed that Maggie was running toward her baby. Now,
this is already
I don't know that there's any evidence.
I'm not going to lie.
Maggie was running or what she was running to. There's not. I mean,
he made his
a fair
point,
inference,
but he has to finish it out.
Everyone who knows Maggie,
he made the point.
Would know that's what
we need
she would
reasonable
do.
doubt. We have
We're
reasonable
not disputing
doubt.
that would be her.
You should.
That would be
acquit.
her mother instinct.
You have to acquit
And
based
did
on the
that probably
evidence,
happen?
which there is
It
none.
probably did, but
And now it's like he just has to
it's-
finish it out.
just to state it as a fact, there's no evidence of that.
You already won, Jim. You can.
Now, one
you can-
thing he also said, the
you don't
cell
have to go
phone
through all of the
backlight
evidence,
turning
but
on.
he's going to anyway. Because I mean, he's going to
and-
feel like he's doing a disservice to his client if he
I
does.
don't have an Apple phone, but so here's the issue, and mine won't do it because I don't have an Apple phone, I don't think. But if you take a phone flat and pick it up, light comes on, and why is that important? Why is that important? Like I say, and I'll probably turn this phone off, and if I'm making a point that you all know the answer to, I apologize, but it's important that you do know the answer to why this is important. It's important because now that we have the OnStar data, we know Alec drove his Suburban by the spot where Maggie's phone was found at 9:08.
Yeah,
Now,
he
there's
has
probably
to.
some seconds in there, but 9:08.
But he's got it.
We know that her phone is in the woods at that point. So the question is, did Alec throw it out the window at 9:08? And the answer is no, he didn't. Because if you throw it out the window, at a minimum, the display light's going to come on. At a minimum, And when that display light comes on, it registers. These phones say a lot. I mean, I was
3 days,
lesson learned in this case.
I think.
It registers in this Knowledge C database, and it says display light on, and it has a time that the display light came on. Well, there's no, on Maggie's phone, the display light does not come on at 9:08. Okay? So, means Alec didn't throw the phone out. And yesterday, Mr. Waters says every single expert testified that the backlight comes on and sometimes it doesn't when the phone is raised aggressively. That's not true. Only one person testified to that. And Mr. Murdaugh, who over the weekend, he works for Charleston County Sheriff's Department. I don't know why they didn't get SLED agent to do it, but he says, apparently he got a phone similar to one that Maggie had, not Maggie's phone, had software, not the same version as Maggie, and he spent all weekend throwing the phone on the ground, see what would happen. Or many hours of the day throwing the phone on the ground. And he comes in here and says, hey folks,
I'm an
sometimes the
expert.
light comes on, sometimes it doesn't.
Yeah.
Well, our expert, Nika Sturgis, says it comes on. It comes
Nina,
on.
did you just
That's what we're
change
talking
teams?
about. That's what we're talking about. But folks, we wouldn't even be having this discussion
You were guilty yesterday. Today you're not guilty?
if they had secured Maggie's phone and not allowed not put it in a Faraday bag so that the GPS coordinates on the 7th would not have been overwritten. And they were. So now
Jim
we've got
is
a
an
guy
expert.
down in Charleston throwing a phone around all weekend. Because they are desperate to prove Alec threw the phone out when he went by the room.
that
They
was
got no evidence
terrible.
of that.
Should have never.
In fact,
put
the
that
evidence
guy
is
on.
the contrary. He did not. And the evidence supports everything that he had said from the day he had that interview or a couple of days. You get the OnStar data, you get GPS data, you get my GPS data, and you'll know I'm not traveling with her phone.
Nina changed teams.
Never got it.
She was guilty yesterday. Today she
Wrote over it, and now we've got a guy tossing a phone in an office. Doesn't even work for SLED. Not every expert says that. The guys even said that's not his area of expertise. So, let's see if I've hit all. Oh, yeah. The last one's about me. Mr. Waters says that I did an HBO interview in November 2022. And he references some things I said in the HBO interview. Well, I didn't, and he knows I didn't. It was testified about. There's an HBO
What the
special.
fuck?
I am on it. I'm not telling anybody to watch it, but that was filmed back in, I don't know, spring, summer of 2022.
No, Jenny. That has no bearing.
Well before he was charged with murder. I'm not on TV talking about his murder charges, but he wants you to think that, and I don't know why. And I took a little bit offensive to that. I really did.
Look at
We
Wednesday.
object.
Oh my God! Objection!
I was not being interviewed.
Objection's overruled.
Thank you.
Not being interviewed in November 2022. Not.
Even Sled is smirking in the back there.
So I've asked why. They can't answer that. They don't have an answer as to why. Now how? How could Alec, in the time period we know we're going to get to it, but how could he have butchered Maggie and Paul without leaving a trace of evidence within a matter of minutes? How?
Look at how
Looking
he's
why,
shifting
now how.
over there.
And the answer to the how is he couldn't. But this is the wrong question to be asking yourself. Because the question that you are tasked with answering is, has the state presented evidence that proves beyond a reasonable doubt showing that Alec butchered Maggie and Paul without leaving a trace of evidence, all within a matter of minutes? In a matter of minutes. Have they proven evidence? Do they present evidence of that? Proof
No.
beyond a reasonable doubt.
No.
He was able to make
Is he about to sit down?
bloody clothes, bloody guns.
There it is. Reasonable doubt. Reasonable doubt.
who knows how much, whatever, disappear in a matter of minutes without leaving a trace. Without leaving a trace. Of course they haven't.
He's about to sit down.
Reasonable doubt is doubt that causes a reasonable person to hesitate in one of the most important decisions of your life.
Oh my God.
And here, there's no direct evidence of Alec doing anything other than he's at the kennel, 8:44, and it's just pleasant family talking about Bubba the dog getting a chicken.
Yes,
so the state's
Jenny.
trying to weave this story of his guilt based upon circumstantial evidence. And the judge will charge you on circumstantial evidence, and I have no dispute with what the state put up here yesterday, because that's the law, and you're going to get it. He's going to give you the written document with the charge. And you will see in there that when they rely upon circumstantial evidence, it's as good as direct evidence, but there's some things that it has to do to be as good as direct evidence. And what it has to do, the circumstantial evidence, is that the circumstances must be consistent with each other, and when taken together, point conclusively
yes!
to the guilt of the accused beyond a reasonable doubt.
Yes.
If these circumstances portray the behavior of a defendant as suspicious,
and there's no conclusive evidence here.
That's circumstantial evidence. So what are the circumstances that the state relies upon? Well, he was at the kennel at 8:44. Paul last used his phone at 8:48. He replied to a text with a friend about a movie recommendation. Maggie's phone locked for the last time at 8:50. Actually, it's 8:49 and 50 some odd seconds, but 8:50. But however, her phone recorded significant steps around 8:55, and we're going to see that. And her phone tried to activate the camera at 8:55, and it registered an orientation change at 9:06. And I think pretty much understand the orientation change, but when the phone goes from landscape to portrait, or this is beats me, but goes from that to that is an orientation change, and the phone will tell you. So it did that at 9:06. And they've got 300 shell casings, extractor and ejector markings matched with casings found around the house and shooting range. So that's pretty much it. And then of the circumstantial evidence of his guilt. Now they want to say, well, he lied about it, so it's consciousness of guilt. But I'm talking about what evidence they have, put all the circumstances together, prove he shot to kill Maggie Paul, and that's pretty much it. And how have they established the time of death here? Solely on cell phone use. And using the phone or not using the phone doesn't dictate or define whether you're dead or alive. I mean, I'd say most everybody in this courtroom does not have their phone with them right now. Under the state's theory, as I mentioned before, if they die while they're not using their phone, then they're dead the moment they stop using their phone. That's what they have here.
Yeah,
that is
that's
their
true.
case.
That's a good point.
There are a number of reasons that Paul would stop using his phone. First, so I got two testimonial clips, one from Rogan. Remember Rogan Gibson? If you'll play that quickly, Doug.
It was never opened again.
This is Rogan testifying
Waters
about
made a
Paul's
big
phone.
point about that, but it's never opening the phone again does not equal deceased at that moment. Like, you could still not unlock your
You
phone
asked a
for
little bit about
10,
Paul's
15, 20
cell
minutes and
phone
still be
usage.
alive, and then
He
be
was on
dead.
a lot. He was on a lot, yes, sir. Yeah.
But that's all they have, so they
um,
have to use it.
And did the battery get down?
Okay. Moment.
What? Another objection?
What is the objection?
Not showing the witness, they're showing the defendant while the witness is testifying. I think the testimony was.
What's the legal basis for the objection? All right,
Overruled.
Mr. Griffin.
It's a clip from the live feed of this trial, Your Honor. I can't control who is being depicted, but it's my voice asking Rogan.
Been in trial how many weeks?
6 weeks.
So we're not going to replay the trial.
No, he's not replaying the trial. He's just
Clip of a few
replaying the
seconds.
clip. Objections overruled. Please, Judge. Come on, be real.
Sustain the objection.
Oh, come on! Get the fuck out of here.
So you will remember that Rogan said that when Paul's phone, and by the way, if you don't remember and
Judge,
you
your
have questions
bias
about
is
it,
showing.
when
You allowed it a
your
minute ago,
deliberations, you
and
can
now it's not
always
allowed
ask
anymore?
to have testimony replayed for you.
Fuck off.
Johnny, can we play the audio without the video?
You're asking me,
Yes.
what can you do? I rule on objections.
That's true.
Can you play the audio then?
Play the
You
audio.
asked a little bit about Paul's cell phone usage. He was on a lot.
They're not
He was on a
objecting.
lot, yes, sir. Yeah,
And they must have heard me or something.
and did the battery get down low pretty regularly?
Yes, he would let his phone die sometime, or he would.
Oh,
lose
I
it.
love this.
Well, and when it would get down
Oh, I love this.
low, did he have a habit of
Very nice.
not using it to try to keep him
And the
going all the way
prosecution
up?
is asleep at the
Yes,
wheel.
I have
It
seen
should
that
have
happen
objected.
before.
Should have
And have you
objected
done that
again.
yourself?
All right, and so you'll know from the photographs and the evidence in the case that Paul's phone was at 2%, and it was on low power mode at the time. He was texting this friend of his about a movie recommendation. And then can you play the audio only of, you remember Nate
They found a loophole. They found a
Tootin?
workaround.
He testified about Paul putting the phone down when he was working around the kennels.
Oh my God. You guys are
And how would you
brilliant.
describe the relationship between Paul and Alex?
They had a really good relationship.
Would you say that Alex?
I don't think that's the right clip. The so there,
That's how you do defense work.
Mr. Tootin testified that when
No,
Paul would
he's
work,
just
he would put the
exhausted.
phone down, forget where it was at times, and
He's
then it was
winning.
pretty
my
common for
book.
him to put the phone
Call
down
me
at
biased. Call me whatever you
the
want.
kennel.
I think
So he
Jim's
wouldn't
got
get
this.
wet. And you recall Dale Davis, they brought him to the stand. I think they brought him to the stand to make it seem like the hose was unraveled and then it was
That's funny.
used and put back. And we know from the video, and you can see it again, the dog kennel video, we pointed out the hose is on the ground
There's rebuttal here.
outside Cash's kennels. And Mr. Davis says, yeah, that was not how I left it. Someone had put it down. And then
It is starting to drag out a little
and I'm
bit.
going to show you.
But the point has been made. Again, the thing is, he doesn't need to prove his client's innocence beyond a reasonable doubt. He just has to show that the state does not have guilt beyond a reasonable doubt. We don't live in communist Russia. In communist Russia, Jim would have to prove Alec Murdaugh's innocence beyond a reasonable doubt, and he would be a cooked duck, probably be in life in prison. But in American systems, the prosecution has to prove guilt beyond a reasonable doubt. Jim only has to show that there is a reasonable doubt, and he has done so.
Doug, can I have the
And he's got more. He's not even done yet.
Oh, that's awful.
Is this the Not Guilty channel? This is where we speak the truth about what we think, and we don't. We're not apologetic to accommodate people's feelings.
Just give it to me, please.
So I hope that answers your question, YouTube user.
Ladies and gentlemen, you'll have back in the jury room State's Exhibit 503, which is a picture of the dog kennels from the murder scene. And
Oh no, he
what
got
I'm
me.
pointing out
He's
on top
absolutely got
of
me.
These two kennels are dog beds. You'll see Exhibit
So
503.
right
The
now
dog
it's
beds
just
are up here on
he
top.
has to finish, but
And you recall Dale Davis says
he did fantastic.
when you
He did
clean out the
exactly what he's
kennels,
supposed to do.
hose it down, you put the dog beds.
This is the
on
logical channel.
top.
Exactly, Tracy.
On top. So it's pretty clear from these photos, this photo, that Paul and or Maggie had sprayed out those dog runs and put the dog beds on top.
Exactly.
And that,
Christopher.
and put the hose away.
But you got to put the hose away.
Alec testified that
I'll make a joke there.
Bubba and Brady had on collars.
Is Wayne Brady gonna have?
And we see the collars.
Is Wayne Brady gonna have to choke a bitch?
States 45.
Got to put the hose away.
So their collars hanging here, but
hose not listening.
Their collars hanging here, and then there's collars here, and the dogs don't have collars on them in the dog picture. So it's a fair conclusion that after Alec left, when he said he left, that Paul puts Bubba up, Paul puts Grady up.
Thanks, Vince.
After cleaning out the kennels, and then he goes back into the feed room to get his phone, where he was confronted.
Exactly, Bumble.
Where he was confronted. Or sometime later it happened.
Oh my God.
I don't know.
We are
but
twisted.
they are relying upon cell phone usage for time of death. The coroner said he did the armpit test, which is no test at all. It's just a guesstimate. Can you pull up in evidence? Now I want to talk about Maggie's phone and defendant's exhibit 158, please. So this is Maggie's phone timeline that we put in evidence, and this is going from 8:49 to 9:07. And if you'll just walk through it, you'll see at 8:49:26, last text message read by Maggie. Okay, go to the next one. 8:49:28, backlight off. Go to the next one. 8:49:31, phone locks and remains locked until recovery by law enforcement. It was locked for the last time and never unlocked. 8:53, but on 8:53, the backlight comes on. Backlight comes on. It's being manipulated. 8:53:12, orientation to portrait starts. 8:53:15, phone begins logging 59 steps. 8:53:20, there was a Siri usage, and the testimony is you can get that by squeezing the button. 8:53:24, the orientation portrait completes, so it switches. And then 8:53:28, backlight is off. Next, backlight is on. Backlight is off again. And it's on again. Keep going. And then 8:54:34, camera use starts. It's activated by touching the camera icon or by swiping left from the lock screen. There was a question as to whether that could be from facial recognition, and Lieutenant Dove said that information resides in the Knowledge C database, but he did not look for it. Micah Sturgis, our expert, looked for it, found it, and came and told you that was not a facial recognition miss. It was from intentionally activating the phone only for 1 second. Go to the next slide. Camera usage ends. Go to the next slide. Orientation of landscape starts. 8:54:44, it ends. And then 8:55. So the point is, there's a lot going on with Maggie's phone at around 8:55. Keep going. Keep going. And then at 9:03, the backlight goes off. And at 9:04, there's a missed call from Alex. And 9:04:23, the backlight's off. And 9:04:41, the missed call from Alex ends. So let's back up to, let's go to 9:04:23, missed call from Alex. Okay, and this was the testimony on 9:04:23, and it's important.
Were you taking a nappy nap?
Alex calls Maggie. And when that happens, you would, her backlight was on. Go back one more. So our backlight is on at
Chat was
9:03:52.
Kitty cat.
At 9:04, missed call from Alex starts. At 9:04:23, and
Yes, Boone.
instantaneously, the backlight goes off. Now, you heard the testimony of that means when that call came in, someone pushed on the side to stop the call. Now, was that done by Maggie because she was over on the other side of the workshop where we see those footprints that we heard about that were never really analyzed? And that she didn't want any noise coming through? Or was that some bad guy or bad person has Maggie's phone and stops the call? But something's going on with her phone at 9:04. I'll tell you that. And then at 9:04, the next one is missed call from Alex ends. 9:05, backlight on. 9:06, orientation changes to portrait. 9:07, incoming call from Alex. 9:06, 14. Keep going, Doug. And 9:06, 52. Keep going. And then at 9:07, her phone stops for good.
She's had enough.
Now, one of the things that you heard
Cat, say
in this
hi to
case
Cat.
is
She looks terrified. Hold
that
on.
orientation change was at 9:06
Let me calm her down.
that we just talked about. And Doug, if you'll go to the
There she goes. Now she's calm again.
if you go to defendants 156, please. And so these are Alex steps on his phone that were registered during this time period. And if you'll go to entry,
Find her
if
husband.
you look at entry
I'm her husband.
28, and if you'll pull that out, Doug.
Watch her paw. Watch her paw. Look at her paw. Watch what I do.
All right.
See? I try to kiss her.
So 28, this is between 9:02:18 and 9:06:47. And this is the time period that Mr. Waters in his argument said was
Stop it.
scurrying around because he took, just bring it back a little bit more,
See what
please.
she's doing? You see what she's
So
doing?
can we
She's
do it so we
pushing
can see
me
the whole
away.
line? Just, that's fine.
This is, you can't make
So
this
that,
up.
so here we see line 28 between 9:02 and 9:06.
Forever memorialized. Somebody
283
please
steps.
put that. 223.
And it went 208 meters.
She actually did it live, finally on camera.
so-
I've been trying to capture it for so long.
I want you to first, and so they take the position that this is him scurrying around. But if you do the math, which we haven't done here on this document, but 283 steps in 269 minutes, 269 seconds, turns out to be 1.05 steps per second. 0.05. 1.05 steps per second. Multiply that by 60, you get 63 steps per second. And if, ladies and gentlemen, this is a slow walk. 1 step per second. 1001, 1002, 1003, 1004, 1005. This is Alex scurrying around according to the state's case. And if you look at the distance in meters of the last, when he gets, I guess, to the house at 7:55 to 8:55, he goes 203 meters before it stops registering. And then one thing you will remember during this time period, between 9:02 and 9:06. At 9:06, Maggie's phone has an orientation change. Her phone has moved from here to here. But what her phone doesn't have, go to the second page. What her phone doesn't have are steps. And Lieutenant Dove testified that, yeah, it doesn't look like anyone that her phone is moving at 9:06, but there's no steps being registered. Alec is walking from 9:02 to 9:06. So it was fair to reason that Alec is not walking with Maggie's phone. That's the timeline data that I wanted to review with you. If you'll go to Exhibit 524. Defense Exhibit 524, please. I think it's, yeah, States 524. I'm sorry. Do you have that? So if you'll go to the slide where no, sir, not 38. Do you have the whole document or you don't? Oh, yeah, we'll drop that. Okay. Well, I mentioned earlier, and so States Exhibit 524 is all the OnStar data. You will see there that he goes by the spot at 9:08 where Maggie's phone was found, and there was testimony that he sped up after he went by there. He sped up to like from 42 to 45 and went back down to 44 miles an hour when he went by there. He's not speeding up when he goes by the area where Maggie's phone was found whenever it was tossed. And then they have, a chart or slide that talks about how long it took him to get over there and the speeds that it took. And Mr. Waters was arguing to you that compressed the timeline. The faster he gets over to Alameda, it means that he's gone longer from Moselle, and it gives him a better alibi because, as you know, he's orchestrating this alibi. And so he's driving fast over to Alameda according to their theory. And we graphed it out, and he's driving, he's passing some cars, and he is, he's a fast driver. Okay, so they say, oh, he's compressing the timeline. Compressing the timeline is what they say. Compressing the timeline. But then they say, he drives fast on the way back. Why? He's driving the same speed over there, same speed back. There's no reason to compress the timeline coming back. I mean, you'd want to be driving slow as you can to make it appear you've been gone a lot longer. I mean, he drives the same speed from Moselle to Alameda as from Alameda back to Moselle. It takes him the same amount of time. He's not compressing any timeline at all. And what's the most curious part about Maggie's phone? About Maggie's phone? What's most curious about it is Alec has her password. Alec, if he is wanting to change the timeline, when he calls her phone, he should answer her phone. When he texts her, he should reply to that text to show activity on her phone that she's still alive. If he is manufacturing a timeline by speeding, the easiest way to do it is use both phones, talk on both phones, and he did it. And this whole thing about using Maggie's phone, driving Maggie's phone, throwing Maggie's phone out it's such a stretch for them to come in and try to put her phone in his hand, and then you start thinking through, why would Alec take her phone and not Paul's phone? Let's start there. Why would Alec take her phone and not Paul's phone? That's a question I don't have an answer to. It makes no sense. It makes no sense why he would take Maggie's phone. If there's something on there, he knows her password. Put it in. See what it is. We know from all this phone data, her phone was never unlocked. And he had the keys. So if he's taking her phone to unlock or to do something with it, he didn't. And so why? Why? And these are circumstances that have to be consistent with each other and have to point conclusively to the guilt of Alec Murdaugh, beyond a reasonable doubt. And these circumstances just raise more questions, ladies and gentlemen, raise more questions that we wouldn't have to be dealing with if they had just simply secured Maggie's phone in a Faraday bag on June the 8th when they got it. We wouldn't be here.
True.
So we do know from the timeline that Alec left the property at 9:07. Were they killed before he left? I don't know the answer to that. But we do know that if he was in the house when the shots were made down at the kennel, that he would not have heard them. We had decibel testing from Mr. Sutton. Now they were angry with Mr. Sutton's angle test. They were not angry, but they challenged his conclusions on a lot of things. But they didn't touch his acoustic testing. Didn't doubt that. Haven't challenged that. And so if he's in the house and shots are ringing down at the kennel, he doesn't hear it. Now, they say that sometime after 8:44, and they peg it 8:48, 8:50, because that's when Paul last
That's a good point.
responded to a text from this friend of his, but they ignore the fact that it had to be cleaned up. And I think Buster testified that takes 10 minutes at least to get the dogs in, clean up, and et cetera. And then there's all this 8:55 stuff going on Maggie's phone. But let's take him at their theory at 8:50, after having a pleasant conversation talking about, is it a guinea or is it a chicken, and Bubba, all right, so 4 minutes later.
You covered it, Jim. Move
kill
on.
my wife and my son because I got questioned at the office today by Jeannie Secretary. Okay, that's their case. So let's run with it and see where it takes us.
Come on, Jim.
Well,
it
takes us that he leaves the property at 9:07. So from the moment, if he's got,
it's easier to see from the outside. I get it.
if it happens at 8:50, he's got 17 minutes.
I guess you have to repeat it a few
17
times.
minutes. He would have to be a magician to make all that evidence disappear.
That is true.
As you heard, under either Dr. Kinsey or Mr. Palmbach, Dr. Reamer and Dr. Kinsey, Mr. Palmbach, and Dr. Eisenstadt, either way, the shooter's covered with blood on Paul's shooting. And that's what all that testimony was about. It wasn't about trying to figure out who's got the right angles. The whole point of that is, while we ended up having to get our own experts, is to prove the shooter is covered in biological material, covered in blood, covered in everything, because of the blowback. And it wasn't until on reply that Dr. Kennedy said, oh, well, there'd be blowback under my version too. Blowback meaning blood, biological material from killing Paul. So the shooter's covered in blood. The shooter's gun is covered in blood.
Nothing but net. It's kind of amazing that there are some polls going around
there's not
that have
sufficient amount
9,200 votes that
clean all that up.
Jim's argument is not
Make all that
clear.
disappear.
800 votes that he's clear.
And then
9,200 votes that he's not clear.
call your son Buster.
That's crazy. That's insane to me.
Driving to visit
Are
your
people
mother,
watching the same trial?
who you got a call from Barbara Mixon earlier today and said your mother's agitated because your dad went back in the hospital and you might want to check on her. He goes to check on her. He calls Buster. And does he say, hey, Bus, I just blew your mom and brother up. You should see the damn mess. Are you kidding me? He calls Chris Wilson. Normal conversation. He calls his brother John Marvin, talking about his dad. And then he goes over there and he sits down with Shelley and sits on his mom's dad. And he stays there 20 minutes, not 40 minutes or 22 minutes. I don't know. The records show what time. But the fact of the matter is, he's got no blood on him. He's acting normal as every day. He is the same old Alec. Yet there he is. He just blew the people he loved the most in this world.
Kids
blew
are
him
mean.
away.
That's important. That's a very important fact.
I'll talk a little bit about the angles that Mr. Sutton did, his reverse trajectories on the
He's been going for about
shots.
2 hours.
And
still not as long as Waters.
They're having a good time joking about the size of the figure in the Pharaoh, saying, oh, it must have been a 12-year-old kid, and it's 5'2", 5'4", and let them have their fun. But that's not what the testimony was. Testimony was that the barrel of the gun has to be at that level to make the shot into the quail pen. We didn't take the measurements. SLED took the measurements. And so,
we don't have a burden here.
6'4" person get down to that level? Sure. And Mr. Sutton says that's not a natural shooting angle. Could a 6'4" person get on their knees? Sure. Shooters are in movement, and a 6'4" person is going to be moving around on their knees? I don't think so. But, the most common sense thing here is there were two shooters. Because there were two guns, and as Mr. Palmbach said, one gun is high capacity, holds 10, 20, 30 rounds. And if you're going down to execute somebody, one gun's enough. Why take another gun that only has 3 shots? And Dr. Kinsey agreed with the angle coming out of the quail pen, so that the angle puts it pretty far away from the door of the feed room where Paul's killed. But it's not our burden. It's not our burden. It's their burden.
There you go. Exactly.
Based on circumstantial evidence.
Yes.
That all the circumstances are
He's about to sit
consistent
down
with
finally,
each other
I think.
and point conclusively to the defendant's guilt beyond a reasonable doubt.
Boom.
And those facts are just not consistent.
Boom.
Those facts are just not consistent.
Boom. Boom shakalaka.
I want to say a word about
He's almost finished, I feel.
condition of Paul and
Again,
Maggie.
for the second
Vicky
time.
Paul.
He gives
Not
the
gonna show you
illusion
any photos.
that he's done. But
But I think you would agree that it was so bad. It was so bad. And Alec in the back of the car,
proof that I don't.
me in the back of that, you could see me on the camera, sitting there and talking to Agent Owen and Agent Croft. And he says, it was so bad, they did him so bad. Agent Croft misheard that and said, he said, I did him so bad. I think the evidence is everyone who's listened to it and everyone who knows what Alex was talking about around that time says they did him so bad. And Agent Owen was in the car and he doesn't say to you, oh, he actually said, I did him so bad. I think we can put that issue to rest, but that issue points to a bigger question. What would they be saying in this trial if that conversation wasn't videotaped? What would they be saying? We know Agent Croft would be saying
The my cousin Vinny
"I did him
argument.
so bad."
I shot the clerk.
And then where will we
I
be
shot
then?
the clerk.
I am
He said, I shot the
grateful
clerk.
to SLED that they
I shot the clerk.
videotaped that. So that you'll hear it if you have any questions. I don't think you should, but they did him so bad. That is for sure. Another thing that we're going to clear up right now is Alec's concern for Buster. You heard that, and you heard that in Mr. Waters' closing. That in the statements that Alec made on the roadside shooting in Labor Day weekend, where he tried to arrange a assisted suicide, that he told officers that there's no danger to Buster. Of course, there was no danger to Buster because of that roadside shooting, because he knew who shot him, Curtis Eddie Smith. He knew he was trying to get himself killed. But from that, there's going, the reason he knows there's nothing to worry about Buster is because he knows he did it. That's what was just argued yesterday.
Yes, it is.
Well, Deputy McDowell in
This happened
a
at the
body
Capitol.
cam video that's in evidence captured
No video.
Alec speaking to Buddy Hill about his concern about Buster's safety. And will you play that now, Doug? It's in evidence. I don't have the exhibit number.
Can y'all get a police officer with my oldest son in Columbia? Can you call back this? No, I haven't told me yet.
Can you play that again? Because I think the.
Randy, what about Buster? You gotta get, Bud, can y'all get a police officer with my oldest son in Columbia? Can you call back this? No, I haven't told me yet.
Did you hear that? Can y'all get a police officer for my oldest son in Columbia? What about Buster? What about Buster? Can y'all get a police officer for my oldest son? Buddy, can y'all get a police officer for my oldest son in Columbia? That's
That's
Buddy
a
Hill,
very
sheriff.
good point.
And they won't come in
Protect
here
my
and tell you
son.
he wasn't concerned for Buster's safety.
Yes. Wow, that's huge.
Once again, I'm grateful Colleton County Sheriff's Department had body cams. 'Cause now you know.
He's
You
grateful
know Alec
for
was
the
concerned.
body cams.
You know
Oh.
Alec asked for a police officer for his son in Columbia, Buster. Now I'm almost done, I promise. But I do want to talk about Alec's misstatements about time. Alex told Deputy Owen during the interviews that, well, first, Alec's statements about time are not lies. They were just misstatements. And even, like I said, Deputy Owen says people make mistakes about all the, Agent Owen, they make mistakes about time all the time. And they do. Now, Mr. Waters is critical because Alec was wrong every time he gave a time estimate. Turns out, I think Mr. Waters is probably right about that. Whether the time period is inconsequential or consequential, he's wrong about it. And and we had brought in, Alec had told deputies in an interview that he got home at 5 o'clock, and that's not true. That he went to work that day at 8:30, that's not true. And so he is just wrong on times. But what was consistent whenever he had an interview, he said, you get the records, and it will show what time did this, what time I did that. It will all be in the records. And guess what? They are in the records. And when the records show that his time estimate was wrong, they jump up and down. The statement to Deputy Green, he says, I've gone to my mom's for about an hour and a half, and I last saw them 45 minutes. Now that I don't know. I frankly don't know if that's wrong or not. I mean, he's talking to Deputy Green about 10:30. Hour and a half from 10:30 is 9 o'clock. I mean, he left. He left at 9. He left at 9:07. But that's that. The question about what he did when he got down to the scene, and he said he ran up to Paul and Maggie, and he left his phone, and then went back to get his phone.
That would be epic Irish eyes.
And then he's talking to the 911 operator, and you can hear it, and he says, I've been up to it now. It's bad. He doesn't remember the sequencing, and I don't think anyone should hold that against him. Mr. Waters gets up here and says Maggie was running to her baby. Alec was running to his baby.
I don't know, DeLuna. Let's ask Chad.
And can you imagine what he saw? And is it evidence of guilt that he doesn't remember what the sequencing was in that moment? Is that evidence? Is that evidence of guilt? Or is that evidence of trauma? This is a guy that then went to get a 12-gauge shotgun, and he put 16-gauge shells in it. He knows the difference, but he didn't know that night. And I'm not quite understanding what the state makes of this. Did he not go up to their bodies? Because the forensic evidence sure speaks to the contrary. What we have is Maggie's DNA all over his T-shirt. And you heard that from Agent Zapata. We have Paul's DNA on his T-shirt. How did he get Paul and Maggie's DNA on his T-shirt if he didn't touch them? If he brutally murdered them, hosed off down there next to their dead bodies, got in the golf cart butt naked, drove to the house, changed clothes, went over to his mom's, goes down, calls 911, then searches for Whaley restaurant menu and checking emails, waiting for the police to show up. How does he get their DNA on his body? Because it's on there. The forensic lab tells you that. Because he went up to them and touched them. And then there's a spot of blood on the Suburban steering wheel that was Maggie's. And we know that the Suburban was never down at the kennel, thanks to the OnStar information. I'm not sure that was an accepted fact until OnStar sent their stuff in, but the Suburban never went down to the kennel until after he returned back from Moselle. So we know the blood got on the steering wheel after he checked Maggie like he said he did on the 911 call. And then there's a spot of blood on the gun that he went to get. And then there's GSR. There's GSR. There's 3 particles of GSR on his shirt, 3 particles of GSR on his shorts, and 1 on his finger. And the SLED agent testified that's consistent with transferred GSR when you pick up a gun. So, but really, we're back to the lie. We are back to the lie. Because that's all they have in this case, is that Alec lied to them when he last saw them. And he shouldn't have. He shouldn't have. And he said, what a tangled web we weave once we start to deceive. And once he lied the first time, he was stuck with the lie, and he continued to lie. And he shouldn't have. He shouldn't have. And he told you, what was going through his mind probably wasn't rational, but he was in the throes of an addiction, and he just found his wife and son murdered. And he's being interviewed. He'd been swiped for GSR, and he does think David Owen is the guy that investigated his friend. But he was wrong. He told you. Turns out he was wrong. But I thought that's who it was that night. And he was under investigation. He was being accused of obstructing the boating accident investigation. And he's under investigation by SLED for that. And he had all these skeletons in his closet. And he was wanting to get them away from him and looking for the real killer. The state in this case has gone to lengths trying to, through a sleight of hand, convince you of this and show you that, and without convince you of guilt, without showing evidence of guilt, convince you that he murdered his wife and son because of his financial misdeeds were going to come out, which is about the most illogical thing imaginable, and there's no evidence of that. And then the state brings all these shotguns in here, and I'm not going to pick every one of them up, but the forensic evidence on these shotguns is they can't be excluded. Well, okay. They can't be included either, so you know nothing more about these shotguns than you would have the day you showed up for jury selection, because there's nothing to know about them. Can't exclude them, can't include them according to them, but we do know there's no blood, guts, brains on any of the guns that would have been there from the shooting under everybody's interpretation of how Paul was murdered. They want you to think that because you own guns, that you should be viewed differently. I don't know what else to make of that. When this trial began with opening statements on January 25th, Mr. Harpootlian asked why. Why would Alex execute his wife and son in cold blood? And here we are, 6 weeks later. And you've heard weeks testimony about Alex's financial crimes, drug addiction, and lies. But after all that, the state has failed to provide a satisfactory answer to this question. Why? The state cannot provide an answer to this question because the answer is he would not, under any circumstances, murder those that meant the most to him. Your oath requires that you hold the state to the exacting standard of proof that the state must prove the defendant's guilt beyond a reasonable doubt. And when they rely solely on circumstantial evidence, these circumstances must be consistent with each other.
He's
when
almost
taken
done.
together, point conclusively to the guilt of the accused beyond a reasonable doubt. And if they merely portray the behavior of the defendant as suspicious, you must find him not guilty. The state's evidence fails to meet these requirements. Circumstances don't point conclusively to Alex's guilt. Far from it.
Keep using that word.
Mr. Waters wants you to believe that Alex slaughtered Maggie and Paul on June 7th and repeatedly lied and changed the story to fit the timeline and evidence. As it turns out, in fact, the state is the one that's been manipulating evidence to fit their theories of guilt, which changed over time from the date of these murders until yesterday. In the absence of forensic science, a reliable investigation, the guns, blood spatter, the time and opportunity to have committed these murders, you're instead left to make inferences about all sorts of interactions and behaviors. Prosecution wants you to view the evidence through the diabolical monster lens that they have tried to paint, but the law requires you to view it through the lens of innocence.
Yes.
Where none of these things, individually or taken together, prove conclusively to Alex's guilt beyond a reasonable doubt. Up until now, you've not been able to say a single word. Can't imagine how frustrating that must be.
Yeah.
But soon you will have the most powerful voice in this courtroom.
Yes.
With your words, you can let everyone know that in a court of law, only evidence and the burden of proof matters, not gossip, innuendo, opinions, and most of all, not theories layered on top of speculation.
Yes.
With your words, you can let the state know that they don't get to obtain an indictment by misleading a grand jury and then bring you before your case built on theories, speculation. There are two words that justice demands in this case, and those two words are not guilty.
Wow.
The oath you've taken in this case is to follow the law, to follow the Constitution, and to hold the government to the burden of proof. And it requires a verdict of not guilty. On behalf of Alex, on behalf of Buster, on behalf of Maggie, and on behalf of my friend Paul,
damn,
I respectfully request that you do not compound a family tragedy with another. Thank you.
Wow. That was a powerful ending.
Ladies and gentlemen, we'll send you to the jury room for a break. Please do not discuss the case.
That was genuine emotion at the end. Holy crap. I was not ready for that. That I was not ready for. He felt it. He felt it, and he was not afraid to show it. State has a rebuttal now. Waters is going to be up there for probably another day and a half. I'm just kidding.
Everyone will be seated. So, Mr. Meadows, are you closing on behalf of the state?
Yes, sir.
Do you have an
Oh, so they
estimated
get a
length of
chance to
time that
switch?
you might go?
Oh, fuck off, Judge.
No more than 40 minutes.
40 minutes. So,
You ready to go?
If you give me, I just need to go to the bathroom.
Sure.
too much coffee.
All right, we'll take a 5-minute recess.
That's fair. That's fair. Wow. Okay, so the jury's going to go deliberate before lunch? Or like go to lunch and then begin deliberations immediately after lunch? Excuse me. Wow. Wow, you guys, I can't believe we're here. It's almost over. You guys, we are here. We've made it. Thank you. Why not stream in 1080p instead of 720? I thought I am streaming in 1080. Am I not? I don't know. I don't know settings. Camera. It is 720. Well, I can't change it midstream, but I think the reason I changed it is because when I travel, 1080 lags. 1080 usually lags because like connections are terrible. But here I could stream in 1080. 40 minutes. You know, you guys, I'm not going to lie. It feels to me, at least, like a repeat, in a way, of the Johnny Depp trial. I always find myself in a minority. Like, mainstream media. Remember, mainstream media during the Johnny Depp trial had an agenda. Me Too, man abusing woman, Amber victim, poor Amber, protect victims, Johnny's an abuser, Johnny's a wife beater. And then here comes DUI guy and he goes, Johnny's going to win. I saw the jury. I looked at how they reacted. Johnny's going to win. Like, I listened to the evidence. Johnny's going to win. And mainstream media refused to report it. I even did an interview on a couple stations and they did not air my interview because I was talking days before the verdict I was saying Johnny's going to win. And they didn't want to air it for obvious reasons because it clashed with their agenda. Now here, we have another situation of a very unlikable character. I'm not saying I like him. I never said I do. I never said that I don't think he's involved. I never said. But of course, you say one thing that people disagree with, like, I think he's going to walk or going to have a hung jury, and people explode. Like, come on. But you have to look at the case in the microcosm of the courtroom. Jurors who have not been exposed to Netflix, jurors who have not been exposed to the luxury that we have. You have to watch and listen to the evidence within the confines of the four walls of the courtroom. Look. Where did I go? There we go. Look at what happened. Look at what happened to I forgot what I was going to say. I was starting to say something and now I forgot what it was. I was going to say, look at what happened to... What was I going to say? I forgot now. Anyway, and it's fine. It's okay. It's okay to I'm not afraid of going against the grain because I will never apologize for my opinion. I will never apologize in what I believe in. I will never apologize for speaking my truth ever. Kind of like Johnny in a way. Remember his? I'm just here to speak my truth, and I will never be apologetic about speaking my truth. I'm the same way. Do I think Alex is a piece of shit, lying, stealing, probably going to get convicted and serve years in prison over the financial crimes? 100%. Do I think he's in some way, shape, or form involved in or is aware of the murders and who did it with Maggie and Paul? Yes. Do I think the state has proven their case beyond a reasonable doubt? I have to take my bias out of the equation. I have to take my personal feelings, my emotions about the case out of the equation and look at it. Remember the A and B, the box and the ball analogy earlier today? If you missed it, it's again, somebody said what it is and I forgot it again. It's kind of like a bias, personal bias type, not confirmation bias. You have person A, person B, person A is here, person B is here. Person B walks out of frame, out of the room. Person A opens the box, puts a ball in there, closes the box. Person B comes back. And the question is, does person B know that there is a ball in the box, or is the box empty? And if the person answers, oh, of course, person B knows. Like, I know. Person A knows. Obviously, person B knows, but person B wasn't there. They have no information that hasn't been relayed to them. They did not witness it. How can person B know? And that's the question. And a lot of people who are saying, oh, obviously he's guilty, are person B's types who are like, well, obviously you saw the ball go in, therefore he's guilty because I saw the Netflix documentary. I know everything about the family. I know. State of mind theory. Thank you. I think that's what it is. That's accurate. And that's exactly what a lot of people right now watching other channels are saying. And that's why we have such a small group here. And I actually like it that way, at least for now. Eventually we will grow. And there will be a trial where I'm going to be the majority opinion. It's just somehow, like, for example, the Daryl Brooks. Oh, come on. Everybody was on like, he's guilty of sin. That one I didn't even stream. I didn't even talk about. I just did like sentencing or something. I did one live on the Daryl Brooks because it was atrocious. It was going to be a slam dunk, guilty on all charges. I knew that from day one. So there I was in the majority opinion. The school shooter in Florida, I knew that was going to be a guilty, life without parole. That one was not. That was an easy one. Johnny Depp was an easy one for the public, hard one for the mainstream media to digest. So that one I was in the minority on the mainstream media side, but I was in the majority on the public side. Here, I am both. Like, this is the first time in recorded history, I guess, of my channel being this large, where I'm both in the minority opinion of mainstream media and I'm in the minority opinion of the public. Again, for various reasons. And I'm okay with that. I don't care if I would be the only one on the planet. If I truly believe in it, I will stand my ground and I will hold my own. You know what I mean? I will put my foot down. I will not put my foot in my mouth and apologize, because my opinion is based on experience, data, trials of my own, and the knowledge that I have. You know what I'm saying? So, Rittenhouse, I didn't follow Rittenhouse, believe it or not. During Rittenhouse, I was so buried in my DUI guy stuff. How did you find me during Rittenhouse? I wasn't doing anything. Well, maybe like my DUI videos popped up, probably, but I was not part of that crew during Rittenhouse. Rittenhouse was October, November of 2021, and I can tell you exactly where I was October, November 2021. October, November 2021, I was taking a long hiatus from YouTube. I believe that's when I took my break, because that's when like Omicron started. I mean, October I might have still streamed. November I just paused. I did like my own stuff. I traveled. I relaxed. And that's when Omicron started going wild, January, February. So business was very, very slow, January, February of 2021. I was bored, but I didn't feel like streaming. And I remember the Rittenhouse era, but I didn't watch it. I was not interested. I was not interested in it. So I kind of missed the boat on that one. And then that's when people started telling me, like, you need to talk to Nick. You need to go on Nick's channel. And I was like, who the fuck is Nick? That was back then. That was back then. And then finally in March, I reached out. And then April, the trial started, and that's when I met Nick. Kelly says, I think you mean Jim, he is clearly showing reasonable doubt in the state evidence and conclusions. So most people are saying I found you in Depp v. Heard. That's probably where most people, I mean, half of my channel, approximately half of my channel is Johnny Depp folks, people who came during the Johnny Depp trial. So that's not surprising at all. Love your expertise, opinion, and stream without chatted. Thanks, Just Joe. Some people found me through Ickmel. Ickmel is cool. I like Ickmel. He's also a don't fuck around, don't find out type of guy. Eglook found me through my DUI cases a few years ago. So yeah, I've been uploading my DUI trials and hearings. My first one went up October of 2018, but my channel didn't really take off its preliminary stages until February of 2019. And I know some people had their channels for way longer than I have and still have not popped off until very recently. And that's okay. Everyone is on their own track. Like, it's not a competition. I mean, subconsciously it kind of is. I'm not going to lie. Subconsciously, we do, like, do I compete against my fellow streamers? Kind of, a little bit, but not really. You know what I mean?
Jury guy there.
It's all a win-win.
Can they bring the jury?
Thank you, Kimber. Oh, he said bring the jury finally. There we go. I found you during... Hey, Mandu! Mandu got more strikes deleted. We're now down to like under a dozen, by the way. Mandu's winning against the evil government. He's slapping them around. Just like whack, 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 whack. Louisiana Parole Board. Oh yeah, they're down. They're down. They're down and not the clown. Legal Bites did me a favor. I was pissed at her and feel bad for you. Thanks, Ellen. Oh, that's hilarious. Saw you and Runkle and fell in love. Aw. I found you because of your DUI cases. Then we fell in love. It was like a fairy tale. Ain't that the truth, Tracy? I think he's ready for it to be over.
Thank you. Ladies and gentlemen, the state gets an opportunity to do a rebuttal. Mr. Metters.
And he's going to close it out. 120 is our benchmark. 120 for the close of all the evidence and closings. Then we're going to come back from lunch. The judge is going to read instructions.
Good afternoon.
Oh, that's nice. I didn't know that, Sinead. Thank you for letting me know.
On behalf of Attorney General Alan Wilson,
Standard stuff, Bob.
Deputy Don Lincoln, Deputy Attorney General Creighton Waters, and this entire team, and I want to name them all, but
because Waters is annoying and we can't stand his voice, so they're switching
thank
prosecutors.
you for the attention you've given this case. Being a juror is not an easy job. I'm not a jury watcher. I don't sit and stare at jurors, but goodness knows we've been here 6 weeks. I have looked over occasionally. Not to pry, but I've noticed when I have looked, you've all paying attention. So
is he hating on James being a jury watcher?
Thank you. And I'm not going to be that.
Stop thanking them, for fuck's sake.
Your clerk, Ms. Hill, has done an outstanding job bringing the world to Colleton County, bringing the world right here with the hospitality or grace.
He's almost completely free.
Making everything as convenient as she can.
Thanks to our efforts.
But the one thing she didn't do and couldn't do is give you a booklet on how to be a juror.
Oh my God. Come on.
5.5 weeks ago when y'all got here.
Don't
6 weeks ago.
doing the same thing as
You
Jim.
didn't have that pamphlet
Thanking
for
them and what it means to be a
because they don't
jury.
exist. There's not a book on how to be a juror.
No, there isn't. Just
But
listen.
You have been preparing for this moment.
Wednesday's looking. Oh, I didn't see the blue top.
This courtroom
Wednesday is very blue today.
to decide this case your entire life. And it's called life. It's called living.
Right.
It's called experiences.
Okay.
It's called
Yes.
interacting with your spouse,
Okay.
your children,
Oh, fuck.
your neighbors, your coworkers, your good experiences, your bad experiences, evaluating people and deciding what's credible, what's believable. It's true in every case I've ever tried in my 34 years of doing nothing but murder cases. Credibility, believability. And I agree with Mr. Griffin. When I looked at this case the first time, I said to myself, this is a CSC case. Now, in our world, that means criminal sexual conduct. It's not a criminal sexual conduct case.
The fuck?
This is a common sense case.
Oh God!
And
lowering
you didn't
the burden.
leave that common sense
No,
with you when you
he's
came here
lowering the
6 weeks ago.
burden. It's beyond a reasonable
It's
doubt.
with you now. It's been with you during the 6 weeks here, and you're going to take it back into the jury room.
He's trying to lower the burden. Common sense is not the standard. Now you don't leave
I've
it at
been
the
listening
door.
yesterday
But that's
and
not a
today,
common
and
sense
we all
case.
have
Oh, you slimy
about
motherfucker!
law enforcement.
I would have objected.
didn't
Well,
do
it's
this,
hard,
law enforcement
but they're going to
didn't
read
do
the
that.
instructions.
They
It's
actually
not about.
said they fabricated evidence.
Oh, they can
Putting
object, but
law
it's
enforcement on trial.
it's tough. It's a tough call.
I once called Mr. Harpootlian in a trial an automatic smoke screen machine. I think what the defense is doing in this case is more like an eclipse. You remember that eclipse on August 17th of 2017, where it kind of got dark for a little bit, and the birds started chirping, and you felt like it was dark, and then it cleared. The eclipse went over, and the light came back. That's what the defense is doing, taking you away from the facts,
Yes,
the credibility.
you can.
And saying, wait a minute, there's a eclipse here, there's a smoke screen here. Look at that. And somebody said the word offensive.
Really?
I find it
Smoke screen?
offensive that a family with a great-grandfather, a grandfather, a father, Sylvester Randolph Murdaugh, who was good to me when I was a young man, prosecutor. He knew I wanted to do this as my job. He knew I cared about this job. This is the best job in the world. I tried to be solicitor 3 times as long. It doesn't get any better than this job. And I find it offensive that the defense, through the defendant, who was also a part-time solicitor, is claiming that law enforcement didn't do their job. Listen to me, please. Didn't do their job
What the hell was that?
while he is withholding and
you just say, "Listen
obstructing
to me,
justice by not saying, I was down at the kennels. I was down at the kennels. I was down at the kennels. And he's going to blame everybody else. Is that offensive? Is that offensive?
Listen to me, please.
Mr.
Who
Griffin
says
said a
that?
minute ago, can you imagine coming up on the scene and seeing, can you imagine not telling law enforcement, lying that I was down there and I saw him? I was right there. Why wouldn't you tell them that? Maybe get some more evidence. Did you hear somebody? No, I wasn't even down there. Credibility, believability.
Why do you say that, Rick?
That really does sum it up. You remember 6 weeks ago today when Mr. Waters' fantastic opening and talked about direct evidence. And direct evidence is something you know it when you see it. It's evidence you gather with one of your senses. You hear it, you feel it, you smell it, you touch it, and you come in here and tell witnesses, hey, this is what I heard, what I felt.
He's
What I
pacing.
smelled, what I touched. But do you remember when he was describing circumstantial evidence? There was a storm that day coming. Part of his theme, the storm just happened to come.
Jim was very
And you
stoic,
could hear it coming.
calm, cool, collected.
And then during part of his opening, you remember it started raining? You could hear it. You could feel it. It's almost like circumstantial evidence morphed into direct evidence. And that's what happened in this case.
Circumstantial
Evidence
morphed
became
into direct
Mm-hmm.
evidence?
Yes.
That's a stretch.
This case
bud.
is about two things.
Circumstantial is circumstantial,
It's about
direct is direct.
being real, and choices. My mama gave me a book when I was a little boy about the Velveteen Rabbit.
Waters is sitting right
Going off
there
to college,
with the purple tie, gray
dealing
top.
with people and learning about people and tough times in life. Go get the Velveteen Rabbit and read it if you haven't read it. But she just put in the front of that book, and I love my mama. Always be real. Always be real. And this case is about that defendant never being real. And choices, which I'll get to at my end. Ladies and gentlemen, They blame everybody.
Is he
but
cold?
Alex.
What was that?
Everybody but Alex.
Let's go back to the first.
I'm not gonna bring it out. But this back here, the press release was sent out.
Okay, rebuttal is not
no
you get a
danger.
chance to restate all your
There's no
arguments.
danger.
You rebut what the defense has just said. What are you doing?
What did Alex not do?
And I would
They showed
object.
the tape there. He's asking the sheriff, I think.
Here, I
call
would
Buster.
have definitely object.
First time he tried to call
He's just
Buster,
doing a
that was-
second
took
closing.
the sheriff a while
That's
to get
not
out
what
there.
rebuttal
Remember the
is,
first time he
bud.
called Buster? It's about 40 minutes. Well, actually, he texted him, didn't even call him. Wasn't his first thought. Wasn't the thing after he did 911. It was later. Perhaps even when some of his friends had gotten there. Oh, don't call. No, right off the bat, if this happened, call my son.
They're asleep.
Call him. Buster, stay where you are. You with your girlfriend? Up there in North Charlotte? Go. We got some people after us. That's what's real. Don't you? You go to the police station right there. And what
Well,
else do you
he
do?
said that. He's get a sheriff
talk
out there to
about me,
protect
are
my
you?
son, you dumbass.
What are you doing? Y'all, I just left my mama. She's with Shelly. Get somebody over there. Get them over there. If these people are out here to kill us, get them over there. Go, please, take them right now. They're by themselves. I can't do that.
Exactly,
That's why I
Golden.
took the
That's what I'm
guns.
getting at.
I can't tell them that. That's what's real. And he brings up the boat case right away. Right away. A year and a half previous. He's coming up for a hearing. Nobody's thinking about that boat case except Alice. And right then, he's using it to throw off. Here's your first suspect. Does that make any sense? They have a hearing coming up. They're going to look to resolve this thing. Nobody's out there thinking about a boat case on a Monday night. Anybody upset about that? Think about all the facts that would have to happen. They'd have to know both, as Mr. Waters said, somebody in the boat case would have to know that they're both there. They'd have to know they were there. They'd have to know that Alex is just wasn't there. Oh, no, wait a minute. That he was there, but just for a little bit and went back up to the house. And they'd have to come. You know what? We don't need a gun. There'll be guns there for us to use. Yes, and that's great circumstantial and direct evidence. I'll get to that. They'll have guns there for us. They'll have guns there for us. We can use them. Does that make any sense whatsoever? Let's talk about murder. Murder is the intentional, malicious killing of another living, breathing human being with malice
Excuse me,
aforethought.
God.
What's malice? Y'all know what malice is? It's the name malice. It's the evil wickedness one person shows to another. You know how long it's got to exist? Just like that. At the pulling of a trigger. 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 Malice aforethought. It can be expressed. Rarely happens. I'm going to kill you. Or it can be inferred. It can be inferred with the use of one gun. There's no claim of self-defense here. They're claiming they weren't there. It can be inferred two guns. Malice aforethought. And we don't have premeditation in this state. We don't have to prove premeditation. We don't have to prove motive.
No, I'm allergic
I
to
think it's been
bullshit.
proven.
That's what I'm allergic to is
His
bullshit.
world was collapsing. Mr. Griffin goes, does that make sense? Did in his mind. His world's collapsing. His world's coming down. This was the only way he could save. It's the only way. It's the only way he could save Alex.
I was about to say, Ellen, what are you on about? Make him start deliberating?
But if you don't, if that motive, well, I don't know, is that enough? Don't know. We don't have to prove motive. We're certainly there. That's one explanation. But if he's down there and he's angry, just don't sound like a real jovial there. Bubba! Don't let me forget about Bubba. Bubba!
Oh.
Come here. Maybe you just got angry. Maybe you got angry at Paul. Maybe you got angry, you started all this with the boat case. And maybe he just lost it. Maybe he just lost it. Maybe it looked like a suicide. And then Maggie came and he had to shoot her. I don't know. Only one person knows. And that's why we've got the motive. That's why we say he did it. But we don't even have to have motive. Just angry. He did it. Nobody else could have done it. Nobody else did do it. I'm going to get to that. And that's how we prove beyond, I want to say all doubt. But our burden's only reasonable now. But losing it, and then you get the question, well, have you proven malice? Well, yes, sir. Yes, ma'am. 2 shots to Paul. Malicious. First one didn't do it. The second one finishes him off. 5 shots to Maggie. Not an accident. 1 shot, 2 shots, 3 shots, 4 shots, maybe 5 shots, depending on whether this one's running through. That's malicious. So if you find he killed him and you get the malice, I don't think there's any dispute in here about that it's a malicious killing. But I've got to go over that with you. Malice of forethought. And then the burden on us in this case, as in every case that's tried in this wonderful land of ours. That's why this is so great. I agree with it. Is beyond a reasonable doubt. I'm going to borrow one of these waters if that's okay. It's not beyond all doubt. If that's the case, this courtroom wouldn't have been here as historically as long as it had. The law doesn't describe that. And listen to his honor. And I'm not playing up to him. He is the best. He's the law. Listen to him when he reads the law. Beyond a reasonable doubt. It's not beyond all doubt. We can't do that. It's beyond a doubt that would make reasonable folks hesitate to act. I was trying to retrial a case years ago and reading reasonable doubt from this ex-solicitor, Solicitor Wilson, I'll give him credit, describing reasonable doubt. And he said, sometimes, questions are just questions. You can't answer every question, and the law doesn't require it. If after hearing all the evidence, or if you're firmly convinced of the defendant's guilt, you must find him guilty. If, on the other hand, you're not firmly convinced, then you must find him not guilty. He goes to see his mother. He goes, and you see the OnStar taking him up to the side, over near the smokehouse. We submit to you that's when he went to hide the guns. It's common sense. We submit to you that there's a driveway there. Nice pavement. You can go look at it. Nice paved driveway. Submit to you when he came, it was 9:30 at night. Testimony is very unusual, very rare. Kind of funny, Ms. Nixon, who testified earlier, we talked to her recently, didn't remember any of the conversation, but said she called and said he told him your dad's not doing well. Well, he didn't go there that afternoon when he got the phone call, when his office is right near there. Go see him then. He didn't do that. He waited to 9:30. I don't know if anybody's got any folks that are suffering from Alzheimer's, but when they're asleep, they're tired. He wasn't going to love his mama. He wasn't going to be with her. He was going there because he loves Alex. He loves Alex. And he was going there to create his alibi. At 9:30 at night, use your common sense. And you remember, she said he called.
Common sense. I swear to God.
What happened after that?
Trying to lower the
About 5
burden.
minutes or so.
It's not beyond a reasonable doubt. It's common sense.
At first I was thinking,
You can't do that.
that's when he was
Prosecutors
going
do it
behind
to
the
me all the
gun.
time.
And the time frame over there is so important, not for how long he was from left to come back, but it's how long he was in there with Shelley. How long he was in there. Because that's when he was hiding the guns. The guns are missing now. He was hiding the guns. And what did Shelley say? He didn't stay long.
At the end of his closing, if I was the defense in front of the jury,
He
I would
left.
stand up and say, Your Honor, I would just like to remind the jury that the standard is beyond a reasonable doubt, not just common sense. Literally
Later
in
that
front
week,
of them. No, this is it. This is the last person speaking in this trial.
later that week,
This is it. After
I
this,
don't know which one in my mind right now. I'm just trying.
instructions from the judge.
But one of the days she came by, I
deliberations,
think
and
it was
that's
after the visitation. He says, Shelley, you remember I was here about 35 or 40 minutes. Y'all remember looking at her up here on the stand? And she got visibly upset. I said, what's wrong? Ask her, what's wrong? What's wrong there? Was he there 35, 40 minutes? No, sir. Why are you upset? It's a good family. You think she knew right then? He's coming back to say, hey, I was here 35, 40 minutes now visiting my mom. Shelley said, no. No, you weren't. So upset that she calls her brother.
I don't think they're going to
Police
deliberate
officer
over the
Yancey.
weekend. No.
You think she knew right then? And that's real. That's real. Shelley's
Jurors
real.
only deliberate on business days. They get weekends off.
You saw her body language is so important, right?
Oh, body language. When I don't have a case,
Talking about the defendant. All our body language. You see Shelley's.
when I don't have when I don't have a case,
And then one day that week,
when I don't have facts, argue body language. Sorry, Zinni.
never before, never, ever before, at 6:30 in the morning,
The judge said they're deliberating over the
doesn't
weekend.
call. He didn't need a timeline to create for that one because it didn't want a timeline, didn't want a record of that.
Are you serious?
He comes to see Shelley. You ever been over that time before? No. What
the fuck is this backwards bullshit?
It was some blue vinyl
I
like.
quit. I quit.
Remember I tried to, what? It's like this. What did you think it was? Tarp. I don't know what it was. And they try to gloss over it now. Tell you one thing they didn't gloss over. You remember when she was on the stand? I said, well, have you talked to them? Have you talked to their investigators? Yes, sir. Did they record you?
Just kidding.
Yes, sir. Can I have a copy of it? And then we came back and we got a copy.
What the
And
fuck?
two investigators, they were worried about it then, went down and talked to her. And talked to her about her times and ran times by her and asked her if she'd ever seen anybody in this blue coat. Have you ever worn? They were worried about it. Because that's great circumstantial evidence. It kind of morphs into direct evidence. I saw him coming at 6:30. You even heard, they asked one of the experts, well, could it stay on there for 5 years, 10 years? Sure. This was days after the murder. Shelley sees him come in with a blue something. Well, where'd he go? He went upstairs. Why? I don't know. Did you see it later? Thought I saw it on the chair. Can't answer every question. Miss Mixon sure didn't see it the next day. Now, I asked her, was there another tarp there? Well, there was a blue and silver tarp. Picture of it, too. That wasn't it, though. This was all blue. And the only other blue tarp that's in evidence, and I let it go in just so I could argue this right now, is the tarp that they showed Shelley that they got from Kmart.
Stop yelling.
That's not real. This tarp, no. Looked like that.
Welcome, Rachel.
I don't know what it was. He had it bundled up. Well, lo and behold, when we find out this information, and they try to make a big deal about it, I think it makes it more pure. She's at a traffic stop or an accident or something. She tells the police officer,
15
got
minutes.
about this. You can't make it up. So they get a search warrant and they go search. And lo and behold, crumbling in the closet is a blue vinyl something where you pull it out and it's this jacket. You see how evidence of a fact and another fact that leads to the fact in question.
Tylenol income. I'm gonna need it for this weekend. I'm not getting a break. We're gonna do verdict watch Friday, Saturday,
I don't
Sunday.
have to say why.
Oh
I think he did it to protect the one he loved the most,
well, shit. Then we're gonna have a verdict like
the one he
Sunday.
really loved the most, so he could keep his lifestyle and not be embarrassed financially. And he wanted to keep going and loving Alex. I don't know why he kept that jacket. Maybe it was Solicitor Murdaugh's jacket. Certainly consistent. It might have been in that truck. I think one of the family said he kept a lot of stuff in that truck. Might have been out in that something else. I don't know.
Why?
But he brought it back in there and hid it. 6:30, days after the killing. And what's inside? Wait a minute. What's on the outside? There's a little bit gunshot here and there. What's on the inside? The inside. Minimum 38 particles. It got so much that Megan Fletcher finally said, you know, we get gunshot residue. Inside the rain jacket, the blue tight garment that Shelley said, I saw him carrying something like that. He got rid of the guns, and he's hiding it there for some reason. Thank goodness he did. Because thank goodness for Shelley for bringing that in. That's what he disposed of the guns with. And he went out of town. She said he left, and before that, she thought he'd left. He came back, and he had moved to ATV, and then he said he was in another truck, and he came back, and then he left. He's disposing and hiding whatever he was doing with that evidence. Only one person knows. But that blue rain jacket, that tarp, is incredible circumstantial evidence that we ask you to consider when you go back there. Is Shelley making that up? How could she make that up? How could she know there'd be a blue tarp in that closet? Same closet, same stairs he went upstairs. We went upstairs. I can't explain the tarp on the chair. Don't have to. We can't answer every question. That doesn't mean it's not reasonable doubt. She saw a blue tarp light. It was in that closet. It's got gunshot residue on it a few days after. Maggie and Paul were brutally murdered. And that's consistent with every reasonable hypothesis.
Somebody clip that.
And you know,
I'm gonna make that my locals intro video. Somebody clip that and send that to me. I'll make that my locals intro video.
The night when they were talking.
I need your help, chat.
You're getting married, aren't you? You remember her saying that? You getting married? If you need any money or help with it, let me know. It's incredible time.
The
job,
news
don't you
part,
work for
when I
school?
start making the news and
You know, I got friends down there.
that part, Rose. It's only like 15, 20 seconds from start to finish. So when I zoom in to my face,
sequence of facts
just a few minutes ago,
that lead to the conclusion he's trying to get her.
and then send me the link.
I was there longer. I wasn't outside longer. Blanca.
Thanks, Rose.
Blanca loved Maggie. I didn't realize that really until I talked to her just a few times. I met her years ago in a federal prison.
I don't know how that makes me a Taurus. But
Remember when I saw her? Remember her name. But you know, even when Blanca was quit working for him for a while, and you remember she had health problems and said she saw Maggie on the road somewhere, and they kind of pulled off. They just talked, just called up. Blanca cared about Maggie. Knew her so well, she knew what she wore to bed and what she didn't wear to bed. And that kind of bothered her about the clothes that were laid out. Some undergarments, which she knew she didn't wear. But Blanca's texting Maggie's texting Blanca on June 7th. And in one of his statements, and I'm going to get to those, he said, you know, Maggie wanted to come. She wanted to come. Well, no, sir. No, she didn't. She was having working on her other stuff. He tries to say in here today, look, she was in Charleston. She was going back to other stuff. Remember the text to Blanca, well, I left the workers there, but I guess it'll be okay. He had said, come. I want you to come. She didn't want to come. We also know that from her sister Mary, who had a little regret in here today. Didn't hear much regret from over there. But you know who regretted? Who was real? It was Mary. I encouraged her to go. She didn't want to go. They got close. You know, it's like siblings. Jane, Marshall, James. I had to get my siblings on the record. We love each other. But she had that relationship, you know, we weren't close. Then we got closer as the kids got older. We were close. We talked. One of her best friends. And she told her, why aren't you going over there? She regretted that. But she killed her about it. But that refutes his lie. Oh, she wanted to come. She wanted to come. No, sir, you wanted her to come. Why? Had he already planned it out? Was his world collapsing? He didn't have to. We don't have to prove he did. But he got her there. She wasn't planning on being there. Blanca's got the food ready. She leaves. Let's stay on the real train for a minute. She goes home. She gets a call sometime that night. And this is real. What does she do when she hears? She drops the phone. Remember that? Her husband had to get on the phone. She dropped the phone, real emotion, because she cared about Maggie. That's real. And you remember she described that day when she left Alex leaving, and I put his shirt up, got his collar, helped him with his, I assume it was a blue jacket, I don't know. Described the shirt. Remember, just kind of tucked it in. And now on Alex's second interview, when he's confronted by David Owens. And they actually showed him the video of the tree. They showed him that. Did you change? When I saw you that night, you were wearing shorts. When did you change? And you remember what Alex said on that interview? When is that? When is that time was that? And then he told him the time, 7:44, whatever it was. He said, well, I guess I changed after that. Well, those are the clothes he was wearing when he murdered Maggie and Paul. Those are the clothes. And what does Blanca tell us? That was on August 11th. She said sometime mid-August. I didn't know this. I got it. You can't make it up. Sometime mid-August, he comes to see her. Do you remember that shirt when I left that day? I said, no. I mean, yes. It's a Vinnie Vine shirt. You weren't wearing a Vinnie Vine shirt. I fixed your collar. He tries to get her to tell what he was wearing. He tried to say, no, you weren't wearing that shirt. That Columbia shirt, you've got one of those. But guess what? I ain't seen that one since. I have not. Blanca and Shelley. That's great circumstance. Did you ever see that shirt again? Never saw that shirt. Ever. What's the shirt? You know what? I forgot about Shelley. I don't think this was mentioned. When Shelley sees Alex that night, you remember what she said about his clothes? Shorts, shirt. What she said about the shoes? Sperry type, cloth shoe. You remember that? When Dave Owens and those get there, and when I think I accidentally put some of the dust out on those aren't Sperry shoes. He's changed his shoes again. I'll get to you in a minute why that's important. When we want to visit his mom, he's got Sperry type shoes. He comes back and puts on the shoes. Why? Is she making that up? Blanca said, I've never seen the shoes before. When I got there the next morning, there was a t-shirt that looked like it had been pulled down, fell on the floor. Where does he keep it? She washes her clothes. Those are clean shorts up there. This is where he kept his shorts. Did he wear these shorts much? No, he didn't wear them much, but she knows that family. She knows where the shorts are, where the shoes are. Do you remember the Sperry shoes? Yeah. Did you see those? Never saw them again. Never saw that shirt again that he was wearing in the video. Never saw it. And when he confronted her at the house.
Thank you, Rose. I got it. What is going on? Their video is glitching.
Real feelings. I told them about that.
Oh my God. That's not me. That's them.
Is that real? And why is that important? Because it goes back to credibility and common sense.
I don't want to know.
Those were clean clothes that Shelly had washed. Excuse me, that Blanca had washed. And when we get there on the scene that night, you remember Laura? Miss Rutland. She's sitting in the back. David's in the front. Alex in the front. His lawyer's on the side. And you know, it's something else I don't understand. Your wife and your son has been killed, and you're worried about having a lawyer around. I said, well, you know, just agents.
Oh
need
my
to have
God.
a lawyer around. Really?
Law and crime. Get your shit together.
My wife and son have just been butchered, and I'm worried about having a lawyer. But they did. And that threatening, overbearing, cheating, manipulating.
What the hell is going on?
That's so Dave put his hand on his shoulder. So did Laura. What are you doing?
Oh, they're
I got a heart. Is that rushing to judgment? I got a heart. They didn't rush to judgment. They were saying, tell me what happened. Tell me what happened. Well, and he starts looking at his phone. You can check my phone, the alibis that he's created, that he's doing. And he says, I went and ran. I got on my knees over here. Went and ran, and I tried to take the pulse of Paul. I'd still be on the ground hugging my son. And I tried to turn him over. Trying to check his pulse. Really? I went to Maggie, checked her pulse. And you can't do that in the 20 seconds he's now trying to say you can. You can't. And
All
they
right.
tried to change that.
Pulls up.
And he never did it. Because what did she say? What did Miss Rutland say? He was clean. He was clean. He was clean. He was clean. He washed up. Yeah, and you hear the water running in the dog video. You hear it. He'd washed up. And this phone, tried to make a big deal about this phone that you do see right afterwards when we know he was down there. There's some movement on Maggie's phone. But every expert has said, just because if one phone's down here and the other one's walking, you're not going to have steps on that phone. He took Maggie's phone, the golf cart, however he got.
He's got 2 minutes of his 40 left.
Shorts and that shirt. And yes, you can get it and manipulate it and call to see if you made a call, put it down. That's not going to record steps on that phone because it's not moving. But that doesn't mean it wasn't with his phone. Don't fall for that. That's not real. Every expert said that. Every expert said that.
He's got 2
and doesn't
minutes.
that make sense? You can grab it, see, make a call, put it down.
Done?
You keep walking, it's not going to record.
I lost track of him a long
It's in
time
the car,
ago.
it's in the Suburban, and I'm getting to that.
It's not even a rebuttal. It's a little mini closing after the closing.
So what happened? And this is why I asked Miss Rutland. And they're bringing in drug use. If he did as many pills as he said, he'd be dead. You can't take that many pills. That's your common sense. But why I ask her this, I want to look at every one of y'all. Tell me what he was like in that car. You've got the video. Did he appear to understand you? Yes, sir. Were his answers timely? Yes, sir. Were they subject matter appropriate? Yes. Do you understand him? He can understand you. Look, he's thinking. He's opening the door. Was he in his right mind? Of course he was. And why is that so important? He says he didn't go down there. Is that enough? Yes. with everything else, that's enough. I never went down there. He's in his right mind.
30
I never went
seconds,
down
according
there,
to his
Dave. I
40
never went down
minutes.
there, Lord. I never went down there after supper. I stayed up. I took a nap. He goes from taking a nap from 6-7. Then next time they met, 6-10, I took a nap. August 15th. You sure you're down there? All right, up there taking a nap. I took a nap. I never went down there. Never, ever, ever. You think?
Stop
He would have
yelling.
taken the stand and said, you know, I was down there, y'all. If that video hadn't come out on that phone. Well, no. Now, under Mr. Waters' cross-examination, I lied. Why'd you lie? I wrote it down. I'm still not clear. I had paranoid thoughts. Usually I can take a deep breath and get through it. But I couldn't, so I just lied. Once I lied, I continued to lie. And he continued and continued and continued until 627 days later when he took the stand, the first time he'd ever told anybody. Anybody. He told his family, he told his friends, he told everybody, and they believed him. I wasn't down there. Why is that so critical? That's the time of death. That's when it happened. That's what the records show. That's when the conversation, yes, it is important. Paul, who uses his phone all the time, Paul is in a conversation about the dogs interacting. Well, send me the picture. He does. And then it stops. Yes, that's what it happened. And then Maggie's phone. A little bit text. She reads that text. I think she went to her car. Y'all decide. Nobody knows. One person knows. She goes to her car. And she's got some rings there she's putting back on. I think she's got 2 rings there, and she's putting on another in the car. Maybe they've been working the kennels. There's one shooter. There's only one shooter. And she hears that shot, and she comes back around. She hears the shot. She reads the last text y'all will have in there. I think she opens the thing about Solicitor Murdaugh. He doesn't. And then you don't see anything else. You don't see anything else on the phone. So is that common sense? Yeah, that's when they were gone. Yes. Yes. When they interact so much. Yes. That's common sense. And that's why it's so important. You want to help law enforcement? You're in law enforcement? I was down there. Y'all, I was down there. I didn't take that nap as long as I did. Did you hear anything? Why would you not give that information? Okay, then the 10th, with his lawyer, Mr. Griffin, in the car. Did you go down there? No. Look at him. Is he coherent? Is he under the influence of anything? Is he withdrawing? No. I want to help you. I want to help you. And then on the 15th, here's this video. Here's you in the tree. Now, Rogan says he thought he heard you down there earlier. Well, I don't think so. Why not say it then? Think about it. That's just Rogan's word.
Their camera's acting up. That's crazy.
Just Rogan's word. No, sir, I can handle that.
He doesn't really
You
have
made a
time.
mistake. Like
He
Shelley
said
did.
he'll be under 40 minutes. It's already been
Mark
43.
Rose. No, sir.
Because he has
I
no
can handle
case
that
and he's
better.
not confident about winning.
But when the video
He's
comes
trying to
out,
like beat it into them.
he's stuck. He's stuck.
As long as he can convince one, he's got a hung jury.
I'm going to try to wrap up. Yeah. Yesterday morning at 2:53 in the morning, I don't sleep much during trials. but I kinda
Until
woke
forever.
up. And what he did when
There's
he
no
took
time
the stand
limit.
was corroborated that he's a liar. He corroborated the fact he doesn't tell the truth. The one thing that was more important than anything. And you know, they're putting these law enforcement on trial, talking about blood evidence, talking about other things that were presented to the grand jury, which you.
I don't know.
Blood
Hen.
evidence was
Let's check
investigated,
his cell phone metadata.
and the state didn't offer it. That's what you do in your prosecution. Didn't try to offer it. Now they're trying to put us on trial for doing our job. Think about that. Blame everybody else.
Don't cry, baby. Don't
We
cry.
looked into this, and it didn't turn out to be. So now we're going to blame them. We didn't try to present it. Isn't that ironic? They're now jamming us for doing our job. Jamming us for doing our job. all the evidence of the gun.
Terrible job.
And I'm gonna get that. Timeline, the incredible timeline, his lies, all of that, the gunshot residue, all of that's presented. And do we make mistakes? Yes.
Oh, he just admitted
That
it.
happens in life. But you don't.
But not for the
lie
prosecution.
and just remember being at the scene of a murder when you said you weren't even there, or being at the scene where your family was brutally murdered. You don't lie about that. That's not a mistake. That's not a mistake. This is the state of South Carolina versus Richard Alexander Murdaugh, not the state versus David Owens, not versus Sled. And I want to tell you something. Sled, Walterboro, Laura Rutland.
But you're all on trial here. You think so, Meg Mullah?
Sled starts working.
I don't know. I think that's
FBI.
extreme.
They're working together. This is, think about it. Rush to judgment. They gave that man every benefit of the doubt.
Cops
Oh, what are
lie.
y'all doing?
Facts.
How's it going? You remember that third interview when he was David Owens said, well, and I submit to you, they're taking those interviews where he's trying to come find out what they've got on him. Well, why is this thing looking? How's this thing looking? Well, we've got some shell casings by Maggie's body out over there where y'all shot in the range, and some shots out there by the side of the house. The shell casings, they all were came from the same gun, all cylindered in the same gun. You think if they didn't, they could find
Alec
an expert
is
that they
so
would-
energetic. He broke the camera
Yeah,
for long crime.
So the gun was there. Yeah, you see his reaction? They all came from the same gun on Maggie. Now the other one, Mr. Griffin tried to argue. Paul Greer, yeah, it could have come from that shotgun. Don't know. Is that credible evidence? But it could have. Not saying it did or didn't, but it certainly could have. He's got that gun. It's got Maggie's blood on it. Don't know if he used that or not.
You only pace when
I
you're
know the assault
uncomfortable.
rifle's missing. And Will Loving comes from a fine family in Columbia. I can tell you that. Says we were down here not in March. It was more like
Remember how
April or
stoic
May.
Jim was?
We were
Because he's
shooting
confident in
his
this case.
gun
He
on
feels
the
good
side of the
about it.
house,
He's
and no
walking
shell
back and
casing.
forth, back and forth, back.
That's
I
where
mean,
they
I
found it.
pace too,
And lo and behold,
but I
the
pace
shell
very
casing matched
deliberately, and then I
shell
stop.
casings around.
He's just pacing back and forth, back and forth, back and forth, back and
Came out of
forth.
the same gun. They've been in the same gun. Yes, Mr. Waters is right. That's a family-owned gun.
Yes, on the
And is
financial
that
crimes, JD Jennings.
incredible, circumstantial, and direct evidence? Yes, ma'am. Yes, sir. it is.
$7 million bond.
That's powerful. You can feel it like the rain. The murderers come in, there'll be a gun there. We'll just use their gun. Does that make any sense?
You're just cruel, Rita. He's approaching 50 minutes of his 40-minute argument.
Y'all too young. You ever watch Columbo? When
Oh,
I first
God.
Looked at this case. This is an episode of Columbo, except this is real. And you get to see one of my heroes, the detective. Didn't always look that good, wasn't all that. But you got to see the crime.
Are you
and then
fucking
you got to
kidding
see
me?
them figure it out.
Columbo?
Mistakes they made. And that's what happened here. He killed him. He thought he could get a timeline, but it got him. Within 20 seconds, he's texting Maggie on that phone when he's passing the location of her phone. Is it common sense? He threw that phone out, called her, and threw it. Threw it, and the orientation didn't go on. They said, if you pick it up, yes. And we had somebody come in here, you throw
nothing
it,
to
you
object
throw it
to.
rough, and it doesn't come on. And what are the chances it's anything else? He'd almost had to bump into him. Almost had to bump into him. And you take this new story, I was down there till 8:50, whatever, go and take a quick nap, come back. He didn't hear the shots, just happens to come back. And common sense, don't leave it with you. Take it back there with you. I'm down there now. My wife told me this. I'm down there under this new story. And the deal is to come talk, go see my mama at 9:30. And you're right down there. You've just seen them now. Well, you said before you hadn't even seen them. Don't forget that. And you go up to the house. Why don't you say, hey, Max, I'm going to go see Mom real quick. It's just a few minutes later. No. You go up there. You take a quick nap. You know what? I'm going to try to call them. Let them know I'm going
Let's get
down.
the
Does that
results
make
of the
any
poll.
sense? And then when you get to the
Oh, look at
line,
that. It's 100-0.
You'll see the light. When y'all went out there yesterday, those trees are much lower. Go back in and look at the way it was. And I think even Buster said, when you get down there, if the lights on, you can see. Why don't you just go right over there? Hey, I ain't going down there. No? Doesn't hear anything, doesn't do anything. He just takes off. He just takes off. Does that make any sense?
Hashtag bias poll.
We've proved that nobody else could. With that timeline. Does it matter when he's rushing back? Yeah. I doubt he's ever killed 2 people before. So he's not thinking, he's frantic. Puts the wrong 2 shells in the gun. Coming back, he's got Maggie's phone. It had been sitting there. That's why the steps weren't on there. He's moving. He gets it. I can't take this phone with me. He's a lawyer, so he tosses it out. That's the only thing that makes sense. And what did he say about Paul's phone? When he went up there, I started to get, I didn't know I got it out, and then it kind of just popped out too. Does that make any sense? You got to evaluate everything. You can't believe somebody's credible one thing. How can you believe them on the ultimate issue when they said they didn't? When the only thing they corroborated for you throughout the investigation, throughout this trial, and throughout Mr. Waters' cross-examination is he's a liar.
Which he admitted to.
And that's all you can judge people on. The 3 witnesses that were beautiful, that were uncontroverted. And one was Paul. He didn't testify to you up on the stand, but he testified through Dr. Raymer, and he testified through his time. And it's so beautiful of evidence. It's so pure. He didn't know he took that video. That's why he said he wasn't down here. And this is beyond all that. We respectfully submit.
Oh.
Paul knew. Dad, I got some insurance.
Oh, I
got some insurance.
When he said I respectfully
I got insurance you've made.
It was done.
Money off of an insurance. Some clients you gave back and some you didn't. I've got some insurance on you. I don't know why you killed me.
I'd like to get in touch with you about your extended car warranty. Have you thought about your extended car warranty, Mr. Prosecutor?
Open your life, your fake life, with this boat case. Your finances are coming out. I know that. But if you go lie and say you weren't down here, I got you. I don't know when it'll come out. Maybe you'll go ahead and lie. But this is going to come out. Paul had that insurance on it. Maybe that's why he was worried about that phone. And you can't make that up. Because you remember when I asked David Owens, does anybody else in the world know that video was out there except Paul? No, sir. And that's incredible evidence. And it did sit there until law enforcement working together, the states, the local, SLED, everybody, got it out. And that's great law enforcement. Thank you.
Thank you?
And that's when the case changed.
Thank you for fucking up an investigation? Why would you thank them?
Testified to you. He shot me here. He shot me here. And look at all the shell casings around there. Y'all look at them. They're the same ones that Will Loving shot with Paul. They're the same ones that have been shot down there. Yeah. They came out of the same gun. That's great direct return.
This is what their new acronym means to me.
Finally, and my daughter-in-law, Sally, and my Aunt Sissy still calls my dad Jack this. My daughter-in-law been married about 3 months, one of the happiest days of my life, because they were happy. They were watching that kennel video. She and her dog Tater.
I'm tweeting
and
that.
When Bubba started to bark, that's what my aunt calls him, bed Bubba. Tater bark. And Sally said, isn't it something that your best witness in here are the dogs? You know, some people say they got a sixth sense. You think Bubba knew? You think Bubba knew something? You got Alex to say something. Bubba! Thank God for Bubba. DNA, and that DNA, when people live together, you'll have it all over your shirt. That's not it. The DNA in this case, That dog negates all. Thank you, Bubba. And guess where Bubba is now? Bubba's with Blanca. Bubba's with Blanca. You can't make that up. And that puts him down there. And that's the lie he told and told and told. I went down there. Why aren't y'all doing something, law enforcement? Why aren't you telling us you were down there? Why aren't you telling us you were down there?
What is happening? What is happening? Where'd he go? Where'd he go? Volume is up. Where's the sound? Where'd he go?
If he tried to respond to his phone, as Mr. Griffin said, it would show that he was going to Malamita. He had to get rid of that phone.
I was hoping.
Finally. It's about your greatest power. My dad gave it to me when I was young. He said, read it. Your greatest power. You know what it is? Your greatest power is your power to choose.
Yes.
Choice. We've all got it. We're born with it. We use it every day. We use it when we treat people, whether we say, hey, whether we're nice, whether we forgive people. We make good decisions. We make bad decisions. But what my dad always told me, don't blame anybody else. If you make a good choice, that's good. Don't get too cocky. Be humble, but that's good. But if you make a bad choice, you're responsible for it. The consequences. It's your greatest power.
Whoa, is that a threat, bro?
And for whatever was going on in his mind, his world's collapsing. It's coming down. All these worlds coming down financially. He's confronted that day by somebody.
We're approaching the first hour of his 40-minute closing.
It's motive. Don't have to have it. But yes, there. And is this rational? When he said that, is that rational? Was it rational?
Exactly, Ellen.
To be on the side of the road and claim you're shot? And when you're in the
They
ambulance?
didn't check. They never checked.
And you're talking to the officer in the ambulance.
Sloppy work.
And you say,
Navy
what
vet.
happened?
They got nothing.
Oh, by the way, he wanted to kill himself. He called 911. He called 911. When he told the officer in the ambulance, well, what happened? Well, some guy shot me. He even did a sketch. He faked the sketch. But what did he tell the guy in the ambulance?
Is this a play on my choose to refuse or you will lose commercial, Henrik?
He's trying his world, and he says there in that last interview with Mr. the call-in interview, Mr. Harpootney and Mr. Griffin, what you
The
guys
jury
there.
must be starving.
Ryan, I'm sorry, I lied about everything.
Stop lying.
I was under a lot of pressure. Had a
My
lot
ears.
going on. Really? Your wife and your son were murdered 3 months ago. And now this is the real Alex. Well, my world's coming down. My world, Alex's world is
Oh
coming
my
down.
God.
Been confronted by his law partners. Losing his job. Now it's me. My world's being affected. Not about that, but now. And I'm sorry I lied. I've lied about everything. Richard Alexander Murdaugh loved. I think he loved Maggie. I think he loved Paul. But you know who he loved
That's
more
interesting
than that?
perspective, Ivy. Maybe.
You know who he loved more than that? And who he's going to make sure that life, wanted to make sure that life, he loved Alex. And he exercised his greatest power of choice to make sure that life continued or try. And he couldn't. And now, ladies and gentlemen, after his honor charges you, you're going to go back there and exercise your greatest power. Based on the evidence you've heard, the evidence you haven't heard, the credibility, the believability of the witnesses, and especially of Richard Alexander Murdaugh. He was lied and lied and lied and lied. And it's been okay. He got you through. It stops here. We respectfully request it stops here today. No, it's not okay. And we're going to exercise our greatest power to find you guilty of killing Maggie.
Right. That's what he said. Okay, Nish, exactly. Oh, thank God. 1 hour. It took him 1 hour of his 40 minutes to get all that out.
Ladies and gentlemen, you've
Lunch
now
break.
heard the evidence and
Lunch
you
break.
have heard the closing arguments.
Launch break.
Next up will be jury charge and then your deliberations. We're at lunchtime. We're going
Thank
to
God.
take a break for 1 hour and 15 minutes for lunch, and you'll come back. I'll charge you on
2:55.
the law, then you will deliberate. Please do not discuss the case.
2:55. So approximately 3 o'clock, they will be charged. They'll go back to deliberate at 3:30 as predicted. Okay. All right. Well, there you have it, folks. You heard it here second. Because I can't be first, because Law and Crime's got the cameras in the courtroom. So you heard it here second.
Seated.
Yeah, me neither.
When we resume, I intend to go directly into charging the jury.
Yep.
When I'm charging the jury, no one comes, no one leaves. Before we break for lunch, are there any matters to discuss regarding the jury charge?
Nope. Yep.
I think the state emailed a revised charge on the other pending charges, which we did not have any objection to. I don't know if Your Honor.
We received it and incorporated that into the charge with correcting a typo here, typo there.
What's my view on what?
We don't have any additional charges or any objections.
And without addition, we don't have any either.
Jenny.
We'll be in recess for 1 hour and 15 minutes.
What's my view on what, Richard? What's a jury charge? The judge is going to give them jury instructions. Actually, no. The judge is going to charge every a juror in the courthouse, in that courtroom. He's going to charge every single one of them with a crime for failure to listen to the prosecution. He's going to charge them criminally because they disagree probably with the prosecution's case. So the judge is going to criminally charge every single one of the jurors. And yeah, they're going to go to jail. The jurors are going to jail. You think they're going to deliberate, but they're actually going to jail. So that's going to happen. They're going to be charged for falling asleep, for not listening, they're going to be charged for disagreeing with everything that Waters had to say yesterday, for agreeing and nodding at Jim's arguments. They're going to be charged criminally because this is a shady ass court. Of course, all of that is a joke. All of that is a joke. All of that is a joke. No, so okay. What's gonna happen now? And by the way, now I'm curious. Since we have time now, let's see if we can get a copy. So they're not seeking the death penalty, so this is not a capital case. It's life in prison without parole. Now let's see, South Carolina. Let's see what we can find. All right, so here are the code of laws. Person causing injury which results in the death of at least 3 years later, not to be prosecuted for homicide. That's not it. Murder is defined as the killing of a person with malice aforethought, either expressed or implied. That's what the charge is going to be. So section 16.310, murder defined Here it is. Punishment. What is the punishment? A person who is convicted of or pleads guilty to murder. Oh, hold on. I have to zoom out a little bit. There we go. Must be punished by death or by mandatory minimum term of imprisonment for 30 years to life. If the state seeks the death penalty, which they're not in this case, a statutory... For purposes of this section, life or life imprisonment means until death of the offender without the possibility of parole. And when requested by the state or the defendant, the judge must charge the jury. See, there's that language again, charge the jury in the instructions that life imprisonment means until the death of the defendant without the possibility of parole. In cases where so the judge will have to tell him that. The jury will know he will have no possibility of parole. The judge must charge the jury in his instruction that life imprisonment means until the death without the possibility of parole. That's extremely important. So the jury's going to know, like, if we convict this guy, he's gone. Like, he's gone for good. Like, he's not coming back out. That's very, very important. In cases where the defendant is eligible for parole, which is not the case here, so we're just going to skip that. No person sentenced to life imprisonment pursuant to this section. No person sentenced to a mandatory minimum term of imprisonment for 30 years of life is eligible for parole. When the state seeks the death penalty, which is not the case here, so we can skip that section. The judge shall consider mitigating circumstances and aggravating circumstances. Aggravating circumstances include murder was committed in the commission of another crime, which none of these apply. Sexual conduct, kidnapping, trafficking, burglary, robbery, larceny, killing by poison. That's interesting. Drug trafficking, physical torture, dismemberment, arson. So none of that happens. If the murder was committed by a person with a prior conviction for murder, that did not happen. The offender, by his act of murder, knowingly created a risk of death to more than one person in a public place. That did not happen because SLED released a statement stating that there was no risk to the public. The offender committed the murder for himself for the purpose of receiving money. No. The murder of a judicial officer, solicitor, former solicitor. No. The offender caused, direct, another to commit murder as an agent or employee. No. I mean, technically, but not really. Federal, state law enforcement officer. No. Murder of a family member. The murder of a family member of an official. Oh, never mind. Sorry. A family member of an official listed in like 5 or 7. Also no. 2 or more persons murdered by the defendant by one act pursuant to one scheme or course of conduct. That can be charged because we have 2 dead bodies. The murder of a child 11 years of age or under. No. The murder of a witness or potential witness committed at any time during the criminal process impeding the term prosecution. No. Like if you kill a witness. That's not the case here. The murder was committed by a person deemed sexually violent. No. Mitigating circumstances. No significant prior criminal history or conviction, violence against another person. That's definitely a factor. Murder was committed while the defendant was under the influence. So that's one theory the defense could pursue, but they chose not to, which is smart. Because then it's like he's guilty, but he was too high. Like, no. The victim was a participant in the defendant's conduct or consented to the act. Oh, this is the please kill me. This is the Kevorkian defense. For those of you who don't know who Dr. Kevorkian is, he was a doctor in a medical facility, I think in the 70s. maybe 80s. I can't remember the exact decade. But what I do remember is that he assisted in the S word of people wanting to unlive themselves. And he said, you know, like, I'll put you out of your misery. So that sort of thing, which did not happen here. He was an accomplice? No. Acted under duress? No. Not in the capacity, mental capacity, substantially impaired? No. Age or mentality? No. Defendant was provoked? No. Below the age of 18? No. Had a mental deficiency? I'm not going to use that word, but also no. It was in the 80s? Okay. I couldn't remember when Dr. Kevorkian committed his acts. I mean, he thought, you know, he was acting in the patient's favor. If you all don't know who Dr. Kevorkian is, look him up. It's a fascinating philosophical argument. Like, did he have a right to take away the life of these people who asked him to take away their life? They were like, please, I am in constant pain. I'm hurting. It sucks. And Kevorkian was like, sure, I'll help you out. So he wasn't like murdering people who were not willing, you know. The statutory instruction as to statutory aggravating or mitigating circumstances must be given in charge and in writing to the jury for its deliberation. So we're going to find out which ones they included. The jury, if its verdict is recommended, no, they're not gonna recommend death because it's not on the table. This is all death, and now these are notes. Jury instruction as to discussion of verdict. In all cases in which an individual is sentenced to death, again, not the case here, so we can skip over that. Punishment for murder, death penalty imposed, again, can kind of skip over that. Punishment for murder, 30 days of trial itself. These are very comprehensive. There's like 50 pages here, you guys, maybe even 100. Right of defendant to make last argument. Oh, interesting. The defense would have had a chance to do a surrebuttal if this were a death penalty case. So it would be like the prosecution goes first, then defense, then prosecution, and defense goes one more time. They have a right to make a last argument if it was a death penalty case, but it's not. But it's not. So they don't. So the most important piece, this is what they're going to be charged as. This is the most important piece right here. Let me single it out so we can talk about it, because that's really all they talked about. And now I understand why. Present, share screen. Here we go. So this is the case. This is their case. State's case. Murder is the killing of any person with malice aforethought, either express or implied. That's what the state had to have proven. Now, any criminal act, for those of you non-lawyers out there, really only requires two things. Two things are required of the state to prove beyond a reasonable doubt. They don't really have degrees, Med Mullah. In South Carolina, they don't really do degrees, it seems like. They just go straight for either it's murder or it's attempted or something like that. Like I don't see any degrees, first degree, second degree, third degree, unless it's in another chapter, which I don't imagine it is. This is the murder chapter. So this is what I'm gathering. This is homicide. This is literally Title 16 homicide. This is what I'm gathering, okay? Murder is the killing of any person with malice aforethought, either express or implied. That's what the jury has to decide, whether or not, because killing has occurred, no question about it. Any person, we have two persons. And you have to have malice aforethought, which could be either express, which I don't think we have here, but we do have, according to the prosecution, implied malice aforethought, which again, I don't think they've proven beyond a reasonable doubt. But they have to show, remember, it's kind of like malice in Johnny Depp's trial, very similar. Malice is not like evil intent. In this case, it's closer to that definition than it is in the Johnny Depp trial. But malice aforethought is basically like, look, I'm going to take these people out and then take them out. And I think Jim has made a great point about seconds before he's at the kennels shooting the shit with him, talking about the dogs, chicken, no chicken, blah, blah, blah. So I think section 16.310. Yep. That's what this is. Thank you, Ken Boone. This is what I'm reading. So they have to show malice aforethought that's been implied in this case. And that's very difficult. And that's very, very difficult. No, I'm not gonna bug him today. He's doing his own thing. I'm just gonna leave James be. All they proved is that he lied and stole money, Guardian Hawk, and that's exactly how I feel. So we'll see how long. I mean, the charge shouldn't take longer than like the charge itself shouldn't take longer than maybe like 10 minutes. So maybe even quicker than that. I don't know. How is it implied? Well, that's the question. They're saying that Maggie knew about his financial crimes, so she was getting ready to out him. And as a result of that, Alec snapped, and Paul was in the wrong place, wrong time, I guess, and he came after Maggie. That's how it's implied. I think it's extremely weak and tangential. But that's their theory. And they're sticking to it because they have nothing else. So is it possible for a jury to convict at this point? I don't think it is. I mean, this is it. We're at the tail end of the trial. It's over. There's no more evidence. There's no more argument. The only thing remaining is for the judge to instruct the jury, or they call it charge the jury, which I think is really bizarre language again. But again, I'm just biased and I'm judging South Carolina for being South Carolina. And I think that the judge is going to instruct the jury. It's going to take about 10 minutes. And they're going to go out at like 3:10, 3:15. They're going to argue amongst themselves. They already have a 4-person, so there's no need to select a 4-person. I'm just hating on your backwards ways, that's all. I like the state overall, and the people are absolutely lovely, but your laws, y'all, shit. I thought Kentucky was bad. Then I went to South Carolina. Facts. Facts. So, not hating on the state, hating on your laws and your crazy ass backwards judges. Who just literally do whatever the hell they want. We have some of those too, but somebody did a crime reconstruction of how Murdaugh, I guess, could have committed the crimes. That's a little crazy. What reaction is the public going to have with respect to what? What reaction is the public going to have to the jury verdict? Well, it depends on what it is. If the public is going to, if the jury verdict is going to be, if the jury verdict is going to be guilty, the public is going to be very satisfied. About 85% of the public is going to be extremely happy. And 15% is going to be very, very upset that our judicial system did not work. If the verdict is going to be not guilty, 15% of the public is going to be very, very happy. And 85% of the public is going to be very, very upset, thinking our judicial system does not work. Just flip the numbers. Because that seems to be the prevailing majority, the overwhelming majority. And then if it's a hung jury, 100% of the public is going to be upset, but half of them are going to go, nah, expected. The other half are going to go, oh my God, how could the jury not obviously see obviously that what I know obviously. And the rest of the public will just roll their eyes and go, you're just a child. You don't understand how laws work. He's not going to make bond, because if he posts bond, they're going to keep all the money. And he stole it to pay people off. They don't have $7 million to just give away right now, especially since he's not working as an attorney. He was the breadwinner, the primary breadwinner in the he was the primary breadwinner in the family. If they post the 7 million, it's going to go to the victims like immediately when the case is over. So that's not going to happen. He has to present the full bond if he wants out. Yes. My maid is here. That's what you're all hearing. Zinnia's playing with a ball, and my maid is cleaning. So that's what you all are hearing. Yeah, can you all hear that? Can we have a Zinnia break? I probably can. I mean, the door is closed. Can you all hear that? Really? That was the ding 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 ding. Mad Mullah, if you want a consultation, you are more than welcome to call the office. The number is 502. Here, I'm gonna. Is Larry gonna dox himself? It's 502-931-6788, and we charge a $150 consultation fee. Oh, he just doxed himself. Oh. Oh my God, Anna. My maid is currently on permanent fatigue leave. Yeah, it was my buddy who last April, I was getting flooded with phone calls. I would talk to like, I don't know, sometimes it felt like 20, 25 people a day, and 16 or 17 of them, all they want is just a free consult. Because I was giving free consultations. I would talk to them and they'd be like, all right, thanks, and then never talk to me again. And I started charging consultation fees in April, and it's the best thing I've ever done because I still get 1 out of 5 people are still hiring me, kind of like before, only now I don't get to talk to the other 90% or whatever, 80% of the people. I literally shave that time off and I get to save all that extra time. So it's like $50 consultation fee if it's just a traffic ticket, $100 on misdemeanors, expungements, stuff like that. And then on oh, James just messaged me. On felony case, so DUIs are $150, and then because that was a DUI question, and then on felony cases we charge $200. And I find it hilarious. Like some people, James is about to come on. Some people are like, I don't have $200 for a consultation fee, and I'm like, and they're like charged with burglary first degree, which is like a $20,000 lawyer fee, and I'm like, please explain to me how you're planning on paying a $20,000 attorney fee when you don't have $200 to talk to me. Like that baffles me. It will never cease to amaze me. It will never cease to amaze me. Somebody asked, $150 for how long? As long as it takes, until I answer all of your questions. If it takes 5 minutes, then 5 minutes. If it takes half an hour, then half an hour. If it takes 17 hours, then I will talk to you for 17 hours. In order to make sure that the point is brought across. James is on his way. Kelly says, I wonder if the jury is intimidated by the prosecution after the juror was removed. No, I don't think so. The judge made it clear that it was him, not the prosecution. What I do think is that the prosecution may be, the jury may be a little bit scared of the prosecution, because the prosecutor is like, well, if you don't believe me, I'm going to beat it into you, like start yelling at you and shit, which was completely unnecessary and over the top and Don't need it. Absolutely not necessary. You did not need to yell. It just shows your lack of confidence in your case. It shows your lack of professionalism, lack of confidence, and so on. James said his phone is broken, or not working, I should say. Oh, discount code for the chat. I hope you guys never call me needing my assistance, honestly. I would never wish that upon anyone, to be like in legal troubles, needing criminal defense. What you guys don't need a discount code, because I hope to never hear from you. Haven't I paid that in the past 2 days? I hope you don't need my assistance. I never wish ill will upon anyone. That's just cruel. No, he's on his computer, Ed. He's on his computer. He's not texting me. He's sending me Twitter dems. Dums. He sent me a dum. Dum dum dum. Oh, James, James, wherefore art thou, James? You need a lawyer for what, mad scientist? For your experiment in your garage that has mysteriously exploded, that's not a meth lab? No, I'm just kidding. Who told you? Just a wild guess. Complete hunch. Well, it says he's seen it. It's been a few minutes. James felt so bad about yesterday, he's sliding into my DMs before I even reached out. I think so. I called James so much yesterday, I broke his phone. Oh, God. Oh, you guys are killing me. No, I called him so much, he's now upset. He's now upset. He reached out. I did not call him, not one time. I did not call him today, not one time. Garage sex dungeon, new poll. What? Garage sex dungeon, what's the difference, right? Hey, Guardian Hawk, you don't have to confess. This ain't the FBI. Enika85 says, if there is a hung jury and the case is retried, can they automatically bring back the other crimes because they're brought into this case? Well, it'll be either the same judge or a different judge, and it'll be the judge's call. And I sent him the link. He's not joining. Come on, James. Get with the program. It's not automatic, Anika. They still have to make the argument. Can they say like, well, they were brought in the other trial, judge? That's not an argument. You still have to make an argument. Well, that judge said it's okay. Well, I'm saying it's not. Like, that's literally what a judge can say. They go to lunch and what? Oh, they're thankful that we don't have to listen to any more closing argument from either side. That's for damn sure. We don't kink shame here, Rose. We don't kink shame. James is in high demand right now. I sent him the link. Let me message him. People are waiting on you. Yes. Go to lunch and then give jury instructions. Allegedly, he's tweeting. Oh, you got to be fucking kidding me. Don't lie to me. Is he seriously? Oh my God, he's fucking tweeting. Oh, James. You know, I can't wait for James to be an adult. I can't wait for James to grow up and be an adult. There he is.
Hello, hello.
Baby. Hey, James. Your mic is muted, FYI.
Hey, how are you?
Good, man. How are you?
Good, good. I'm just gonna get a little bit closer to the Wi-Fi.
Oh, dude, you're all good. Thanks for joining.
Uh-oh. Hold on. Ambulance coming.
Yeah, there's an ambulance. I can hear it in the background. Phone is not broken. Lying just like Alex. Alan, you kill me. James is getting arrested. No, I don't think James is getting arrested.
No, not yet.
Not yet, he says.
All right, this should be better. I'm right by the Wi-Fi now.
All right, good deal. So give us the sticky. Did the jury show any emotion to anyone in the courtroom today? Speaking.
Not a lot. I mean, a lot of them are tapped out at this point. So the emotion I saw was boredom. I mean,
Logical.
besides for maybe like a few eye looks and things like that, it was very much kind of bored, you know? A lot of heads in the hands, like looking away.
Do you think they got it at this point? They didn't even really need a closing argument. They already made a decision.
I think a lot of them are like that, yeah. 1 second.
No problem. Take your time. That's crazy. I mean, it kind of makes sense. You know, like once you've already made a decision, you don't need to keep listening to more evidence, guys, you know? Or like more argument. We just kind of get it. Same with the jury. The jury's got it. They don't need any more convincing.
Yeah,
they already made their decision. Go ahead.
Yeah, no, I mean, you're right. They've seen all the evidence. There's not a lot that I think is going to change as far as in their minds. It's still nice to see their reaction to the argument, but I don't know how much is going to change in this last, few hours. Although I will say that, I will say that there was a better reaction to the, what is it called, rebuttal closing, or what is it called?
Rebuttal rebuttal.
There was a better reaction, less boredom, less things like that. I thought he did a good job finishing I don't love that one attorney. I thought other times he didn't do as great of a job, but I thought for this, I don't know, he had them, it was much more concise. There was a timeline of certain things as to why Alex was, everything just fit nicely together in a package on why he was lying, why he could have, I guess, been involved because he's, not credible, and I definitely noticed that they just were more interested. It could have been, that's just before lunch and they know that they're getting out soon, but that's what I saw.
That's fair. That's actually literally what I was thinking, because I'm wondering if their reactions are to the argument being made before them, or the fact that, oh, thank God it's almost over, we get to go soon and deliberate. Like, that's a great observation, because it could be hit or miss. You can't look at them and say, oh, they really love this. You have to take the surrounding circumstances into consideration.
Yeah, and I wouldn't say any of them love it for sure. I just saw, again, a little bit more of engagement with like active listening versus looking around versus head down versus not paying attention. There was a couple of people who were less active in the beginning and then more active when state took over again. But yeah, that could just be because they know they only have 30 or 40 minutes left and then they're done. It's not like this was going to be another 2 hours.
By the way, he went overtime. He said no more than 40 minutes. He went a full hour.
Yeah. Which they always do. I mean, yesterday Creighton said, oh yeah, it's just another, whatever, 3 hours later, and here we are,
Right, exactly. So what I'm hearing you say is not a whole lot of reaction to Griffin, the defense closing.
I mean, in the beginning they were engaged, then he lost some of them. Once he started to get to the PowerPoint again of the time frame, it was like, okay, this is when the phone, this is when the phone shuts off, this is when the phone turns on. Like, he was losing them again, because that's just rehashing evidence we've all been through.
Yes.
And I definitely noticed there was, 4 of them had their arms crossed at that point at him. So I thought he was good, but I don't think the jury, it wasn't like an engaging finish, that captured their attention.
What about that emotional ending to his closing, when he got emotional and like almost teary-eyed?
Well, that happened so quick. I didn't even know until basically he said, all right, thanks, that he was crying. He was like choking up and you could hear it in his voice. It was weird. The jury didn't react to that. It was very, very quick. My feeling, in my personal opinion, it was an act, and that's why it came off a little faked and a little too quick. And it took us all by surprise. People next to me, I'd be like, what's going on? Is he crying? So it wasn't very clear.
Chad is saying something you did not see. Jim winked at Poot after he did that.
Did he really?
That's what Chad is saying. I missed it.
I'll get the stream of that because I need to see that. I wouldn't.
A lot of people are saying that.
All right. Well, that just reaffirms to me that it was an act.
Yeah. It's very possible. I'm not gonna lie. When I started off as a criminal defense attorney, there was a moment where I talked to another criminal defense attorney, and she was like, "If you can cry on demand, you're gonna make a great criminal defense attorney." And I was like, "What?"
Wow.
Yeah, she wasn't joking either. I believe it wholeheartedly. Let me pull up this footage just real quick, because now I am curious. I don't know. Can you see my screen?
Yep.
Okay, here it is.
Burden of proof matters, not gossip, innuendo, opinions, and most of all, not theories layered on top of speculation. With your words, you can let the state know that they don't get to obtain an indictment by misleading a grand jury and then bring you before you a case built on words that
Let's skip.
Tragedy with another.
Right here.
Thank you.
All right, let's watch.
Ladies and gentlemen, we'll send you to the jury room for a break. Please do not discuss the case.
Does he wink?
Well, I'm waiting. Poot hasn't come up to him yet. Poot is about to walk over. So watch the stream on the bottom. Yeah, there. He walks over. Now, here it is. Let's look at his face. Oh, yeah, there it is. There it is. Okay, but what does that wink mean? Did you see it?
Yeah.
So, but what does that wink mean? Does it mean I was playing, or does that wink mean like I did everything I could? That was a good job. You know what or what's up, brother? Like, I don't know.
Yeah, that wink could mean a few things. You know, because it's not right after. It's one thing if he looked at him right away and winked.
Yeah, no, Poot kind of walked over, so that was more of a brotherly wink, I think. It's like, that's it. I mean, the case is done.
Yeah.
It's dude, it's over. We did everything we could. So it could also be that as well, because they can't shake hands because the jury's not going back to deliberate yet. Question for James: when Metters said, "Listen to me," was it at a juror? Do you remember that moment when he was like, "Listen to me"?
What do they mean? Was it a juror? I don't think he wasn't talking to anyone specifically.
You don't think so? He wasn't like a juror was like asleep and he was like, "Wake up, listen to me."
No, God, no. He wouldn't do that. No. He's just talking to them.
Okay, that's
jurors.
fair. What was the nickname of the juror that got yeeted today?
Blondie.
Blondie got yeeted.
Yeah.
Okay, so it's probably not who I thought. I'll tell you later who I thought it was, because I can't mute myself and still talk to you on here. But
Fair.
The prosecutor called you out. He's like, "I'm not a juror watcher. I've been looking at the jury a little bit," but he said, "I'm not a juror watcher." Did you catch that?
I did. I was like, "Hey, what's up?" I almost waved my hand.
Whoop, whoop.
Shout out to all the juror watchers.
Raise the roof to all the juror. Hey, this trial is basically just you, brother. I was there for a fraction. I don't count this trial.
I know. I'm holding it down for LawTube.
Holding down the fort, baby. Who was picked to replace Blondie?
Big Beard.
Big Beard. Okay. Thank you, Stephanie. I'll address some of these after James is done. Ellen Natsir Ali asks, what about the yelling? Did that come across as like effective, or did it feel like he's distancing the jury, or what did that feel like?
To me, it came across a little aggressive, but it might be necessary to wake them up a bit. But
oh, really? They were falling asleep.
I mean, not falling, but bored. Yes.
Bored, not paying attention.
Asleep, but bored. Yeah. So just to liven them up, you know.
Yeah.
And I'm sorry, just like probably another minute, because there is someone who got my spot today, so I want to try to get back in early to get my spot back. If you saw in that stream, I was like, "There's where I'm normally sitting. You could see me, but you can't see me because some person."
We were looking for you.
Nice.
We couldn't find you.
Yeah, my seat got bumped today, so that was fun. You and
Blondie got yeeted today.
I know. Yes, yeeted.
Elkanich asks, by the way, Elkanich said she felt really bad about trolling you yesterday, just for the record.
Oh, no, that was a fun joke.
I sent them, I was like, go mess around with James and like tell him stuff. And they created this whole theory about, you know, the press dinner was canceled.
Yeah.
And then all that other stuff. That was all me, man. Just for the record, I sent them there.
No, I know. Everyone said it.
Okay, and then
shoot, I really.
Oh, you gotta go.
I do. I'm sorry.
No worries, man. Thanks for joining. Honestly, you've been a fucking treat, man. Have fun in there. It's almost over. We have 10 minutes of courtroom stuff left, and then they go to deliberate. So we'll talk again.
Yeah, I'll call you after we get out of that, because it'll be early. So.
Oh, very early. You're gonna be out of there before 3:30.
I hope so. Your lips to God's ears.
All right, man.
All right. See y'all. See you later. Talk to you later.
All right. Bye. Elkanich, yeah, I just told him. She says, please tell him how sorry I'm about what I said. He looked wonderful. He's a sweetheart. And it was just a joke. He got it. You heard him. I'm so sorry, James. I never meant for you to second guess your hair or your tie. It was just a joke. So sorry again. I remember how his chat like came to his defense because you were joking about how the tie doesn't work, his hair doesn't work. It was funny. It wasn't like in a cruel way. It was just right. It was just right. So I very much appreciate you, LK Nick. LK Nick, I guess. Ashley King says, was Blondie the one you thought was pro-prosecution? Well, I don't think he can answer that. I think she's pro-defense. Otherwise, Poot would not object because the state didn't care. If the state doesn't care, it's whichever party is objecting, that's always the dead giveaway. Whichever party is objecting to the judge's ruling is the party that disagrees with the ruling. So if Blondie had been pro-prosecution and it had been yeeted, then the prosecution would have objected. If because think about it, it's common sense. It doesn't take a genius. It doesn't take, if she was clearly pro-defense, that's why Poot was like, we disagree with your honor's ruling, blah, blah, blah. You should put her back in. Thank you, Kelly. Greatly appreciate your streams. Thank you for covering this. You are welcome. Do I take cases pro bono or pro bono? That's cute. I like that. Because you're a dog lover. That's hilarious. I love that. James is such a people pleaser, so it crushed him that someone said they didn't like his tie. No, I love James. It did. He recovered. He recovered. He's doing good. By the way, you all are about to hear my maid use the vacuum cleaner, so just giving you all a heads up. Don't freak out. It's just a vacuum. Just a vacuum. Nothing too terrifying. You're not cats, right? Cats are the ones who are usually scared of vacuum cleaners. You all are not cats, like my Zinni, so you should not be scared of vacuum cleaners. What other questions do you all have? Why did Blondie leave? Because she did something she was not supposed to do. I've seen videos of that. Poot told the judge, sled bad, not keep juror. Yeah, but he also wanted the juror. You could tell. The Blondie took her eggs. Oh. My lips are sealed. Yes, I do think it's going to be a hung jury. You missed the part what Blondie actually did. She communicadoed with people outside the jury about her opinion as to guilt or innocence of the defendant. That's what she did. I predict it will be a fast decision. Well, okay. So my original prediction, I thought we're going to have a verdict Monday, maybe Tuesday at the latest, because the deliberations are going to start this afternoon after they're charged, given the instruction by the court. The problem with that theory now is that I didn't know they're going to be deliberating through the weekend. I guess I missed that part where the judge said they're deliberating through the weekend, which is, by the way, again, I don't know. To me, it's so unprecedented. I already said the judge did something unprecedented by not charging them before closing arguments. Apparently, that's the law in South Carolina. I've come to find out I was completely wrong. I'm not afraid to admit when I'm wrong. So the law in South Carolina is unusual. There are some states that agree with South Carolina, but I think they're in a minority. Most states, the majority of states, you charge, then you argue. But how fast are they going to come back? I mean, so they're going to start Thursday. Don't forget, they also are human beings. It sounds to me like they're going to take a poll. See, Jim did a brilliant thing, and I told you guys, out of his entire closing, I'm definitely stealing this piece for my own closings in the future. He's like, you're going to go back and you're going to write down. He told them what to do. What do you do in closing argument? You tell the jury what to do. You give them, you empower them. You give them tools. When one juror starts going, well, obviously they're guilty, don't bend over and be like, all right, I'll agree with you. No, stand your ground. I do not think he's guilty. I think he is not guilty. You know, even if you're the lone wolf in the room, depending on the case, that may be a good closing, part of your closing. But one of the things that he mentioned that I'm absolutely going to steal is that you write it down. You're going to go back and you're going to write down. And that's exactly, they're going to 12 Angry Men them. If you have not seen the movie with Henry Fonda, it is a phenomenal movie. 1 against 11. 11 guilty is 1 not guilty. And then watch what happens. I don't want to spoil the ending for you. So it's fascinating that they're going to go back there and think about it. They're going to, let's say they do take a vote first thing. As soon as they take a vote first thing, they're all going to write down. If you get 12 not guilty verdicts, they're going to be out of there in 6 minutes. Not likely to happen, but possible. Not likely, but possible. Let's say they write it down and it's like split 6-6, 7-5, 8-4, 9-3, 10-2, 11-1, whatever it may be. Now they start deliberating. Okay. So either we're going to have a verdict tonight, which is very unlikely, but possible. I place it at maybe 10% chance. I like that Waters' argument is kind of washed off from yesterday. Like yesterday, this is the downside to having such a long closing. The jury's not going to remember what the hell he said yesterday. You know what I mean? If not, why? What? If not, why? Would help to understand more. Do you study? Oh, English, Scottish law for your fans. No, I don't. Why? Because practice in America. I mean, we don't really need that here. So Waters' argument is kind of washed off. Today we had Griffin and we had Metters. So it's kind of like a battle of the wits there, you know, and which way the jury. But do you really think like closing argument is going to sway a jury one way or another? Unless the case was so confusing that they need closings in order to make a decision. For the most part, you are going to have jurors who already made up their mind. I mean, you heard James. James said the jurors have already made up their mind. They were bored. They wanted out. They were ready to get out of there. And so I changed my decision now that I know they're going to deliberate Saturday and Sunday. Don't forget, they're also human beings. This is what I started to say that I never finished. They also want to go home to their families. So they're going to vote today. Either we're going to have a verdict today, 10% chance for today, in my opinion. Actually, you know what? I want to poll you guys before I finish that statement. I'm curious. Before I tell you guys, I want to poll. When do you think we will have a verdict? And I'm going to poll you all, and I'm going to poll Twitter as well. Let's see. So option 1 is going to be today. Option 2 is going to be tomorrow, Friday, and then Saturday. And no later than Sunday, I imagine. Let's see. Let's see what you all think. And let's see what Twitter thinks. Apparently they're deliberating over the weekend. I've never heard of that before. Again, just more unprecedented shit. It's just absolutely staggering. How do we know How do we know deliberate through seemed? How do we know deliberate through weekend, not seemed? That's what the chat is saying. That's what the chat is saying. And I trust chat because like several people said that. It wasn't just like one random person. One or two randos like in the chat I will not trust. But when everybody starts saying it, that's when it's like, all right, obviously you got your intel from somewhere. And so that's respectable. And I trust it. Judge wants a vac. I think we all do at this point, especially the one person who really wants a vacation is James. Wait, so once the jury goes to deliberate, they don't get to leave the room the entire week? No, they'll go home. They'll go home at like 5:30, and then they come back in the morning. Don't forget to like this video, comment below, subscribe to the channel. If you're new here, join in as a member. If you're so inclined, love to have you. You guys are all awesome. You're absolutely amazing. Wait, James told us to troll you? No. Are you serious? That would be impressive, as a matter of fact. Because then I have to delete the tweet. Did the judge say they're deliberating over the weekend? Be honest. Are you trolling or are you for real? See my comment above. If necessary, the jury will deliberate through the weekend. Court officials said Wednesday, 3 hours ago from CBS News. Okay. All right. Thank God. Whew. I was about to say, damn, if James has pulled the, it's like, who's trolling who here, huh? Uno reverse, bitch. Mic drop. That would have been the most epic troll I have ever seen. That's an Uno reverse troll. Straight up. How long do they have to deliberate before they can be hung? You mean declared a mistrial? It depends. It depends on the case. There's no specified legal time limit period, whatever. Like obviously if they come out in 20 minutes, Your Honor, we can't decide, the judge will look at them and be like, you're joking, right? Like you talked for 20 minutes. That's not enough time. Now, if they talk for 3 days and they come out and, Your Honor, we're hung, that's a different story. Boise, it was great meeting you in Walterboro as well, even though I have no clue who you are. What's the average? There's no such thing as an average deliberation. It all depends on the facts of the case, the severity of the case, and the, yeah, Shane, you missed it. You're going to have to go back in the video. We already talked to James. Thank you, Ash. I'm no longer allowed to super chat, YouTube or iPad. You have sent me too much money, Ellen. You need to stop that. No, you've just been super chatting a lot. They have a daily limit of $500. I found out the hard way because one day I tried to like super chat Nick, Emily, and Tug. I think I wanted to send them each 500, and I sent one of them 500. I can't remember who it was, and then I had to wait until the next day, and then the next day to send the rest because it has a $500 cap on super chats on YouTube, which is bullshit. But whatever. Do you remember that, Sinbad? You remember those Johnny Depp days?
Back into court, so you.
Oops.
And they always have a police escort.
Oh, the jury. They're talking about the jury now. Man. Court will be back in about 10, 15 minutes. What that would be Allen charges. Yes, Mary. Exactly. Yep. Daily limit of 500. You can send me $500. Well, do you live stream emailer? Maybe I will. Alexandra is like, send me $500. All right. We got some more simps in the chat. Welcome, simps. Don't forget to like this video, simp below, and subscribe to the channel. Trust in the Chad. I always trust in the Chad, but sometimes Chad can be trolling too. You got to be ready for the trolls, especially if they're, prompted by yours truly, which is James. Let's see, where's the poll at? Everyone is saying verdict tomorrow. Why? Probably because they don't want to go into the weekend, huh? That's logical. That's logical. Some people are saying it's going to go into next week. Some people are saying Monday is the formal day. Some people are saying Wednesday. Others are saying, how long does a jury take, or a hung jury? They're asking my question with a question. I'm the only one who's allowed to be a Jew here, okay? Stop answering my questions. It's the Jewish thing, like, how old are you? I don't know. Who's asking? That's like the Jewish thing. We do it all the time. People ask me questions, and I'll ask them with a question. I'll respond with a question, It's like standard stuff. I don't know what it is. I don't know what it is about us. So they're copycatting me. Judge Newman said they could deliberate into the weekend if necessary. I think it will be a hung jury, so we'll go at least into next week. Larry, you bring Christopher to your live. Okie dokie. Can we do a Scottish poll with guilty, not proven? No, because that's confusing, and it's not the standard here in the United States. It will confuse people. Otherwise, I would, Kelly. Because remember, even Jim talked about it in the beginning of his closing this morning. He said guilty, and then we have not guilty includes not proven and innocent are wrapped into the not guilty, which is so powerful. I might steal that too. I love that. Not proven. God. But see, we can't define reasonable doubt, but I can define not guilty. Ooh, not proven. But it depends on the case. You can't use, it's not universal. Sorry, I learned from Jim, just like Jim learned from me, talking about preponderance of the evidence and clear and convincing. I swear, it's I know it's a template, but hey, a man can dream. A man can dream that Jim Griffin goes to the DUI guy school of law and has been watching my videos like incessantly and was like, this DUI lawyer makes some good points. I should probably use some of these arguments. All right. A man can dream. Leave me alone. All right. I've been a longtime fan. You are so refreshing and funny. Thank you very much. Also, I love your videos of you in action in court. Thank you very much, Paige. Thanks for joining. Welcome. Welcome to the channel. Sending love from the UK, Great Britain. Thank you for your content. And thank you, KH. Love you. Thank you so much. OJ is going to be trending on Twitter if he walks, basically. OJ 2.0. OJ of the 21st century compared to the OJ of the 20th century. Whew, tell me about it. There's like no way they're gonna have a verdict today. So okay, so now that people have voted, so we have, let's see, almost 800 votes here. 2 out of 3 of you are saying verdict tomorrow, and 1 out of 6 of you are saying today's. One out of 6 of you are saying Saturday, and 1 out of 6 of you are saying Sunday. That's on YouTube. So I'm going to end that poll. And then on Twitter, people are still voting, and it's the same thing. Even less for verdict today, 5%. So about 1 out of 20 are saying verdict today. Again, 2 out of 3 are saying verdict tomorrow. Almost 1 out of 5, 1 out of 6 are saying verdict Saturday. And another 1 out of 10, 1 out of 6 are saying verdict Sunday. With some stragglers saying it'll go into next week. Very interesting. Very interesting. People keep asking me if I'm going to cover Idaho and Daybell, time permitting. I mean, this has been a trip, you guys. I want to, but like, I'm starting to realize the trials that are not televised are not gaining as much attention. Because when I went to Johnny Depp, there was a lot of attraction. A lot of people were watching because it was televised. A lot of people were in the know. Then when I went to the Kristen Smart trial, it wasn't televised. So nobody was watching. And when I was tweeting about it, people were like, meh, out of sight, out of mind. Then a big one, 2 big ones, Harvey Weinstein and Danny Masterson, also both Hollywood, big trials, not televised. Meh, fell on deaf ears. Thank you, Marilee. Welcome to the channel. And then Murdaugh, boom, televised, insane attention. Everyone's watching. Excuse me. Everyone is streaming. Now, granted, non-televised trials still do have their benefits because no one else is watching. There is no televising of it. So, thank you, gang. Thank you. Because, and you become the only source of information, which is nice, but it's very limited in scope. So I think Daybell is not going to be televised. So I may still show up for like a day or two, but that's it. Question: what if a jury person falls asleep? Answer: they may or may not be dreaming. I mean, what kind of question is that? They might be snoring. They may need a pillow. They probably have a blanket. What's the question here? If a juror falls asleep, maybe a neighboring juror will try and wake them up. Maybe they will ignore them. Do they wake them up? Nope. Do they get reprimand? Nope. Haley Henworth says, hi, Larry, love your channel. Haley from Suffolk in the UK. Welcome. Sometimes they get hit with a raw egg, if provided by the jurors, of course. Eggs permitted. Eggs permitting, I mean. If the judge, well, I mean, yeah, he'll do a stretch break, but that's all he can do, if you noticed. When was the okay? Let me throw the question back at you. Right, you ready? What does the judge do if a juror falls asleep? Name a case, and I can give you time to research. I'm not going to put a time limit on you. Name one time over the last 100 years of United States jurisprudence where a juror was scolded or attacked or spoken to by either the bailiff, the judge, or one of the lawyers to wake up when they fell asleep in court. Go ahead. I will wait. I'll go on to the next topic. Find me a case where a juror was scolded for falling asleep. I don't think they exist. I've never heard of that happening. Even senators, by the way, here we go. Here's some stuff for you. This is interesting. For many, the idea that a juror can fall asleep during a trial seems like an affront to justice. However, in many cases, a trial will continue even if a juror falls asleep. A judge could stop the case to wake the juror up, excuse the juror, or order an entirely new trial if there's not enough jurors. None of these options help judicial expediency, but what about fairness to the defendant? It's a judge's option. Oh, sorry, I thought you were seeing my screen. My bad. First, if a juror falls asleep, the judge may choose to do nothing. Even in higher levels of courts, senators have been recorded nodding off during impeachment hearings, and the trial continues without them. That doesn't tell you everything you need to know. As another option, a judge may stop the trial to wake the juror and ask them if they need anything. Excusing the juror. Many people will go to extremes to avoid jury duty. People may be looking to be excused just because it seems like they're nodding off. For many attorneys, just trying to fill the jury box with people that can understand the facts of the case is a difficult enough task. If every juror who looked uninterested or asleep was excused, many more people would need to be alternates. That is very true as well. Starting a new trial. Very rare, almost will never happen. Overturning juror verdicts when someone is asleep. The appellate court is incredibly hesitant to overturn a jury verdict because both parties have to agree on the selection of the jurors. This means all attorneys for each side selected the jury members during pretrial hearings. Since there is a trial on the facts and there were other people who agreed the person was guilty, most court cases will continue even if someone is asleep. There you have it, folks. And again, the reason for that is jurors are human beings. Do people tend to forget this fact? Jurors are human, just like you and I. If you are bored out of your skull and you're falling asleep, how do you think the jury's feeling? They're entitled to a sleep nap break just as much as you are. Why are you an exception? Why are you special? More special than the juror? Stop putting yourself on the pedestal. You know what I'm saying? You're no more important than that juror in that box. However, and this is the important distinction, if you're like hooked and you're like, oh my God, this is fascinating. This is like the most interesting witness I've ever seen. By God, you can bet money that all 12 or more of those people are wide awake and paying attention. That's the key difference. You think that they are asleep? You think that they are asleep when it's like fireworks going off in the courtroom? Extremely unlikely, unless they like literally did not sleep and spent the whole night at the strip club or the disco, the dance club, wherever they went the night before. You know what I mean? And spent the whole night there and literally slept a couple hours, and they're just gonna come into court and sleep there. I mean, that's possible. You can't stop a juror from living their life, but what you are definitely not going to see, more than likely, is a juror just randomly going to bed when it's like fireworks going off in the courtroom. That's so unlikely. That's just so unlikely. Mandatory caffeine injections? What the fuck is chat on about? Mad scientist, you need to... DUI plus is arrogance personified. Welcome to the chat, Mooresville. North Carolina, the finest of everything. I love that name. Hey, Larry. Tree. Oh, there you go. Hillary. What's up, Hillary? Hillary is from California. Her husband and her were on my panel talking about the multi-million-dollar treasure hunt. Tree had a judge fall asleep once. True. There you go. I don't know if I ever had a judge fall asleep. I had judges like on their phone texting in the middle of my trial, but there's nothing I could do. They're not the ones rendering a verdict. Was Hillary, was the judge in that case the decision maker, or was it a jury trial and the judge was just calling the shots? Because that I can accept that. They're calling the shots and they're asleep, as long as they wake up as soon as there's an objection. Objection, Your Honor. No, sorry. What's the objection? What was the testimony? Can you please repeat the question? Can you please repeat the answer? No. That's crazy. Ahmaud Arbery. The defense brought it up, but I don't believe she was excused. Thanks, Caitlin. Shoot, I think you're answering someone else. Not exactly moi. Stephanie Scotton. Oh. Oh, South Carolina specific. That's interesting. Does it say the word sleep does not even appear in the South Carolina Judicial Branch juror information segment? Stephanie Scotton says Koberger in Idaho will probably be televised, and mainstream media has already requested cameras in the room. IIRC motion for a camera was granted. IIRC. I forgot what that stands for. If I recall correctly. That's right. Thank you. I forgot. If I recall correctly. Yeah, so check this out. This is the juror information, juror behavior. Certain things are obvious, like they have to be on time. They must hear all the evidence. The result of being late is a delay and inconvenience. When a court begins, they should rise. Everyone should rise. I'm going to Control F the word sleep. The word sleep doesn't even appear. OJ did a live stream on Twitter, his opinion of the trial. Did he really?
If you would bring the jury.
Here comes the instructions, or the charge, whatever they call it here. All right, this is ironic. O.J. Simpson admits on Twitter that he watched Alec Murdaugh testify on the stand. What the hell is this world coming to? Are you an expert now on murder cases, O.J.?
All right, thank you. Madam Forelady and members of the jury, you have heard the testimony, received the evidence, and heard the arguments of the state and the defendant. I will now explain to you the law that applies to this case. Under the Constitution and laws of South Carolina, you are the finders of the facts in this case. I do not have the right to pass upon the facts or to even express any opinion that I might have as to them, because this is a matter solely for you, the jury, to determine. As jurors, then, it is your duty to determine the effect, the value, and the weight of the evidence presented during this trial. As a trial judge, it is my responsibility to preside over the trial of the case, and I have the duty to rule upon or pass upon the admissibility of the evidence offered during the trial. You are to consider only the testimony which has been presented from this witness stand,
Yes, I got it.
along with other exhibits and evidence presented during the trial. Any other evidence or exhibits which have been made a part of the record you may consider, along with any stipulations made by counsel. I have the additional duty to charge you the law applicable to this case. And as the presiding judge, I am the sole judge of the law. It is your duty as jurors to accept and apply the law as I now state it to you, then to deliberate in an effort to reach your verdict. And finally, I charge you in this regard that you should not be concerned with what you think the law ought to be, but what I charge you that the law is. You are also the judges, the sole judges of the credibility, that is the believability of the witnesses who have testified and of the evidence offered. In considering credibility, you may take into consideration many things, such as the demeanor or manner of testifying, whether the witness had reason to be biased or prejudiced, and whether the testimony was contradicted on the one hand or supported and corroborated on the other hand. You may believe a small portion of a witness's testimony and disregard the larger, or vice versa. All these things you will consider, bearing in mind that you should give the defendant the benefit of any reasonable doubt. It becomes your duty as jurors to analyze and to evaluate the evidence and determine that evidence which convinces you of its truth. There are two types of evidence which are generally presented during a trial: direct evidence and circumstantial evidence. Direct evidence directly proves the existence of a fact and does not require deduction. Circumstantial evidence is proof of a chain of facts and circumstances indicating the existence of a fact. Crimes may be proven by direct evidence or circumstantial evidence. The law makes no distinction between the weight or value to be given either direct evidence or circumstantial evidence. However, to the extent the state relies on circumstantial evidence, the circumstances must be consistent with each other.
That courtroom cleared
and
out
when taken
fast.
together, point conclusively to the guilt of the accused beyond a reasonable doubt. If these circumstances merely portray the defendant's behavior as suspicious, the proof has failed. The state has the burden of proving the defendant guilty beyond a reasonable doubt. This
There she
burden
is.
rests with the state, regardless of whether the state relies on direct evidence, circumstantial evidence, or some combination of the two. The rules of evidence ordinarily do not permit witnesses to testify to opinions or conclusions. An exception to this rule exists for witnesses we call expert witnesses. An expert witness is a witness who, by education and experience, has become expert in some art, science, profession, or calling, and may state an opinion as to relevant and material matter in which the witness claims to be an expert, and may also state the reasons for the opinion. You should consider any expert opinion received in evidence, and like any other evidence, give it the weight you think it deserves. If you decide that the opinion of an expert is not based on sufficient education and experience, or if you conclude that the reasons given in support of the opinion are not sound, or that the opinion is outweighed by other evidence, you may then disregard the opinion entirely. An expert witness's testimony is to be given no greater weight than that of any other witness, simply because the witness is an expert. Further, you are not required to accept an expert's opinion, even though it is not contradicted. In regard to evidence of other crimes and evidence of alleged bad acts on other occasions, this evidence is limited to consideration by you as it relates to the motive of the defendant for the offenses charged in this case. This evidence cannot be used for any other purpose. This type of evidence must not be considered in any other fashion. In particular, the South Carolina rules of evidence provide that evidence of other crimes, wrongs, or acts is not admissible to prove the character of a person in order to show action in conformity therewith. Put another way, evidence of other crimes or bad acts cannot be used to show that the defendant is a bad person and therefore is more likely to have committed the crime for which he is accused. You may not consider evidence of other crimes and bad acts for this purpose or for any other purpose other than it as it relates to the motive of the defendant. In addition, while you may have heard that other crimes and bad acts of the defendant have resulted in other charges or indictments not before you, the fact that the defendant was arrested, charged, and indicted in these matters is not evidence and cannot be considered by you as evidence of guilt in this case, nor do these indictments create any presumption of guilt. As to any other pending charges, as is the case here, the defendant is presumed innocent until proven guilty beyond a reasonable doubt by the state in a court of law. The function of the jury is to determine whether a defendant is guilty or not guilty, and the consequences of a conviction in this or other pending matters is of no aid in determining whether the defendant committed the offense. You should not consider nor speculate about sentencing consequences for this or any other crimes.
I thought you're supposed to.
Those issues are not before you.
Wait a minute.
The fact that the defendant was arrested, charged, and indicted.
I thought he's supposed to charge them since it's going to be life without parole, that he's going to get life without parole.
It cannot be considered by you as evidence of
That's
guilt.
what I read in the South Carolina stuff with you all earlier today.
Nor does it create any presumption or inference of guilt. The indictments are simply the formal written instruments which contain the charges made against the defendant. The indictments are the formal documents by which this case is brought into this court. The defendant, Richard Alexander Murdaugh, has pled not guilty to the indictments, and that plea puts the burden on the state to prove the defendant guilty. A person charged with committing a criminal offense in South Carolina is never required to prove himself innocent.
Correct.
I charge you that it is an important rule of the law that the defendant in a criminal trial, no matter what the seriousness of the charge may be, will always be presumed to be innocent of the crime for which the indictment was issued, unless guilt has been proven by evidence satisfying you of that guilt beyond a reasonable doubt. This presumption of innocence does not end when you begin your deliberations, but it accompanies the defendant throughout the trial until you reach a verdict of guilt based on evidence satisfying you of that guilt beyond a reasonable doubt. The presumption of innocence is like a robe of righteousness placed about the shoulders of the defendant, which remains with the defendant until it has been stripped from the defendant by evidence satisfying you of that guilt beyond a reasonable doubt. The presumption of innocence is not a mere legal theory. It's not just a legal phrase. It is a substantial right to which every defendant is entitled, unless you, the jury, are satisfied from the evidence of the guilt of the defendant beyond a reasonable doubt. The state must prove the defendant guilty beyond a reasonable doubt.
Notice how many times he says
So
that
what
phrase.
is a reasonable doubt in the law?
Oh, you're allowed to define it in South Carolina.
A
not in
reasonable
Kentucky.
doubt is a doubt which makes an honest, reasonable, sincere, and conscientious juror hesitate to act.
Oh,
Proof beyond a reasonable doubt must therefore be proof of such a convincing character that a reasonable person would not hesitate to rely and act upon it in the most important of his or her own affairs. Proof beyond the reasonable doubt can also be described as proof that leaves you firmly convinced of the guilt of the defendant. Now, there are very few things in this world that we know with absolute certainty. And in criminal cases, the law does not require proof that overcomes every possible doubt. If based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of a crime charged, you must then find him guilty. If, on the other hand, you think there's a real possibility that he is not guilty, you must then give him the benefit of the doubt and find him not guilty. The indictments in this case allege 4 separate offenses against the defendant.
4.
The indictments are murder of Maggie Murdaugh, murder of Paul Murdaugh, possession of a weapon during the commission of a violent crime involving the murder of Maggie Murdaugh, and possession of a weapon during the commission of a violent crime involving the murder of Paul Murdaugh. Each indictment charges a separate and distinct offense. You must decide each indictment separately on the evidence and the law applicable to it, uninfluenced by your decision as to any other indictment. The defendant may be convicted or acquitted on any or all of the offenses charged. You will be asked to write a separate verdict of guilty or not guilty
they kind of go hand in
for
hand.
each indictment. The defendant, Richard Alexander Murdaugh, is charged with the murder of Margaret Murdaugh and Paul Murdaugh. The state must prove beyond a reasonable doubt that the defendant killed Margaret Murdaugh and Paul Murdaugh with malice aforethought. Malice is hatred, ill will, or hostility towards another person.
That's a high burden.
It is the intentional doing of a wrongful act without just cause or excuse, and with an intent to inflict an injury, or under the circumstances that the law will infer an evil intent. Malice aforethought does not require that malice exists for any particular time before the act is committed, but malice must exist in the mind of the defendant just before and at the time the act is committed. Therefore, there must be a combination of the previous evil intent and the act. Malice aforethought may be expressed or inferred. These terms, expressed and inferred, do not mean different kinds of malice, but merely the manner in which malice may be shown to exist. That is, either by direct evidence or by inference from the facts and circumstances which are proven. Express malice is shown when a person speaks words which express hatred or ill will for another, or when the person prepared beforehand to do the act which was later accomplished. For example, lying in wait for a person or any other acts of preparation going to show that the deed was within the mind of the defendant would be expressed malice. Malice may be inferred from conduct showing a total disregard for human life. The defendant is also charged with possession of a weapon during the commission of a violent crime.
It's a fascinating charge. I've never seen that either.
2 counts. The state must prove beyond a reasonable doubt that the defendant was in possession of a firearm during the commission of a violent crime. A firearm means any weapon which is designed to or may readily be converted to expel a projectile.
But he can only be convicted of that if he's convicted on the underlying charge.
Possession of a weapon during the commission of a violent crime, you must first find the defendant guilty of committing a violent crime.
Yes.
Murder is a violent crime.
So if they convict on murder, they can convict on those.
Beyond the reasonable doubt,
they acquit on murder, they have to acquit on that. Otherwise, it doesn't work.
Helped in the commission of the crime.
They can't acquit of murder and then convict on possession of a firearm. It's not possible.
While the arguments of counsel are
now they can convict of murder, acquit of the weapon, but
you should remember that the statements made by counsel are not evidence.
I've never seen
presenting their arguments.
A law like that in the United States.
Counsel often have referred to the evidence. However, you should base your verdict on the evidence as you remember it. If there are any conflicts between the recollection of counsel about the evidence and your own recollection, you should rely on your own understanding of the evidence. You must decide whether the state has met its burden of proof beyond a reasonable doubts based solely on the evidence presented in this courtroom.
See?
As you were instructed at the start of the trial, you're not permitted to conduct any independent research about this case.
Oh, independent research.
The facts of the case
Should have been saying that
the evidence
every
presented in the
day
case,
of the
or the
of the
people or
trial.
organizations
Every
involved
day,
in any way
not at the end.
in the case.
So biased.
Do
He
not
wants
try
them
to
to
find
research.
any information from any source outside the courtroom,
Should have said it 6 weeks ago, Judge.
however reliable that source may seem to be. Do not look at dictionaries or other reference materials. Search the internet, websites, or blogs, or use any other electronic tools to get information about this case or help you make a decision. You may not use computers, telephones, cell phones, smartphones, tablets, the internet, or other tools of technology with communication capabilities at any time during your deliberations, except only as provided by the court to review the digital evidence in this case. If your deliberations necessitate an overnight break, you may use these devices as necessary, but you may not use them to communicate with anyone about the case until the case is over. This means that you must not use phone calls, video calls, emails, text messages, instant messages, blogs, chat rooms, websites, or any social media, such as Facebook, Twitter, LinkedIn, YouTube,
Now you're saying
Reddit,
it.
and Discord,
Now.
to send or receive any information about this case. This includes information about a party, a witness, an attorney, a court officer, or your fellow jurors. News accounts about the case, research on
You're
any
supposed
topic
to do this
raised,
6 weeks ago.
or even any topics you may think would be helpful in deciding the case, or any testimony presented by any witness you may not investigate. During your deliberations, do not read, listen to, or watch any news reports about this case. This includes anything that may be in the newspapers or on the internet, radio, or television.
Or YouTube.
You must not consider anything you may have read or heard about the case outside of a courtroom, whether before or during the trial. Information on television, radio, internet, or from other sources may be wrong or incomplete. In our judicial system, it is important that you are not influenced by anything or anyone outside of this courtroom. If your deliberations necessitate an overnight break, even though you may use electronic devices as necessary for purposes unrelated to this trial, I must urge you to minimize your use of such devices. Many internet browsers, smartphone apps, and social media services, as well as traditional media like television and radio, will provide information and news that you do not seek with little or no prompting. It is a strong possibility that information about this case may be thrust upon you every time you use an electronic device. You must therefore use these devices only as absolutely necessary. You must ignore and avoid uninvited information about this case. No matter for lady and members of the jury, I am required to charge you the law as I have done through these instructions now I'm being given, to help guide you to a just and lawful verdict. Whether some of these instructions apply will depend upon what you find to be the facts. The fact that I have instructed you on various subjects must not be considered as indicating an opinion of this court as to what you should find to be the facts or what your verdict should be.
Why is his badge so shiny? Is he trying to blind us with our light? Blinded by
Now
the
you've
light.
been chosen and sworn to give the parties a fair and impartial trial. When you have done so, you will have completed your oath, and no one will have a right to criticize your verdict. You must not be swayed or influenced by opinions or expressions of opinion you may have heard outside of the courtroom, but rather should base your verdict solely on the testimony of the sworn witnesses who took the stand, the exhibits received into evidence, and the law which I have stated.
Don't forget to vote in the poll.
You should not
Polls
be
up.
swayed by caprice, passion, prejudice, or improper sympathy for or against anyone. Remember, you have no friends to reward or enemies to punish, and all parties are entitled to a fair and impartial trial. It is your duty as jurors to consult with one another and to deliberate in an effort to reach an agreement.
It's live. I can't put it on 1.75.
Each of you must
live.
decide this case for yourself,
Come on, you know this.
but only after impartial consideration of all of the evidence with your fellow jurors.
Jurors.
In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if you become convinced it is erroneous. However, do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. As I stated earlier, you are the judges of the facts. Your verdict must represent the considered judgment of each juror. In other words, your verdict must be unanimous.
Unanimous.
Now, you may have noticed that I have read these instructions. I do so to give you the law as accurately as possible. I will give you a copy of these instructions to have in the jury room. You may refer to these instructions to assist you in your deliberations. You must consider the instructions as a whole and not follow some and ignore others. And Madam Forelady, it would be your duty to preside over the deliberations of the jury. If during your deliberations you should desire to communicate with the court, please reduce your message or question to writing, signed by your foreperson and the foreperson only. Do not address any questions to anyone other than the court, and reduce it to writing and pass it to the bailiff, signed by the foreperson.
And I will reduce it to
foreperson
ashes.
only. It will then be brought to my attention. I will then respond as promptly as possible, either in writing or by having you return to the courtroom. I caution you, however, with regard to any message or question you might send, that you should never state your or specify your numerical division at the time.
Numerical division.
Now, you've heard the testimony and you have heard the law. Whatever your verdict.
Wait, what did he say about
Madam Forelady,
numerical
you will
division?
Indicate the verdict on the back of each indictment and then sign and date your verdict. You will have these 4 indictments, and on the back of each indictment is a place for verdict. And each one, as to each one, you write your verdict, either not guilty or guilty, then sign and date the verdict. You're not authorized to write the verdict until all of you have agreed on the verdict. Now, in just a minute, I will send you to the jury room. But prior to doing so, I want to ensure that from the 12 jurors we have remaining. If there is any reason that any one of you cannot continue deliberating, please let me know at this time. We have 13 jurors. Only 12 can deliberate. So out of the first 12 jurors now on the panel, if there are any reasons why you cannot continue, please let me know at this time before I excuse the alternate. A show of hands as to anyone who cannot continue deliberating. All jurors then seem to be in good shape and good to go. So when the jury leaves the courtroom, the alternate will remain. And the alternate is. I will send you to the jury room, all of you, except for the alternate. But do not begin deliberations until you have received a copy of this jury charge, the indictments, and the exhibits. Once you receive these things, that will be your signal to begin your deliberations. Once you begin deliberations, you will deliberate until you have reached a verdict, at which time you will knock on the door, advise the bailiff, and we will bring you out to receive your verdict.
What about if they don't finish by the end of the day?
Will now go to the jury
Oh, wait,
room,
what if they don't
except
finish?
for
What's
the
their
alternate juror number 741,
You never said
who will remain with us while the others go to the jury room.
I don't get it. Are they just going to deliberate?
State it for the record, whatever it is. All right, what about it?
We go for 6 weeks, and if we could perhaps hold the alternate in the case there's a problem with the 12, and we have to insert the alternate.
That's how you know how confident the defense is.
Yes. The state concurs with that, Your Honor.
First, the statute says alternate must be excused once the jury begins deliberating.
Kind of makes sense, though.
And that's always a risk that is taken. So with the consent of the parties, if that's what the parties want, Mr. Murdaugh.
Yes, sir.
Do you want me to hold the alternate in the event something happens to any other juror?
Yes, sir.
All right, very good. So, madam, you will not be dismissed. You will remain
The defense is so
member of the panel
confident.
while the jurors are
Wow.
deliberating, but will need to be taken someplace separately from the panel to ensure that you do not talk with anyone or communicate with anyone. And we'll figure all that out in a few minutes.
That's impressive.
But aside from that, if you all will review the exhibits with the court reporter and the bailiff, you can take the charge and the indictments in, and the jury may begin deliberating. Okay, thank you for reminding me on that. Any additions or exceptions to the charge?
Voluntary intoxication, Your Honor.
Yeah, voluntary intoxication was not charged. It was not raised. I cited with the fact that it was not raised as a defense and would not be appropriate to charge.
I agree.
Okay. Why is everyone standing?
Everyone was mesmerized.
Clip on it. So, let's see, is there a separate room the alternate can go to for the time being? For the time being.
Wow, I feel bad for the alternate. She has to
Just for
sit
the
there by
time
herself or him. Defense does not want to.
741, if you will follow court officer to a place. Yes, sir.
Your Honor, may I approach with Mr. Waters of something that's come up that I think that needs to be.
Defense does not want to excuse the alternate in the case. In case something happens to the original 12 deliberating. Talk about confidence in their case. Wow. They are so confident. No, she can't. She can't have an iPad. She can't consult social media. She can't read the news. She can't read the newspaper. She can't, I mean, she can have a book. She can have a book, like to read a book. She can't surf the web. She can't do anything. She can probably read a book that's not related to the trial. Maybe she can watch a movie, but under supervision. Yeah, so the firearm charge, if a person is in possession of a firearm during the commission of a violent crime and is convicted of committing the violent crime, they must be imprisoned for 5 years in addition to the punishment provided. So it's a worthless charge. It's a completely worthless charge. It's not really going to do anything. It's not going to change the outcome of the case. You know what I mean? Either they're going to convict on murder and it's going to be the end of it, or they're going to convict on, they're going to acquit on murder, or it's going to be a hung jury. Oh, man. We had a couple of super chats that I missed because we went back to court. It was an answer to a juror falling asleep. Defense brought it up during the break that a juror was falling asleep. Love your channel. Thank you, Caitlin. Shoot. Yeah, I got, somebody sent me an article written by a law student. So thank you for that. Shali Richter, are you one of my yentas? I forget. I'm losing track of my yentas. I have so many. Any any luck today? Hectic day in New York. Missed a lot today. Mr. DY, guilty, not guilty, hung. And by the way, toda rabah, which means thank you very much in Hebrew. You are welcome. Bevakasha. And that's a good question. Are they trapped in that courthouse? Please explain your comment about the defense being confident. Okay, let me explain. A verdict of anything but guilty is a victory for the defense. Hung jury, mistrial, not guilty. That's a win, win, win for the defense. If, let's say, 12 jurors are deliberating day 1, they're deliberating day 2, they're deliberating day 3, and on day 4, whatever, suddenly one of the jurors gets COVID and they can't come in, that would be an automatic mistrial. The defense, again, remember, mistrial is a win. The defense would love a mistrial if they don't have a case. That's a win. But the fact that it was the defense that asked for the 13th juror not to be excused in case something happens to the original 12 and the 13th needs to step in, that shows extreme confidence. Extreme confidence.
All right, you may take them all in along with the, put this on top.
Because they do not want a mistrial on one of the jurors just not showing up one day. They have a backup plan. They have a backup plan. All right. I created the next live stream, so I'm terminating this one.
We'll be in recess waiting for the verdict.
We're in recess waiting for the verdict. 4:30. I'm gonna try and make it on time. I should be able to. I want to. How do I send people? Oh, I don't know how to do that. Let me see if I can view on YouTube. View on YouTube. Let me try. I've never done this. Or maybe I have. I don't remember. This one is upcoming. So that's the edit details. Add a fundraiser, copyright monetization, customization, add a trailer, redirect. Oh, here we go. I can do that, I think. I can push you all in there. Okay, cool. I'll see you guys there. Bye, y'all.